This is the publisher's preface to the works of Robert G. Ingersoll in 12 volumes, Dresden edition, published 1900. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read for you by Michele, Baton Rouge, Louisiana. Publisher's Preface. In presenting to the public this edition of the late Robert G. Ingersoll's works, it has been the aim of the publisher to make it worthy of the author and a pleasure to his friends and admirers. No one can be more conscious than the publisher of the magnitude of the task undertaken, or more keenly feel how far short it must fall of adequate accomplishment. When it is remembered that countless utterances of the author were never caught from his eloquent lips, it is matter for congratulation that so much has been preserved. The authorized addresses, arguments, and articles that have already appeared in print and passed the review of the author's more or less careful inspection will be readily recognized as accurate and complete. But in this latest and fullest compilation are many emanations from his heart and brain that have never had his scrutiny, were not revised by him, and that yet, by general judgment, should not be lost to the world. These unedited sundries consist of fragments of speeches and incompleted articles discovered amongst the author's literary remains, and for unknown reasons left in more or less unfinished form. It has been the publisher's ambition to gather these fugitive pieces and place them in this edition by the side of the saved treasures. Whether the work has been well or ill done, a generous public must decide, while the sole responsibility must rest with, as it has been assumed by, the publisher. In carrying out the design of the present edition, the publisher gratefully acknowledges the assistance of Mr. Ingersoll's family, who have freely placed at his disposal many papers, inscriptions, monographs, memoranda, and pages of valuable material. Recognition is also here made of the kind courtesy of the press and of publishers of magazines who have generously permitted the publication of articles originally written for them. Finally, the publisher gives his thanks to all the devoted friends of the author who, in many ways, by suggestion and unselfish labor, have aided in getting out this work. Of these, none have been more unremitting in service, and to none is the publisher more indebted than to Mr. I. Newton Baker, Mr. Ingersoll's former private secretary, to Dr. Edgar C. Beale, and to Mr. George E. MacDonald for the fine tables of contents and the very valuable index to this edition. C. P. Farrell, New York, July 1900. End of Publisher's Preface. Part 1, Chapter 1 of the Works of Robert G. Ingersoll, Volume 10. Ingersoll's Address to the Jury in the Munn Trial. Part 1 of 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Michele, Baton Rouge, Louisiana. Part 1. Article printed in the Times, Chicago, Illinois, May 23, 1876. The United States versus Daniel W. Munn, Deputy Supervisor of Internal Revenue, who was indicted under Section 5440 of the Revised Statutes of the United States. There was an unusual rush to obtain admission to the United States District Courtroom yesterday to listen to the closing arguments of counsel in the Munn whiskey conspiracy trial, which has attracted so much attention during the past 10 days. The stalwart deputy who guards the entrance to this judicial precinct was compelled to employ his entire strength and power of persuasion to keep the eager, anxious crowd from trespassing on the convenience and dignity of the court. About 10 o'clock the court took the bench, and Colonel Ingersoll walked into the room, took off a broad-brimmed felt hat, which gives the barrister, while he has it on, somewhat the appearance of a full-grown, well-developed Quaker in good standing in the society to which he belongs. When he has the hat removed, however, the counselor's appearance undergoes a marked change. He then looks like a crop-haired follower of the House of Montague in the Shakespearean play. He sat down on a crazy old chair, which threatened every moment to break down beneath his weight, and listened to the remarks of Judge Doolittle for the remainder of the morning, until it came his time to talk. Colonel Ingersoll never troubles himself to take notes of anything. What he cannot recollect he does not have any use for. Judge Doolittle occupied the morning session until the time for adjournment at 1 o'clock, with a review of the case on the side of the defense. He was followed by Mr. Ingersoll in the afternoon. At 2 o'clock the courtroom was more crowded than before, and at that hour Mr. Ingersoll appeared in the forum and delivered his speech in behalf of the defendant. If the court please, and the gentlemen of the jury. Out of an abundance of caution, and as it were an extravagance of prudence, I propose to make a few remarks to you in this case. The evidence has been gone over by my associates, and arguments have been submitted to you, which, in my judgment, are perfectly convincing as far as the innocence of this defendant is concerned. I am aware, however, that there is a prejudice against a case of this character. I am aware that there is a prejudice against any man engaged in the manufacture of alcohol. I know there is a prejudice against a case of this kind, and there is a very good reason for it. I believe to a certain degree with the district attorney in this case, who has said that every man who makes whiskey is demoralized. I believe, gentlemen, to a certain degree it demoralizes those who make it, those who sell it, and those who drink it. I believe from the time it issues from the coiled and poisonous worm of the distillery until it empties into the hell of crime, dishonor, and death, that it demoralizes everybody that touches it. I do not believe anybody can contemplate the subject without becoming prejudiced against this liquid crime. All we have to do, gentlemen, is to think of the wrecks upon either bank of the stream of death, of the suicides, of the insanity, of the poverty, of the ignorance, of the distress, of the little children tugging at the faded dresses of weeping and despairing wives asking for bread, and of the men of genius it has wrecked, the millions struggling with imaginary serpents produced by this devilish thing. And when you think of the jails, of the almshouses, of the asylums, of the prisons, of the scaffolds upon either bank, I do not wonder that every thoughtful man is prejudiced against the damned stuff called alcohol. And I know that we, to a certain degree, have to fight that prejudice in this case, and so I say, for this reason among others, I deem it proper that I should submit to you, gentlemen, the ideas that occur to my mind upon this subject. It may be proper for me to say here that I thank you, one and all, for the patience you have shown during this trial. You have patiently heard this testimony. You have patiently given your attention, I believe, to every word that has fallen from the lips of these witnesses, and for one I am grateful to you for it. Now, gentlemen, understanding that there is this prejudice, knowing at the time the case commenced that it existed, I asked each one of you if there was any prejudice in your minds which in your judgment would prevent you from giving a fair and candid verdict in this case, and you all, honestly, I know, replied that there was not. The district attorney, Judge Bangs, stated to you in the opening of this case, for the purpose of preparing your minds for the examination of this testimony, that you must, first of all, divest your minds of sympathy. I do not say that, gentlemen, neither would I say it were I the attorney of the government of the United States. But I do say this: divest yourself of prejudice if you have it, but do not, gentlemen, divest yourself of sympathy. What is the great distinguishing characteristic of man? What is it that distinguishes you and me from the lower animals, from the beasts? More, I say, than anything else, human sympathy. Human sympathy. Were it not for sympathy, gentlemen, the idea of justice never would have entered the human brain. This thing called sympathy is the mother of justice, and although justice has been painted blind, never has she been represented as heartless until so represented by the district attorney in this case. I tell you, there is no more sacred, no more holy, and no purer thing than what you and I call sympathy. And the man who is unsympathetic is not a man. Gentlemen, the white breast of the lily is filthy as compared to the human heart perfumed with love and sympathy. I do not want you to divest yourself of sympathy, neither do I want you to try the case entirely upon sympathy. But I want you sympathetic enough to put yourselves honestly in the place of this defendant. Now, gentlemen, as a matter of fact, this case resolves itself into simply one point. All the rest is nothing. All the rest is the merest fog that can be brushed from the mind with a wave of the hand, and it is all resolved down to simply one point, and that is Jacob Rem worthy of credit? Has Jacob Rem told against this defendant a true story? Now that is all there is in this case. The other points that they raise, and which I shall allude to before I get through, are valuable only as they cast a certain amount of suspicion upon the defendant, but the real point is, and the attorneys for the government know it, is Mr. Jacob Rem's story worthy of credit? Did he tell the truth? Judge Banks felt that was the only question, and for that reason, in advance, he defended the reputation of Jacob Rem for truth and veracity, and he made to the jury this remarkable statement, quote, "The reputation of Jacob Rem for truth and veracity is good. It spreads all over the city of Chicago like sunlight." End quote. That was the statement made by the district attorney of the United States. I do not believe that he would swear to that part of his speech. It was an insult to every person on this jury. It was an insult to this court. It was an insult to the intelligence of every bystander that the reputation of Jacob Rem spread like sunlight all over the city of Chicago? My God, what kind of a sunlight do you mean? Think of it. Now then, gentlemen, he knew it was necessary to defend the character of Mr. Rem. He knew it was necessary to defend that statement. He knew that the testimony of Mr. Rem was the only nail upon which the jury could possibly hang the verdict of guilty in this case. And now I propose to examine a little the testimony of Mr. Jacob Rem. I believe it was stated by Judge Banks that one of the best tests of truth was that a lie was at war with all the facts in the universe, and that every fact standing, as it were, on guard, was a member of the police of the universe to arrest all lies. Let me state another truth. Every fact in the universe will fit every other fact in the universe. A lie never did, never will fit anything but another lie made to fit it. Never, never. A lie is unnatural. A lie in the nature of things is a monstrosity. A lie is no part of the great circle, including the universe within its grasp, and consequently, as I said before, will fit nothing except another lie. Now, then, to examine the testimony of a witness, you examine into its naturalness, into its probability, because you expect another man to act something the same as you would under the same circumstances. We have no other way to judge other people except by our own experience and an authenticated record of the experience of others. Consequently, when a man is telling a story, you have to apply to it the test of your own experience, and, as I say, the recorded tests of other honest men. Now, let us suppose, just for a moment, that the testimony of Mr. Jacob Rem is true. Let us suppose it. It has been stated to you, and admirably stated, by Judge Doolittle, admirably stated, that it was the height of absurdity to suppose that a man would do as he did for nothing. But let me put it in another light somewhat. According to the testimony of Mr. Jacob Rem, he first tried to stop this stealing. Nobody offered him any money to stop it, but he simply went to the collector, Irwin, and said they were stealing and that it must be stopped. And thereupon Collector Irwin changed the gaugers for the purpose of stopping the stealing. A few days thereafter, somebody came to him and wanted the stealing to commence, and he told them that they would have to pay for it, and the amount they would have to pay for it, and then he went to Collector Irwin, whom he supposed at that time to be a perfectly honest and upright man, and told him, in short, that they wanted to steal and would give $500 a month. Irwin said, "Go ahead." He admits that they did steal. He admits that they made a bargain with him. He admits that that happened, and he assigns all these gaugers and storekeepers. He admits that he did that for 2 years. He admits that he received at least $120,000 of this money. He admits that in order to carry out this scheme, he knew that every distiller would have to sign a lie every time he made a report to the government. He admits that he knew every gauger would have to swear to the lie at the end of every month in his report of the transactions of each day. He admits that every storekeeper would be guilty of perjury every time he made a report. He admits that he knew that the thing that he was committing for 2 years was a daily penitentiary offense. He admits that he put himself in the power of all these gaugers and all these storekeepers and all these distillers and rectifiers, put it in their power to have him arrested for a penitentiary offense at any moment during the whole 2 years. And yet he tells you that he did this absolutely for nothing. He tells you every cent he received he divided and paid over, and that he never kept a solitary dollar, except it may be for a box of cigars. I want the attorney for the government to tell this jury that he believes that story. And if he does tell you so, gentlemen, I will give you notice now that you need not believe any other word Mr. Ayres says, if he says he believes that. Now then, what more? He knew that all these men were committing these penitentiary offenses, and that he was putting himself in the power of all these men. And what was his motive? What, gentlemen, was his object? It is impossible for me to imagine. If he got no money, if he made nothing out of this transaction, it is impossible for me to imagine why he embarked in such a course of crime. Why, then, did he say to you, gentlemen, that he paid all this money over? It was to build up a reputation with you. It was to make you think that whereas he paid this all over, that whereas he did all this business simply to accommodate his friends, that he was worthy of credit in his statement of this case. He told you that he did not keep a dollar simply to make a reputation with you. What did he want a reputation with you for? So that he would be believed. And what did he want to be believed for? So that he could send Munn to the penitentiary and, as the price of Munn's incarceration, get his own liberty. That is the reason he swore it, and there is no other reason in the world. Is it probable that a man would commit all these crimes for nothing? Is it possible that he would hire and bribe other men to commit these crimes for nothing? I ask your common sense. I appeal to your brains. Is it probable that he would do all that absolutely for nothing? Is it probable that he would lay himself liable to the penitentiary every hour in the day for 2 years for nothing? There is and can be but one answer to such a question as that. Why, gentlemen, if his statement is true that he did all this for nothing, he is the most disinterested villain, the most self-sacrificing and self-denying thief of which the history of the world gives any record. Is it possible? Is it possible, I say, that a man would make himself the sewer of all the official rot in this city in which was deposited the excrement of frauds? Is it possible he would turn himself into a scavenger cart, into which should be thrown all the moral offal of the city of Chicago for nothing? Whoever answers that question in the affirmative is, in my judgment, an idiot. Nobody can. Nobody has a mind so constructed that it can lodge an affirmative answer to that question within its brain. What next? He tells you that Munn was in this plot, and that he, Mr. Rem, at the same time was selling protection to these distillers. No distillers, and you know it, would have given him $10 a barrel unless they expected protection. He then was engaged in the sale of protection, was he not? Did you ever know of a vendor crying down his own wares? Did you ever hear of a merchant crying down the quality of the cloth he wished to sell? Did you ever hear of a grocery man endeavoring to cry down that which he wished you to buy? Jacob Rem was selling protection at $10 a barrel, and sometimes asking $12.50. Was it not natural for him to endeavor to convince distillers that he had plenty of protection to sell? Was it not natural for him to make the distillers believe, if you will give me $10 a barrel, you will have perfect protection? Would it be natural for him to say, I will protect you for $10 a barrel, and yet I have none of the officers in my pay? They would say, what kind of protection have you got, sir? Would it not be natural for him to make out his protection as good as he possibly could? Would it not be natural for him to tell you, I have got all these officers on my side, from the lowest gauger to the gentleman who presides over the Internal Revenue Department at the city of Washington? The more protection he had, the more money he could get, and consequently it would not be natural for him to cry down his own protection. If Mr. Munn was in it, and if Mr. Munn at that time was the superior officer of the collector, and this man had protection to sell, would he not have said that Munn was also in the ring? When he was trying to sell protection to George Burroughs at $10 a barrel, George Burroughs asked him if Munn was in the ring, and he said he was not. If Mr. Munn had been, why didn't he say that Munn was? For the reason that that would make his protection appear to be of a better quality, and he could have sold it at a better price. But he said no, and that they did not need him, because they could manage him and fool him through this man Bridges, and you will recollect that Bridges was appointed directly by the government, and not by Munn, and Bridges reported directly to the government, and not to Munn. He had nothing to do with him one way or the other, except that they were both in the Revenue Department. Now, I say, if it is possible that a man can cry down his own wares that he wishes to sell, then you may say that the statement of Rem is natural. Now, gentlemen, why should Rem inform Burroughs that Munn was about to make a visit here? In order that Burroughs might have an opportunity to have his house put in order. Why should he have sent notices to other distillers that Munn was coming? Why should he tell them to put their houses in order? So as to be ready for a visit from Mr. Munn. It may be that the counsel for the government will say, this shows the infinite fidelity of this infinite rascal. Now, I will come to this part of my argument again, but the next thing I will speak of is Rem's story, where he says that he actually paid the money to Munn himself, and if there is anything left out of that after I get through with it, you are at perfect liberty to find the defendant guilty. You must recollect that Rem had a bargain. Now, according to his story, he paid this money to Bridges. You must recollect, according to his story, that Munn at that time was one of the conspirators, had been receiving money, a half of $35,000 or $45,000 having gone into his pocket. Recollect that. He goes over one day to the rectifying house of Roel and Junker, and there are some barrels found, and stamps of which had not been scratched. Mr. Munn was assured by Roel that there was no fraud. Roel still swears that there was no fraud. He was afterward assured by Junker that there was no fraud. Junker still swears that there was no fraud. Now, what does Rem come in to swear? Rem says that Bridges came to him and told him that Munn was going to make trouble. Going to make trouble about these barrels that had the stamps on that were not scratched off. Why did not Rem say to him, "How is he going to make a fuss? He has got $20,000 of money already. He is in the conspiracy. He is a nice man to make a fuss. What is he going to make a fuss about?" Would it not have been just as likely that Mr. Bridges should have made a fuss as that Munn should have made it? Bridges, according to the testimony of your immaculate witness, was in this no more than Munn, not one particle. And why was Munn going to make trouble? Mr. Rem has endeavored to answer that question. Mr. Rem then goes to Munn, sent there by Bridges. It would be very hard to find out why he did not give the money to Bridges, but he went to Munn and says, "You are going to make some trouble about what you found at Roll and Junker's, yes?" "Why?" "Because," he says, "the men at work there, the persons employed there, will make a fuss about it, but they will see it and say that it is overlooked." Now that is the reason that Rem puts in the mouth of the defendant. Afterward he goes himself to Junker and advises him to give Munn $500, and Junker proposes $1,000 and gives Rem $1,000. And then he sends for Munn, and he comes to his office, and Rem hands Munn $1,000. Now, gentlemen, the reason Munn gave was that the men there would notice it and make a disturbance about it. Well, then, why not pay the men? What is the use of paying Munn? If this was done to prevent the men working at the rectifying house from making trouble, why not pay the men? Why not pay the men who were going to make the trouble? Why give an extra $1,000 to a conspirator to whom you have already given $20,000, and who at that time, according to the testimony of Rem, was officially rotten? Why not give the money to men who were going to make the trouble? And the next question is this, and if you will recollect the testimony of Roel, he swears that when the defendant came to the rectifying house, he, Roel, was alone. He swears that he was alone. He swears that all the rest had gone to dinner, and according to Roel's testimony, there was nobody there but himself. Where were the men that were going to make this disturbance? Where were the men that were going to notice this oversight? Where were the men that were going to stir up difficulties at Washington or any other place? According to the testimony of Roel, those people were at dinner. And where, gentlemen, is the philosophy of that lie which they have told? Where is it? Why should he have paid Munn money? Why didn't he pay it to Bridges? If it was for the purpose of stopping the men from making trouble, why not pay it to the men they wished to stop? I ask the gentleman to answer that question. I ask the gentleman to tell us what men were in danger of making this trouble. Was it the gauger who received $600 a month for being a liar and a thief? Was it the bookkeeper who, every report that he made, swore to a lie? Was there any danger of these liars and of these thieves making a fuss on their own account? Was there any danger of that gauger stopping his own pay? Was there any danger of that bookkeeper trying to throw himself out of employment? Was there any danger of any thief or of any conspirator saying anything calculated to bring this rascality to the surface? If a bribed gauger would not tell it, if a bribed bookkeeper would not tell it, I ask the Attorney General for the government, would Munn tell it, who had received, according to your evidence, over $20,000 of fraudulent money? Was there any danger of Munn turning state's evidence against himself? Was there not just as much danger of Bridges making a fuss as Munn? Was there not, according to their testimony, the same danger of Rem himself going to Washington as there would be of a bribed gauger and of a lying bookkeeper? Gentlemen, your story won't hang together. There is no philosophy in it, and it will not fit anything except another lie made on purpose to fit it, and it has got to be made by a better mechanic than Jacob Rem. Now then, gentlemen, what more? The district attorney told you, and I was astonished when he told it. I was astonished. He said that the testimony of Jacob Rem was not impeached, that on the contrary it was sustained by these other witnesses. Had he made such a statement under oath, I am afraid an indictment for perjury would lie. He said that the testimony had been sustained rather than impeached. How sustained? Mr. Rem, did you ever give Mr. Burroughs notice that Mr. Munn was coming in order that he might put his house in order? Mr. Rem says no. We then asked Mr. Burroughs, did Mr. Rem ever give you such notice? And he corroborates Mr. Rem by saying yes, if that is what you call corroboration. Did you tell Mr. Hessing that Munn was not in it? I did not. Mr. Hessing, did Mr. Rem tell you that Munn was not in it? He did. That is another instance of the attorney's idea of corroboration. Did you tell Hessing that Hoyt was innocent? I did not. Mr. Hessing, did Mr. Rem tell you that Hoyt was innocent? He did. Another corroboration. Did you tell him that Munn never was in it, that Munn was innocent? No. We then asked him, did he tell you that? He did. We say to Burroughs, in 1874, in 1873, in 1872, did Rem tell you that Munn was not in it? He did. That is another idea, I suppose, of corroboration. Question. Mr. Rem, how much money did the house of Dickinson and Leach give you? Answer, $25,000. Question. Will you swear they did not give you 30? Answer. I will. Mr. Leach on the stand. Question. How much money did your house give Rem? Answer. Between $40,000 and $50,000. Another instance of corroboration. We then called Mr. Burroughs upon the stand. He belonged to the same house. Question. How much money did you give Jacob Rem? Answer. $52,000. Another instance of corroboration. Question. Mr. Rem, did Mr. Abel ever give you any money? Answer. Yes, sir. How many times? Answer. Once. How much? Answer. $500. Will you swear it was not 1,000? Answer. Yes. Mr. Abel takes the stand. Question. Did you ever pay Jacob Rem any money? Answer. Yes. How often? Answer. Once. How much? Answer. $2,000. And that is another instance of the corroboration of Jacob Rem. And when a man is thus corroborated, gentlemen, his reputation for truth and veracity spreads like sunlight all over the city of Chicago. There was not a circumstance, there was not a statement made by Mr. Rem, except it was made in the presence of Bridges, who is in Canada, of Irwin, who is in his grave, or in the presence of the defendant, who stands here with his mouth closed, not one solitary circumstance, with those exceptions, that has not been contradicted. Can you believe this man? Can you believe this man who has been contradicted by every one brought upon the stand? Can you take his word after he has sworn as he has? I tell you, gentlemen, you cannot do it. And as Judge Doolittle told you, if there is an infamous crime in the world, it is the crime of perjury. All the sneaking instincts, all the groveling, crawling instincts unite and blend in this one crime called perjury. It clothes itself, gentlemen, in the shining vestments of an oath, in order that it may tell a lie. Perjury poisons the wells of truth, the sources of justice. Perjury leaps from the hedges of circumstance, from the walls of fact, to assassinate justice and innocence. Perjury is the basest and meanest and most cowardly of crimes. What can it do? Perjury can change the common air that we breathe into the axe of an executioner. Perjury out of this air can forge manacles for free hands. Perjury out of a single word can make a hangman's rope and noose. Perjury out of a word can build a scaffold upon which the great and noble must suffer. It was told during the Middle Ages and in the time of the Inquisition that the inquisitors had a statue of the Virgin Mary, and when a man was brave enough to think his own thoughts, he was brought before this tribunal, and before this beautiful statue, robed in gorgeous robes and decked with jewels, and as a punishment he was made to embrace it. The inquisitor touched a hidden spring, the arms of the statue clutched the victim, and drew him to her breast filled with daggers. Such, gentlemen, is perjury. And if you take into consideration the evidence of this witness when you retire to the jury room, you, in my judgment, will commit an outrage. Every man here should spurn that man from the threshold of his conscience as he would a rabid cur from the threshold of his house. Is there any safety in the world if you take the testimony of these men, especially when character avails nothing? Is there any safety in human society if you will take the testimony of a perjured man? Is there any safety in living among mankind if this is the law? If the statement of a confessed conspirator makes the character of a great and good man worthless? For one, I had rather flee to the woods and live with wild beasts and savage nature. Gentlemen, I know that you will pay no attention to that kind of testimony. I know it. I know that you cannot do it. And why? You know that that man is swearing a lie for the purpose of protection. You know that that man is swearing a lie under the smile of the government of the United States. You know it. You know he expects a benefit from it. You know it. When other witnesses, Burroughs and Hessing, that swear here, understand that they are swearing beneath a frown. Understand that they know that no mercy will be extended to them by the attorneys that they have offended. Understand that, and when you understand that a man is swearing to protect himself, and when he is a man that will swear to a lie for money, of course he will swear to a lie to keep himself out of the penitentiary or to shorten his time. I say, when you know a man is placed in that condition, you have no right to give the least weight to his testimony, not one particle. What more, gentlemen? Why, they have another witness, and he has sworn nothing. He has sworn nothing that has anything to do with this conspiracy, one way or the other. Nothing. The only evidence against the defendant, I tell you, is the evidence of Mr. Jacob Rem. The defendant, gentlemen, was an officer of the revenue for several years. When he came to Chicago in 1871, the district attorney said the distillers were here in full blast making illicit whiskey. If he had read the evidence, he knew better. If he had not, he had no business to make any statement about it. In 1871, when the defendant came here, according to the testimony of all these men, the distilleries were running straight, and the rascality did not commence until the fall of 1872, when Jacob Rem sold protection to these distillers. The defendant had been here a year before any frauds were committed. He was then supervisor of Internal Revenue up to May 1875. During that time, he did many official acts. During that time, he wrote hundreds and thousands of letters. During that time, he made hundreds and hundreds of visits to all these establishments. They have searched the records. They have had every nook and cranny looked at by a hired detective, and all that they can possibly bring forward is the beggarly account presented in this case. First, that there were 4 or 5 barrels of rum without the 10-cent stamps, and that, you know, is a thing that ought to send a man to the penitentiary. Next, 25 barrels of which the stamps had not been scratched, but about which there was no fraud. Ought a man to be sent to the penitentiary because he does not seize a house when there has been a technical violation without any fraud? A supervisor that will do it ought to be kicked out of office. He ought to be kicked out of the society of honest and decent men. And if this defendant was satisfied from the story of Roel and Junker that there had been no fraud committed by leaving the stamps on the 25 barrels unscratched, and had seized that house, that would have been an act of meanness, an act of oppression, which I do not believe even a government attorney would uphold unless he was hired in the case. Now, what next did he do? The next thing he did, he went to Golson and Eastman. Gentlemen, I do not care to speak much of Golson. If there ever was a man utterly devoid of such a thing as principle, if there ever was a man that would read the statute against stealing and stand in perfect amazement that anybody ever thought of making such a statute, it certainly must be Golson. You heard him, and he is the man that said he told lies in business. He is the man that said he did not think it was wrong to swear lies in business, and his business now is to keep out of the penitentiary. That is his principal business. That is one of the gentlemen they have hired. That is one of the gentlemen they have brought forward here to offend the nostrils of decent men. Now then, he went to Golson and Eastman. Judge Bangs told you in his speech that Golson then and there explained his infamy to Munn. This ends Chapter 1, Part 1 of 2. Chapter 1, Part 2 of the works of Robert G. Ingersoll, Volume 10, Ingersoll's Address to the Jury in the Munn Trial. Part 2 of 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Michele Fry, Baton Rouge, Louisiana. Part 2. If there is anything which makes my blood boil, it is to have the evidence misstated for the purpose of putting a man in the penitentiary. I will never make a misstatement to add to my reputation. I recollect that evidence so perfectly. I recollected it so clearly that it shocked me when Judge Bangs stated that the man Golson explained all his rascality and villainy to Munn. Why, I never heard of such evidence. What was it? It was said by Mr. Eyre in the opening that in the presence of Munn, Golson said to Bridges, "It is not now all right," or something like that, "but I can make it right," or that he said in the presence of Munn to Bridges something that should have put Munn on his guard. I heard that, and I heard Golson, when he came on the stand, say that he said that to Bridges. And you will bear me out when I say that I asked him in his cross-examination, "Did Munn hear it? Did you say it thinking that Munn did hear it?" And he did not pretend any such thing. He did not pretend it, and I tell you I was hurt. I was touched, I admit it, when Judge Bangs made the statement. I have an interest in this case. I am not only an attorney in this case, but, gentlemen, I am proud to say I am the defendant's friend. I am more than his attorney, I am his friend. And when an attorney makes a statement like that, I must say it shocks me. Golson did not swear that he explained his villainy to Munn, not a word of that kind or character. On the contrary, he simply said he told this to Bridges, not to Munn, and that Munn did not hear it. What more? Then Munn went through the rectifying house like an honest man. How did he act? Like an honest man. Did he act like somebody trying to cover up a fraud? No, he acted like an honest man, and I tell you, up to that time, Mr. Eastman had borne a good reputation, a good character in the state of Illinois. Munn believed what he said. He believed there had been an accident. Munn believed they made the charge in the books not for the purpose of covering up a fraud, but for the purpose of making the books agree with the facts. So much for that. I do not recollect any others. I do not recollect any others that amount to anything, that can throw the slightest suspicion on this defendant. If Munn were on trial now for failing to make a report, if he were on trial now for malfeasance or nonfeasance or negligence as an officer, it would be proper to bring all these things before this jury. But that is not the case. He is here for entering into a conspiracy to defraud the government, and these things that they have shown outside, and it is perfectly amazing to me that they have not shown more. It is perfectly amazing to me that a man could be in that position the years he was without making more mistakes. I say all they prove in the world is, given them their very worst construction, that Munn was guilty of some negligence as an officer. But they do not attempt to prove that he was in a conspiracy with Mr. Jacob Rem to steal. The next point, gentlemen, to which I wish to call your attention, is the testimony of Mr. Rem before the grand jury. You recollect when we put on Mr. Ward to show what Rem testified to before the grand jury, that Mr. Eyre, attorney for the government, suggested that we had better have the notes. I saw then that he was extremely anxious for Schlichter to get on the stand. Then we introduced Mr. Oleson, and Eyre still spoke about having the notes. I understood that it was a part of his case to have Schlichter brought on the stand in some way. Now, then, it does not make any difference to me whether Schlichter swore to the truth or not. Not a particle, not a particle. But I think he did. But if he did swear to a lie, and he will swear to a lie every chance he gets, in the course of time he will get such a character and such a reputation that a district attorney of the United States will stand up and say, "Schlichter's reputation is good. It spreads like sunlight all over the city of Chicago." Now then, you have been told by Judge Doolittle, all the men who swore, that Jacob Rem did swear before the grand jury that he did not know of any crookedness. You have heard the testimony of men who swear that Jacob Rem did swear before the grand jury that he knew of no fraud. If he did so swear, he perjured himself, or he has perjured himself now. But what more? Whether he swore that or not, he swore this, according to their own statements. Question. At the time you burned your books, had you any knowledge that they contained any evidence of fraud against the government? Answer. No, sir. Now, he knew the distillers used a certain amount of malt to make a certain amount of high wines, and he knew the more malt they used, the more high wines they would have to account for, and if they bought twice as much malt as was necessary to make the whiskey upon which they paid the tax, he knew that that was evidence that they had been running without paying the tax. If it takes a certain amount of malt for a gallon of high wines, and his books would show that they used twice as much malt as they had paid taxes, according to gallons, then he did know that his books did contain evidence showing that they had committed fraud. And when he said his books did not, he told what he knew was a deliberate lie. What more does Jacob Rem say? He says these books were burned up about the 1st of May, just to get them out of the way, for no earthly object except simply to get them out of the way. And he swears that he sold to nearly all these distillers malt, and he knew that the amount of malt sold to each of these distilleries would determine the amount of whiskey they had made, that is, not into a barrel or into a gallon, but approximately. And he knew the more malt they used, the more tax they would have to show that they had paid. And he knew that his books would be evidence against every distiller in the city. He knew that. And yet he swears here, squarely and fairly, that at the time he burned his books, he did not know that they were of any value as evidence against these distillers. Now, gentlemen, I want to call your attention to another thing. When I asked Jacob Rem, when he was called here on the stand, if he was not asked about crookedness, whether he was not asked about fraud, at first he stumbled into telling the truth, as far as that was concerned, as far as being asked was concerned, and then told a lie as to how he answered it. Now let me read it to you. You may have forgotten it. There is nothing like having these things printed. Question. Were you sworn before that grand jury by anybody? Answer. Yes, sir. Were you asked any question about this whiskey business? Yes, sir. Were you asked by one of the grand jurors whether you knew of any illicit whiskey being made in this city by any of those distilleries? Answer. No, sir. Question. I ask you in regard to your answer to that. If you did not say, you did not. Answer. I did not. Question. What did you say? Answer. The question was not asked in that way. Question. Well, wait until I ask you, and then you can tell. Were you not asked if you knew of any crookedness about whiskey, and didn't you reply, no? Answer. No, I answered yes. There is his testimony. He was afraid then that he was caught, and he was going to swear deliberately that he swore before the grand jury that he did not know of crookedness. Then he changed his idea and says afterward that it is about the 150 barrels. He says now, put your question. Then I put this question. Were you asked by one of the grand jurors whether you knew of any illicit whiskey being made in this city by any of those distilleries? Answer. The question was not put to me in that way. Now he gets out of it and says it was the 150 barrels he talked about. But I asked him then if he was not asked if he did not know about any crookedness here and how he answered it, and he says that he answered it yes. That is, before he found out that it was necessary to change his answer or to change his mind upon that question. That is what he says. And it is utterly impossible, gentlemen, to get out of the fact that Jacob Rem did, before that grand jury, swear that he knew of no crookedness. You cannot get out upon Mr. Roell's testimony. You cannot get out upon the idea that Schlichter put it in. Schlichter did not put it into the memory of the old man Samson. Schlichter did not write it in the memory of Mr. Hoag. Schlichter did not write it in the consciousness of Mr. Oleson. Schlichter did not write it in shorthand in the head of J.D. Ward. Schlichter, I tell you, by his shorthand necromancy, has not changed 6 or 7 men into liars, whether he put that in the second line from the top or not. He cannot do that with his shorthand, gentlemen. He could not make old Mr. Samson come here and say, quote, I asked that question myself. I thought that when he was there, Rem was the head center of all the rascality. And so, just before he went out, I put one of those general pinching questions as to whether he knew anything. It was a kind of conscience scraper. End quote. The old man put that question just as these witnesses were going out. Quote, do you know anything about any fraud? Do you know anything about any crookedness? End quote. It was a kind of a last question that would cover the case, and the old man recollects that he put it to Jacob Rem, and he recollects why he put it to him, because he believed at that time that Rem was the head center of the villainy. Mr. Hoag says the same thing. Mr. Hoag says that he looked upon Rem as the great rascal in the business, and he recollects distinctly that he asked him that question, and he recollects as distinctly how Rem answered it. J.D. Ward was the attorney for the United States, and he swears to it that he recollects it perfectly. Oleson was an attorney of the United States. He says that he recollects it perfectly. And yet is this all to be accounted for, gentlemen, by saying that Mr. Schlichter inserted it in his notes, and that all these other gentlemen are mistaken? The fact is, gentlemen, that Mr. Rem, when he was there, had not made up his mind to vomit. He had not yet made up his mind that he could make a bargain with the United States to get out of punishment. He did not know at that time that he need not go to the penitentiary if he would furnish a substitute. He did not know, gentlemen, at that time that he could have an understanding with anybody. If he would bring better blood than his, they would deal lightly with him. He did not know at that time that 2 owls could be traded off for an eagle. He did not know at that time that 2 snakes could be traded off for a decent man. As soon as he found that out, then, instead of saying that he did not know anything about any crookedness, instead of saying that he did not know anything about any fraud, he said, gentlemen, I know all about it. I know all of them, every one of them. Now, gentlemen, I want you to put against that man's testimony the lies he swore to himself. I want you to put against that man's testimony the improbability that he would commit numberless crimes for nothing. I want you to put against that man's testimony the testimony of everyone who has contradicted and disputed him. I want you to put against that man's testimony the idea and the fact that he warned these other men against the approach of Munn. I want you to put against that man's testimony all the circumstances of the lies he has sworn, and I want you, in addition to that, to put against that man's testimony the evidence of this defendant. You have been told by the district attorney, and if I have said anything too strong in the warmth of this discussion, I beg his pardon. I have known Judge Bangs a long time. I have been his friend. I respect him. But I must say I felt a little outraged at what he said, because he said he had sympathy with this defendant. He got up here and said that Daniel Munn bore a most excellent reputation. He got up and said that he sympathized with him, and all at once I saw his sympathy was a cloak, under which he concealed a dagger to stab him. Now then, he says good character is nothing. Good character is nothing? Good character, gentlemen, is not made in a day. It is the work of a life. The walls of that grand edifice called a good character have to be worked at during life. All the good deeds, all the good words, everything right and true and honest that he does, goes into this edifice, and it is domed and pinnacled with lofty aspirations and grand ambitions. It is not made in a day, neither can it be crumbled into blackened dust by a word from the putrid mouth of a perjurer. Let these snakes writhe and hiss about it. Let the bats fly in at its windows if they can. They cannot destroy it, but above them all rises the grand dome of a good character, not with the bats and snakes, but up, gentlemen, with eagles in the sunlight. They cannot prevail against a good character. Is it worth anything? If ever I'm indicted for any offense and stand before a jury, I hope that I shall be able to prove as unsullied a reputation as Daniel W. Munn has proved. And when I read those letters, not only saying that his character was good, but adding above reproach, it thrilled me, and I thought to myself then, if ever you get in trouble, will anybody certify as splendidly and as grandly to your reputation? There is not a man of this jury that can prove a better reputation. There is not a judge on the bench in the United States that can prove a better reputation. There never was, and there never will be an attorney at this bar that can prove a better reputation. There is not one in this audience that can prove a better reputation. And yet we are told that that splendid fabric called a good character cannot stand for a moment against a word from a gratuitous villain, not one moment. Such, gentlemen, is not the law of this country. Such, gentlemen, never will be the law of this land or of any other. I deny it, and I hurl it back with scorn. A good character will stand against the testimony of all the thieves on earth. A good character, like a Gibraltar, will stand against the testimony of all the rascals in the universe, no matter how they assail it. It will stand, and it will stand firmer and grander the more it is assaulted. What is the use of doing honestly? What is the use of working and toiling? What is the use of taking care of your wife and your children? Where is the use, I say, of being honest in your business? What is the use of always paying your debts as you agree? What is the use of living for others? Character is made of duty and love and sympathy, and above all, of living and working for others. What is the use of being true to principle? What is the use of taking a sublime stand in favor of the right with the world against you? What is the use of being true to yourself? What is the use, I say, if all this character, if all this noble action, if all this efflorescence of soul can be blasted and blown from the world simply by a word from the mouth of a confessed felon? And yet we are assured here in this august tribunal, in a federal court of the United States, where the defendant stands under the protection of the Constitution of his country, that his character is absolutely worthless. They say, "Why don't you bring somebody to impeach Mr. Jacob Rem?" Why? Because he has impeached himself. To impeach a man is the last method. If he tells an improbable story, that impeaches him. If he tells an unnatural story, that impeaches him. If you prove he has sworn a different way, that impeaches him. If you show he has stated a different way, that impeaches him. What is the use of impeaching him any more? That would be a waste of time. Now, gentlemen, I say to you, and I say to you once for all, I want you to get out of your minds and out of your hearts any prejudice against this man on account of these times. I understand now that in every man's pathway hiss and writhe the serpents of suspicion. I understand now that every man in high place can be pointed at with the dirty finger of a scurvy rascal. I understand that. I understand that no matter how high his position is, that any man, no matter how low, how leprous he may be, what a cancerous heart he may have, he can point his finger at the man high up on the ladder of fame, and the man has to come down and explain to the wretched villain. I understand that, but these prejudices I want out of your mind. I want you to try this case according to the evidence, and nothing else. I want you to say whether you believe the testimony of these conspirators and scoundrels. I want you to say whether you're going to take the testimony of that man, and if you bring in a verdict of guilty, I want you to be able to defend yourselves when you go to the defendant and tell him, "We found you guilty upon a man's testimony who admitted that he was a thief, who admitted that he was a perjurer, who admitted that he hired others to swear lies, and who committed crimes without number year after year." I want you to say whether that is an excuse to give to him. Is it an excuse to give to his pallid invalid wife? Is it an excuse to give to his father, 80 years old, trembling upon the verge of the grave? I sent your son to the penitentiary upon the evidence of a convicted thief. I say, is it an excuse to give to his weeping wife? Is it an excuse to give to his child? I sent your father to the penitentiary upon the evidence of Jacob Rem. There is not one of you can go to the child, or to the sick wife, or to the old man, or to the defendant himself, and without the blush of shame say, "I sent you to the penitentiary upon the evidence of Jacob Rem." You cannot do it. It is not in human nature to do it. Now, gentlemen, there is one other thing I want to say. Suspicion is not evidence. Suspicious circumstances are not evidence. All the suspicion in the world, all the suspicious circumstances in the world amount not to evidence. I want to say one more thing. They say that the testimony of a thief ought to be corroborated. By whom? Another thief? No, because that other thief wants corroboration, and that other thief would want corroboration, and so on until thieves ran out, which I think would be a long time in this particular community at this particular time. Understand that whatever one thief swears, that it is not corroborated because another thief swears to the same thing, and upon the point upon which Judge Doolittle dwelt so splendidly, he must be corroborated upon the exact point. For instance, Mr. Munn went to his house, Mr. Munn went to his office, and another man says, "I saw him there." That is not corroboration. He must be corroborated in the fact that he gave him the money, not that Munn went to his house, not that he had an opportunity to give him the money, not that he was there, but he must be corroborated as to the exact identical point that makes the guilt. Now, gentlemen, I am going to leave this case with you. I feel a great interest in it. The defendant feels an infinite interest in it. Infinite, I tell you. It is all he has on earth. All he has is with you. You're going to take his hopes. You're going to take his aspirations. You're going to take his ambition. You're going to take his family. You're going to take his child. You're going to take everything he has in this world into your power. It is a fearful thing to take this responsibility. I know it. But you are going to take it. His future, everything he has dreamed and hoped for, everything that he has expected to attain, his character, everything he has that is dear to him, and you are going to say, "Not guilty." Or you are going to cover him with the mantle of infamy and shame forever. You are going to disgrace his blood. You are going to bring those that love him down with sorrow to their graves. You're either going to do that, or you're going to say, "We will not believe the testimony of self-convicted robbers and thieves." And gentlemen, I ask you, I implore you, I beseech you, more than that, I demand of you, that you find in this case a verdict of not guilty. Put yourself in his place. Do you want to be convicted on that kind of testimony? Do you want to go to the penitentiary with that kind of witnesses against you? Do you want to be locked up on that kind of testimony? Do you want to be separated from your wife or your child on that kind of evidence? Do you want to be rendered infamous during your life upon the testimony of such men as Golson and Conklin and Rem? Do you? Do you? Do you? Does any man in the world imagine that 12 honest men can be found that can rob another of his citizenship, of his honor, of his character, of his home, and of his entire fortune, simply on the testimony of such scoundrels? No, gentlemen. For myself, for this defendant, I have no fear. All I ask is that you will give to this evidence the weight that it deserves. All I ask of the prosecuting attorney in this case is that he do his duty. All I ask of him is to state, just as nearly as he can, as I have no doubt he will, the evidence in the case. All I ask of him is that he give to all these circumstances their due weight and no more. I ask him to fight for justice and not for his reputation. I ask him to fight for the honor of the government. I ask him to fight for the complete doing of justice, if he can. But I hope he will leave out of the case all idea that he must win the case or that I must lose the case. We are contending for too great a stake. Personally, I care nothing about it, whether I make or lose what you may please to call reputation in this affair. I care everything for my client. I care everything for his honor, and more than that, gentlemen, I love the United States of America. I love this government. I love this form of government, and I do not want to see the sources of government poisoned. I do not want to see a state of things in the United States of America whereby a man can be consigned to a dungeon upon the testimony of a robber and a thief, simply upon a political issue, simply by the testimony of some man who wishes to purchase immunity at the price of another's liberty and honor. One more point, and I have done. I had forgotten it, or I should have mentioned it before. They have appealed to you all along to say that the fact that high wines were so cheap during all this time put Mr. Munn upon his information, so to speak, that there were frauds. Let me take those books, and let us see. On the 6th day of June, 1874, the tax on spirits was 70 cents, and the price was 94 cents. That made them get 24 cents a gallon for the whiskey. Understand, the tax was 70, the price was 94. That made them get 24 cents for the whiskey. Now then, on the 10th of June, it was 96.5 cents. That made 26.5 for the whiskey. Then on the 10th of June, 1874, 26.5 they got for the whiskey. February 11th, 1874, 96 cents. which made 26 cents, and so it went on in that way until what? Until the tax was raised from 70 cents to 90 cents. And what is it now? The tax on whiskey, gentlemen, is 90 cents, and the price on the 10th day of May, 1876, is $1.07, so that the price of whiskey now is only 17 cents above the tax. And at the time that Mr. Munn ought to have known that everybody was a thief and rascal, the price was 26 cents above the tax, 10 cents more than now. From these figures, gentlemen, you will see it. And how high did it go? The day Mr. Munn was turned out of office, gentlemen, on the 10th day of May, 1875, the tax then being 90 cents, whiskey was worth $1.15. The day he was turned out. It was 9 cents more than it is today. You are welcome to all you can make out of that argument. It was worth 9 cents more a gallon above the tax the day he was turned out than it is today. And if Mr. Munn was bound to take judicial notice that there was nothing but frauds in the district, and every distillery was running crooked, I say that the officers of the government are bound to take that notice today, and you must recollect, gentlemen, that it was admitted in this case that there were frauds all over the country, that there were distilleries running in St. Louis, in San Francisco, in Milwaukee, in Peoria or Pekin, in Peoria, I believe, in my town, not a sound has been heard, and not a solitary man, I believe, charged with fraud. In St. Louis, in Louisville, in Cincinnati, in all these towns. Now, where was the whiskey being made that was crooked? Nobody could tell. If there was a vast amount being made in Cincinnati, it would lessen the price in Chicago, no matter whether the Chicago distillers were running honestly or not. If there was a vast amount being made in St. Louis, it would lessen the price, no matter whether the other distilleries were running honestly or not. Consequently, it was impossible for the supervisor to tell it. There was another thing I forgot. During all the time Jacob Rem was doing this gratuitous rascality, he was one of the bondsmen on the official bond of Hoyt. He was not only helping Hoyt steal and giving him all the money, but he was making himself responsible for the money he stole, and he did not charge any commission on it. He did not charge for any shrinkage or shortage or anything in the world, but made himself liable for the uttermost farthing. He was on the bond of Collector Irwin, called the stamp bond, and so do not forget that he did not only not take any money, but he went on the acknowledgments of the thieves that stole it. He not only did not take any himself, but he made himself liable as a bondsman for what he gave to them. Do not forget these things. Now, gentlemen, I believe I have said about all I wish to say to you. The rest is for you. You must take the case, and as I said, you do not want to go off on any prejudice against the kind or the character of the case. You do not want to go off on the idea that the air is full of rascality because some of us are to be tried next. We don't know. Let us try this case fairly and squarely on the evidence, and the next time I meet you, gentlemen, every one of you will be glad that you found this defendant not guilty, as you cannot avoid doing. The jury rendered a verdict of not guilty. End of Chapter 2. Ingersoll's address to the jury in the Munn trial.
Chapter 2, Part 1 of the Works of Robert G. Ingersoll, Volume 10. Ingersoll's Closing Address to the Jury in the First Star Route Trial, Part 1 of 7. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Part 1. Closing Address to the Jury in the First Star Route Trial. The most characteristic feature of the Star Route Trial, which has been the central point of interest in our city for the past 3 months, was the marvelously powerful speech of Colonel Robert G. Ingersoll before the jury and judge last week. People who knew this gifted gentleman only superficially had supposed that he was merely superficial as a lawyer. While acknowledging his remarkable ability as an orator and his vast accomplishments as a speaker, they doubted the depth of his power. They heard him, and the doubt ceased. It can be said of Ingersoll, as was written of Castelar, that his eloquent utterances are as the finely fashioned ornamental designs upon the Damascus blade. The blade cuts as keenly, and the embellishments beautify without retarding its power. The following is Colonel Ingersoll's speech. Its swift incisiveness, keen and comprehensive logic, and apt deductions from proper premises are only equaled by the grand manner of its delivery, and under the circumstances incidental to the case and the routes to be traversed, by its expedition of action and brevity. Washington, D.C., the Capital, September 16, 1882. May it please the Court and gentlemen of the jury, let us understand each other at the very threshold. For one, I am as much opposed to official dishonesty as any man in this world. The taxes in this country are paid by labor and by industry, and they should be collected and dispersed by integrity. The man that is untrue to his official oath, the man that is untrue to the position the people have honored him with, ought to be punished. I have not one word to say in defense of any man who I believe has robbed the treasury of the United States. I want it understood in the first place that we are not defending, that we are not excusing, that we are not endeavoring to palliate in the slightest degree dishonesty in any government official. I will go still further. I will not defend any citizen who has committed what I believe to be a fraud upon the treasury of this government. Let us understand each other at the commencement. You have been told that we are a demoralized people, that the tide of dishonesty is rising, ready to sweep from one shore of our country to the other. You have been appealed to find innocent men guilty in order that the tide may be successfully resisted. You have been told, and I have heard the story 1,000 times, that this country was demoralized by what the gentlemen are pleased to call the war, and that owing to the demoralization of the war, it is necessary to make an example of somebody that the country may take finally the road to honesty. We were in a war lasting 4 years, but I take this occasion to deny that that war demoralized the people of the United States. Whoever fights for the right, or whoever fights for what he believes to be right, does not demoralize himself. He ennobles himself. The war through which we passed did not demoralize the people. It was not a demoralization, it was a reformation. It was a period of moral enthusiasm, during which the people of the United States became 1,000 times grander and nobler than they had ever been before. The effect of that war has been good, and only good. We were not demoralized by it. When we broke the shackles from 4 millions of men, women, and children, it did not demoralize us. When we changed the hut of the slave into the castle of the freeman, it did not demoralize us. When we put the protecting arm of the law about that hut, and the flag of this nation above it, it was not very demoralizing. When we stopped stealing babes, the country did not suddenly become corrupted. That war was the noblest affirmation of humanity in the history of this world. We are a greater people, we are a grander people, than we were before that war. That war repealed statutes that had been made by robbery and theft. It made this country the home of man. We were not demoralized. There is another thing you have been told in order that you might find somebody guilty. You have been told that our country is distinguished among the nations of the world only for corruption. That is what you have been told. I care not who said it first. It makes no difference to me that it was quoted from a Republican senator. I deny it. This country is not distinguished for corruption. No true patriot believes it. This country is distinguished for something else. The credit of the United States is perfect. Its bonds are the highest in the world. Its promise is absolute pure gold. Is that the result of being distinguished for corruption? I have heard that nonsense, that intellectual rot, all my life, that the people used to be honest, but at present they are exceedingly bad. It is the capital stock of every prosecuting lawyer. But in there is not one word of truth. Is this country distinguished only for its corruption throughout Europe? No, it is respected by every prince and by every king. It is loved by every peasant. Is it because we have such a reputation for corruption that 1,000,000 people from foreign lands sought homes under our flag last year? Is corruption all we are distinguished for? Is it because we are a nation of rascals that the word America sheds light in every hut and in every tenement in Europe? Is it because we are distinguished for corruption that one word America is the dawn of a career to every poor man in the Old World? I always supposed that we were distinguished for free schools, for free speech, for just laws, not for corruption. A country covered with schoolhouses, where the children of the poor are put upon an exact equality with those of the rich, is not distinguished for corruption. And yet in the name of this universal corruption, you are appealed to become also corrupt. This nation is substantially 100 years old, and today the assessed property of the United States is valued at $50 billion. Is that the result of corruption? Or is it the result of labor, of integrity, and of virtue? I deny that my country is distinguished for corruption. I assert that it rises above the other nations distinguished for humanity as high as Chimborazo above the plains. Never will I put a stain upon the forehead of my country in order that I may win some case, and in order that I may consign some honest man to the penitentiary. I stand here to deny that this is a corrupt country. Let me say that the only tribute that I ever heard paid to corruption was indirectly paid by Mr. Merrick himself. He told you that official corruption destroyed the French Empire, and upon the ruins of that empire arose the French Republic. He makes official corruption the father of French liberty. If it works that way, I hope they will have it in every monarchy on the globe. Napoleon stole something besides money. He stole liberty, and the French people finally got to that condition of mind where they preferred to be trampled on by Germany rather than to have their liberty devoured by Napoleon. From that splendid sentiment sprang the French Republic. This country is the land not of slavery, but of liberty, not of unpaid toil, but of successful industry. There is not a poor man today in all Europe, or a poor boy, who does not think about America. I recollect one time in Ireland that I met with a little fellow about 10 years old, with a couple of rags for pantaloons and a string for a suspender. I said, "My little man, what are you going to do when you grow up?" "Going to America." It is the dream of every peasant in Germany. He will go to America, not because it is the land of corruption, but because it is the land of plenty, the land of free schools, the land where humanity is respected. There is another thing about this country. We have a king here, and that king is the law. That king is the legally expressed will of a majority, and that law is your sovereign and mine. You have no right to violate one law to carry out another. We all stand equal before that law, and the law must be upheld as an entirety, and in no other way. If in this case you believe these defendants beyond a doubt to be guilty, it is your duty to find them so, and you must find them so in order to preserve your own respect. I do not agree with this prosecution in the idea that the perpetuity of the Republic depends upon this verdict. Decide as badly as you please, as horribly as you can, the Republic will stand in spite of this verdict, and the Republic will stand until people lose confidence in verdicts, until they lose confidence in legal redress. When the time comes that we have no confidence in courts and no confidence in juries, then the great temple will lean to its fall, and not until then. As long as we can get redress in the courts, as long as the laws shall be honestly administered, as long as honesty and intelligence sit upon the bench, as long as intelligence sits in the chairs of jurors, this country will stand. The law will be enforced, and the law will be respected. But so far as my clients are concerned, everything they have, everything they love, everything for which they hope, home, friends, wife, children, and that priceless something called reputation, without which a man is simply living clay, everything they have is at stake, and everything depends upon your verdict. I want you to understand that everything depends upon your decision, and yet my clients with their world at stake, home, everything, ask only at your hands the mercy of an honest verdict, according to the evidence and according to the law. That is all we ask, and that we expect. By an honest verdict, I mean a verdict in accordance with the testimony and in accordance with the law, a verdict that is a true and honest transcript of each juror's mind, a verdict that is the honest result of this evidence. Whoever takes into consideration the desire, or the supposed desire, of the outside public is bribed. Whoever finds a verdict to please power, whoever violates his conscience that he may be in accord, or in supposed accord, with an administration or with the government, is bribed. Whoever finds a verdict that he may increase his own reputation is bribed. Whoever finds a verdict for fear that he will lose his reputation is bribed. Whoever bends to the public judgment, whoever bows before the public press, is bribed. Fear, prejudice, malice, and the love of approbation bribe 1,000 men, where gold bribes one. An honest verdict is the result not of fear but of courage, not of prejudice but of candor, not of malice but of kindness. Above all, it is the result of a love of justice. Allow me to say right here that I believe every solitary man on this jury wishes to give a verdict exactly in accordance with this testimony and exactly in accordance with the law. Every man on this jury wishes to preserve his own manhood. Every man on this jury wishes to give an honest verdict. There are no words sufficiently base to describe a man who will knowingly give a dishonest verdict. I believe every man upon this jury to be absolutely honest in this case. The mind of every juror, like the needle to the pole, should be governed simply by the evidence. That needle is not disturbed by wind or wave, and the mind of the honest juror never should be disturbed by clamor, nor by prejudice, nor by suspicion. Your minds should not be affected by the fume, by the froth, by the fiction, or by the fury of this prosecution. You should pay attention simply to the evidence, and to use the language of one of my clients, you should be governed by the frozen facts. That is all you have any right to think of, and all you have any right to examine. Having now said thus much about the duties of jurors, let me say one word about the duties of lawyers. I believe it is the duty of a lawyer, no matter whether prosecuting or defending, to make the testimony as clear as he can. If there is anything contradictory, it is his business, if he possibly can, to make it clear. If there is any question of law about which there is a doubt, it is his right and it is his duty to give the court the result of his study and of his thoughts, for the purpose of enlightening the court upon that particular branch of law. No matter if he may believe the court understands it, if there is the slightest fear that the court does not or has forgotten it, it is his duty to bring the attention of the court to that law. It is not his duty to abuse anybody. It is not my duty to abuse anybody. There is no logic in abuse, not the slightest, and when a lawyer, under the pretext of explaining the evidence to the jury, calls a defendant a thief and a robber, he steps beyond the line of duty, and in my judgment beyond the line of his privilege. What light does that throw upon the case? In his effort to explain the law to the court, what cloud does it remove from the intellectual horizon of his honor for the attorney to call the defendant a robber, a thief, or a pickpocket? I shall in this case give you what I believe to be the facts. I shall call your attention to the testimony. I shall endeavor to throw that light I am capable of throwing upon this entire question. I shall not deal in personalities. They are beneath me. I shall not deal in epithets. Nobody worth convincing can be convinced in that way. Now let us see what the law is, and let us see what our facts are. In the beginning of this dusty branch, I shall ask the pardon of every juror in advance for going over these facts once again. You see, they strike every man in a peculiar way. No two minds are exactly alike. No pair of eyes distinguish exactly the same object, or the same peculiarities of the objects. This is an indictment under Section 5440 of the Revised Statutes, and there must not be only a conspiracy to defraud, but there must be an overt act done in pursuance of that conspiracy for the purpose of effecting the object of it. Now then, how must these overt acts be stated in this indictment? Is the overt act a part of the crime, and must it be described with the same particularity that you describe the offense? Which of the overt acts set out in this indictment is the overt act depended upon, together with the act of conspiring, to make this offense? I hold, may it please your honor, that every overt act set out in the indictment must be proved exactly as it is alleged, no matter whether the description was necessary to be put in the indictment or not. No matter how foolish, how unnecessary the description, it must be substantiated, and it must be proven precisely as it is charged. No matter whether the particular thing described is of importance or not, no matter how infinitely unnecessary it was to speak of it, still, if it is a matter of description, it must be proven precisely as it is charged. Upon that subject, I wish to call the attention of the court to some authorities, and it will take me but a few moments. I will call the attention of the court first to the case of the State against Noble, 15 Maine, 476. Here a man was indicted for fraudulently and willfully taking from the river and converting to his own use certain logs. These logs were described as marked W with a cross, and H with another cross, and with a girdle. Now it seems that a part of this mark was not found, according to the testimony upon the logs taken. The description of these logs in the indictment is the only way the logs could be distinguished, and could not be rejected as surplusage. It has been settled that if a man be indicted for stealing a black horse, and the evidence be that he stole a white one, he cannot be convicted. The description of a log by the mark is more essential than that of a horse by its color. If it was not necessary to describe the log so particularly by the mark, yet so having stated it, there can be no conviction without proof of it. Now, the court in deciding this says, "It may be regarded as a general rule, both in criminal prosecutions and in civil actions, that an unnecessary averment may be rejected where enough remains to show that an offense has been committed, or that a cause of action exists." In Ricketts v. Solway, 2 Barn, and Aid, 360, Abbott, C.J., says, "There is one exception, however, to this rule, which is, where the allegation contains matter of description. Then, if the proof given be different from the statement, the variance is fatal." As an illustration of this exception, Starkey puts the case of a man charged with stealing a black horse. The allegation of color is unnecessary, yet as it is descriptive of that, which is the subject matter of the charge, it cannot be rejected as surplusage, and the man convicted of stealing a white horse. The color is not essential to the offense of larceny, but it is made material to fix the identity of that which the accused is charged with stealing. 3 Stark, 1531. In the case before us, the subject matter is a pine log marked in a particular manner described. The marks determine the identity and are, therefore, matter purely of description. It would not be easy to adduce a stronger case of this character. It might have been sufficient to have stated that the defendant took a log merely, in the words of the statute. But under the charge of taking a pine log we are quite clear that the defendant could not be convicted of taking an oak or a birch log. The offense would be the same, but the charge to which the party was called to answer, and which it was incumbent on him to meet, is for taking a log of an entirely different description. The kind of timber and the artificial marks by which it was distinguished are descriptive parts of the subject matter of the charge which cannot be disregarded, although they may have been unnecessarily introduced. The log proved to have been taken was a different one from that charged in the indictment, and the defendant could be legally called upon to answer only for taking the log there described. In our judgment, therefore, the jury were erroneously instructed that the marks might be rejected as surplusage, and the exceptions are accordingly sustained. I also cite the case of the State against Clark, 3 Foster, New Hampshire, 429. Indictment for fraudulently altering the assignment of a mortgage. The indictment set forth the mortgage, and also the assignment, as it was alleged to have been originally made from Miles Burnham to Noah Clark, the respondent, and alleged that the assignment was signed, sealed, delivered, witnessed by 2 witnesses, and duly and legally recorded at length in the Registry of Deeds of Rockingham County on the 18th of September, 1844. It then alleged that this assignment was fraudulently altered on the 28th of June, 1844, by inserting the letter S in 2 places, between the words Noah and Clark, so that the assignment originally made to Noah Clark, after the alteration appeared as if it were made to Noah S. Clark. On trial the records of deeds were produced, and there was found a record of the assignment purporting to be made to Noah S. Clark, the record bearing date September 18, 1844, but there was no record of any assignment to Noah Clark. The respondent's counsel objected that this evidence did not support the allegations of the indictment. The forgery was alleged to have been committed on the 28th of June, 1844, and the court admitted evidence that Miles Burnham, who executed the assignment, being applied to about the 30th of July, 1846, for a loan of money upon a mortgage of the same property, declined to make the loan unless he was satisfied there was no mortgage of conveyance of the land by Noah Clark, and the person who drew the assignment searched the records with Burnham and found no such deed on record. This evidence was objected to, but was understood to be introductory to other material and pertinent evidence, and was therefore admitted, but no such other evidence, to which it was introductory, was offered. The jury found a verdict of guilty, which the defendant moved to set aside. Upon that, the court says, "We are not able to look upon this statement that the deed was duly recorded as well as witnessed and acknowledged, according to the statute, in any other light than as part of the description of the deed and conveyance which the defendant was charged with altering. We are, therefore, of opinion that the evidence upon this point did not sustain the indictment." Now, if the statement that the mortgage was recorded was such a material part of the description that a failure to prove the record as charged was fatal, so I say, in these overt acts, if they charge that a thing was done or a paper filed on a certain day, and it turns out not to be so, that is a fatal variance, and under that description in the indictment the charge cannot be substantiated. I refer to the case against Northumberland, 46 New Hampshire, 158, and also to the King against Wennard, 6 Carrington and Payne, 586. Clark v. Commonwealth, 16b, Monroe, 213. The doctrine seems to have been well settled in England and this country that in criminal cases, although words merely formal in their character may be treated as surplusage and rejected as such, a descriptive averment in an indictment must be proved as laid, and no allegation, whether it be necessary or unnecessary, more or less particular, which is descriptive of the identity of what is legally essential to the charge in the indictment, can be rejected as surplusage. And in this case I cite Dorset's case, 5th Rogers Record, 77. On an indictment for coining, there was an alleged possession of a die made of iron and steel, when in fact it was made of zinc and antimony. The variance was deemed fatal. And yet it was not necessary to state of what the die was made. If the indictment had simply said he had in his possession this die, it would have been enough. But the pleader went on and described it, saying it was made of iron and steel. It turned out upon the trial that it was made of zinc and antimony, and the variance was held to be fatal. So I cite the court to Wharton's American Criminal Law, 3rd edition, page 291, and to Roscoe on Criminal Evidence, 151. Now I cite the case of the United States against Foy, 1st Curtis's Circuit Court Reports, 368, and I do not think it will be easy to find a case going any further than this. It goes on to the end of the road. A letter containing money deposited in the mail for the purpose of ascertaining whether its contents were stolen on a particular route and actually sent on a post route is a letter intended to be sent by post within the meaning of the Post Office Act. This, I understand, was a decoy letter. The description of the termini between which the letter was intended to be sent by post cannot be rejected as surplusage, but must be proved as laid. Upon that, the Court says, "But a far more difficult question arises under the other part of the objection. The indictment alleges not only that this letter was intended to be conveyed by post, but describes where it was to be conveyed. It fixes the termini as Georgetown and Ipswich. The allegation is, in substance, that the letter was intended to be conveyed by post from Georgetown to Ipswich. The question is, whether the words from Georgetown to Ipswich can be treated as surplusage. It was necessary to allege that the letter was intended to be conveyed by post. The words from Georgetown to Ipswich are descriptive of this intent. They described more particularly that intent which it was necessary to allege. In United States v. Howard, 3 Sumner, 15, Mr. Justice Story lays down the following rule, which we consider to be correct. No allegation, whether it be necessary or unnecessary, whether it be more or less particular, which is descriptive of the identity of that which is legally essential to the charge in the indictment, can ever be rejected as surplusage. Apply that rule to this case. It is legally essential to the charge to allege some intent to have the letter conveyed somewhere by post. Suppose the indictment had alleged an intent to have it conveyed between two places where no post office existed, and over a post route where no post road was established by law. Inasmuch as the Court must take notice of the laws establishing post offices and post roads, the indictment would then have been bad, because this necessary allegation would, on its face, have been false. Words, therefore, which describe the termini and the route, and thus show what in particular was intended, do identify the intent, and show it to be such an intent as was capable in point of law of existing. And we are obliged to conclude that they cannot be treated as surplusage, and must be proved substantially as laid. We are of opinion, therefore, that there was a variance between the indictment and the proof, and that for this cause a new trial should be granted. So I refer to the State v. Langley, 34th New Hampshire, 530. The Court. I think, Colonel Ingersoll, there is no doubt about this doctrine. Mr. Ingersoll. I do not want any doubt about it. The Court. There cannot be. Mr. Ingersoll. Well, I will just read this because I do not want any doubt about it in anybody's mind. The Court. I have no doubt about it. Mr. Ingersoll. Very well. If a recovery is to be had, it must be secundum allegata et probata, and the rule is one of entire inflexibility in respect to all such descriptive averments of material matters. The cases upon this point, many of which are collected in the case of State v. Kopp, 15 New Hampshire, 2F5, are quite uniform. Now, if the Court please, I not only read this with regard to the overt acts, but with regard to the description of the crime itself, the conspiracy. I will then refer to State against Kopp, 15th New Hampshire. I will also refer to the case of Rex against Whelpley, 4th Carrington and Payne, 132, to 3rd Starkey on evidence, sections 1542 to 1544, inclusive. Also to the United States against Denis and others, 3rd Wood, page 48, and a case under this exact section, 5440. It seems clear that the statute upon which this indictment is based is not intended to relieve the pleader from any supposed necessity of setting out the means agreed upon to carry out the conspiracy by requiring him to aver some overt act done in pursuance of the conspiracy, and make such act a necessary ingredient of the offense. The Court then refers to the Commonwealth against Shedd, 7th Cushing, 514, and continues. In that case it was different. That difficulty does not exist here, for the overt act is part of the offense, and must be proved as laid in the indictment. So I find that the Court passed upon this very question, and I wish to call the attention of the Court again to one line on page 961 of the record in this case. But in all cases the principle is simply this, that where the act which was done in pursuance of the conspiracy is described in the indictment, it must be described with accuracy and completeness, and if there is a variance in the proof, it is fatal to the prosecution. When I come to that part as to the necessity of describing offenses, then I will cite the Court to some other authorities in connection with these. Now, then, we have got it established, gentlemen of the jury. There is no longer any doubt about that law, and the Court will so instruct you that wherever they set out in the indictment that we did a certain thing in pursuance of the conspiracy, they must prove that thing precisely as charged, no matter whether the description was necessary or unnecessary. They must prove precisely as they state. They wrote the indictment, and they wrote it knowing they must prove it, and if they wrote it badly, it is not the business of this jury to help them out of that dilemma. Now, as I say, we come to the dust and ashes of this case, the overt acts, and I take up these routes precisely in the order in which they were proved by the prosecution. First, I take up route 34149. Now, let us see where we are. The first charge is that we filed false and altered petitions by Peck, Minor, Vail, and Rirdell. When did we file them? The indictment charges that we filed them on the 10th day of July, 1879. When did the evidence show they were filed? On the 3rd day of April, 1878. That is a fatal variance, and that is the end eternal, everlasting of that overt act. Without taking into consideration the fact that every petition was true and genuine, the petitions were not sent by the persons as charged. It was presented by Senator Saunders, and that is the absolute end of that overt act, and you have no right to take it into consideration any more than if nothing had been said upon the subject. Second, that on the 10th of July a false oath was placed upon the records. Now, that is an overt act, and you know as well as I do that the description of that must be perfect. If they say it is one date and the evidence shows that it is of another, it is of no use. It is gone. They say then that a false oath was filed. When? On the 10th day of July. Suppose the oath to have been false. When was it filed? The evidence says April 3rd, 1879. That is the end of the false oath, no matter whether that oath is good or bad, no matter whether they committed perjury or wrote it with perfect and absolute honesty, it is utterly and entirely worthless as an overt act. Third, an order for expedition, July 10, 1879, alleged to have been made by Brady. As a matter of fact, the order was signed by French. There is a misdescription. No matter if Brady told him to sign it, It was not a matter of fact signed by Brady. It was signed by French. They described it as an order signed by Brady. It is an order signed by French, and the misdescription of variance is absolutely fatal, and you have no more right to consider it than you have the decree of some empire long since vanished from the earth. Now, this is all the evidence on this route. That is all of it, with the exception of who received the money, and I will come to that after a while. That is Route 34149. According to their statement in the indictment, holding them by that, there is not the slightest testimony. We can consider that route out. We have only 18 now to look after. That is the end of that. It has not a solitary prop. Upon the roof of that route, not a shingle is left, not one. End of Ingersoll's closing address to the jury in the first Star Route trial, Part 1 of 7. Read by Roger Melin. Chapter 2, Part 2 of the Works of Robert G. Ingersoll, Volume 10. Ingersoll's closing address to the jury in the first Star Route trial, Part 2 of 7. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Part 2. Let us take the next route, 38135. What do we do in that, according to the indictment? And now, gentlemen, recollect, they wrote this indictment. You would think we did, but we didn't. They wrote it, and they are bound by it. But if I had been employed on behalf of the defendants to write it, I should have written it just in that way. First, sending and filing a false oath. When did we send it? When did we file it? On the 26th day of June. That is what the indictment says. What does the evidence say? April 18th, 1879. Now, that is the end of that. It was a true oath, but that does not make any difference. That oath is gone. That has been sworn out of the case and dated out of the case. What is the next? Second, filing false petitions. When did we file them? The 26th day of June, 1879. The last petition was filed the 8th of May, 1879, and it does not make one particle of difference whether these dates were before or after the conspiracy as set forth, but, as a matter of fact, every one of the petitions was true. That charge is gone, a fatal variance. What is the next fraudulent order? That of June 20th. There was never the slightest evidence introduced to show that it was a fraudulent order, not the slightest. And what is the next charge? Fraudulently filing a subcontract. And right here I stop to ask the court, of course not expecting an answer now, but in the charge to the jury, is it possible to defraud the government of the United States by filing a subcontract? Now, gentlemen, I want you to think of it. How would you go to work to defraud the government by filing a subcontract? If the subcontract provides for a greater amount of pay than the government is giving the original contractor, the government will not pay it. It will only pay up to the amount that it agreed to pay the contractor. It is like A giving an order to B to pay C what A owes B. He need not pay him any more. That is all. And if the ingenuity of malice can think of a way by which the government could be defrauded by the filing of a subcontract, I will abandon the case. It is an impossible, absurd charge, something that never happened and never will happen. Well, that is the end of this route, with one exception. This is the agate route. This is the route where $30, it is claimed, has been taken from the government. It is that route. You remember the productiveness of that post office. They established an office, and nobody found it out except the fellow that was postmaster. And in his lonely grandeur, I think he remained about 18 months, and never sold a stamp. That is all that is left in that route, that order putting agate upon the route and taking it off, and then giving 1 month's extra pay. That is all. Another child washed. 38135. That is all there is to that route. No evidence except epithets. No testimony except abuse. If anything is left under that, it is simply robber, thief, pickpocket. That is all. Now we come to another route, and I again beg pardon for calling attention to these little things. The government has forced us to do it. It is like a lawsuit among neighbors. Each is so anxious to beat the other, they begin to charge for things that they never dreamed of at the time they were delivered. They will charge for neighborly acts, time lost in attending the funeral of members of each other's family before they get through the lawsuit. So the government started out in this case, and not finding a great point, had to put it in little ones, and we have to answer the kind of points they make. 41119. Overt acts. First, filing a false oath. When did we file it? The 25th day of June, the indictment says. Who filed it? Peck and Minor. Well, when was it filed, or when was it transmitted? According to their story, June 23, 1879. This oath is marked 8C, and an effort was made to prove by a man by the name of Blois that it was a forgery. That was objected to, first, that it was not charged to be forged in the indictment, and second, that a notary public had already sworn that it was genuine, and that he could not be impeached in that way, and thereupon that oath was withdrawn, and you will never hear of it any more. I do not know whether it is true or not. That is found on record, page 1469. Now recollect that oath was withdrawn. That is the end of it. Second, filing false petitions. When were they filed? July 8, 1879, and it turned out that the charge was true, with 2 exceptions. First, that they were not filed at that time, and second, that all the petitions were true. That is the only harm about that charge. Third, a fraudulent order made by Brady, July 8th. Now let us see what the fraud consists in. The fraud is claimed to be in expediting to 33 hours when the petition only called for 48. You remember the charge expediting to 33 hours when the petition only called for 48? Now let us see. It is claimed that to grant more than the petitions ask is a crime. Certainly it must be admitted that to grant less is equally a crime. The only evidence now of fraud in this is that he was asked to expedite the 48 hours, but he expedited to 33. That is to say, he violated the petitions, and if that is good doctrine, then the petitions must settle whether expedition is to be granted or not. If that is good doctrine, there is no appeal from the petition. I do not believe that doctrine, gentlemen. I believe it is the business of the Post Office Department to grant all the facilities to the people of the United States that the people need. He must get his information from the people and from the representatives of the people, and while he is not bound to give all they ask, If he does give what the people want, and what their representatives endorse, you cannot twist or torture it into a crime. That is what I insist. Now, the only charge is here, and while they asked for 48 hours, he gave 33. That is the only crime. Did he pay too much for it? There is no evidence of it. Before I get through, I will show you that there is no evidence that he ever paid $1 too much for any service whatever. Now then, if the doctrine contended for by the government is correct, then a petition is the standard of duty and the warrant of action, and if they gain upon this route, they lose upon every other route. Let us examine. There are 3 charges. First, false petitions. They were all true. Second, false oaths. They offered to prove it, and then withdrew it. Third, that while the petitions called for 48 hours, he granted 33, and before you can find that that was fraudulent, you must understand the precise connections that this mail made with all others, and it was incumbent upon them to prove, not an inference, but a fact, that there was not only reason, but reason in money, sound reason for expediting it instead of 48 to 33. That is the end of that route. There is not a jury on earth, let it be summoned by prejudice and presided over by ignorance, that would find a verdict of guilty upon the testimony in that route. It is impossible. Another child gone. 44155. Let us see what we get there, and I have not got to my client yet. First, filing false petitions by Peck, Minor, Vail, and Rudell. When? On the 27th of June, 1879. Were they false? Let us see. Mr. Bliss, speaking of these petitions contained in a jacket held in his hand, dated the 29th of June, 1879, record, page 687, said, quote, "We do not attack the genuineness of these petitions." End quote. That is the end of that. So much for that. Second, a fraudulent order increasing service, and yet all the petitions are admitted to be genuine, and the order was in accordance with the petitions on the route. Before, the order was fraudulent because it was not in accordance with the petitions, and in this route it is a fraud because it is in accordance with the petitions. Now, just take it. Here is the route. Every petition is genuine. The oath is true. Not a petition attacked. The order in accordance therewith, and the only evidence that the order is a fraud is that it was in accordance with genuine petitions recommended by the people and by the representatives of the people. That is all. Let me tell you another thing. Expedition had been granted on the route long before, and this was simply an increase of trips, and no charge was made that the order granting the expedition ever was a fraud. Third, another fraudulent order by Brady of April 17, 1880, and it turns out that this order was in fact made by French. That was the only evidence that it was fraudulent, but the mere fact that French made it takes it out of the case, and you have no more right to consider it than you would an order made in the Treasury Department. The only objection to this order now is what? That it was in violation of the petitions. How? That it took off 1 or 2 of the trips. That was the fraud of the order of April 17, 1880. The fraud consisted in taking off 2 or 3 trips that had been put on. Now, let us see. The next fraudulent order was July 16, 1880. What was that for? for putting the service back precisely as it was. Now, I want you, gentlemen, to understand that, every one of you. Here is a charge in the indictment of a fraudulent order that took off, say, 2 trips from the service. That is a fraud, they say. Then the next order put those 2 trips back, and that, they say, is another fraud. It would have been very hard to have made an order in that case to have satisfied the government. It was an order to decrease it. It was an order to put it back where it was. That is, it was a fraud. Consequently, it was a fraud to do anything about it. That is all there is in that case. Let us boil it down. False petitions. That is the charge. The evidence is that the petitions are all true. A false oath is the charge. The evidence is that the oath is true. A fraudulent order decreasing the service, another fraudulent order increasing the service, that is, leaving it just where he found it. In other words, according to this indictment, Brady committed a fraud in reducing the trips and another fraud by putting the trips back. I think it was only 1 trip that he reduced. Now, that is all there is in that case. People may talk about it one day or 1 year. That is all there is, and that is nothing. 38145. Fraudulently filing what? A subcontract with J. L. Sanderson. I say you cannot fraudulently file a subcontract against the government. It is an impossibility. Besides all that, Mr. Sanderson filed his own subcontract. There is no evidence that anybody else did file it or present it for filing. It was not our contract. It was Sanderson's subcontract. How comes that in this indictment? Let me tell you. In the first indictment, they had Sanderson, and when they copied that first indictment, with certain variations to make this, they forgot this part and put in the fraudulent filing of Sanderson's contract. It never should have been in this case. It has not the slightest relationship. The real charge of fraud in this route is that a retrospective order was made, and this order bore date February 26, 1881, and was retrospective in this, that it was to take effect from the 15th of January, 1881. But understand me, this was Sanderson's route. He received that money, and it has nothing to do with us. Still, I will answer it. That retrospective order gave pay from the 15th of January, 1881. Now, it seems that before the order of February 26, an order had been made by telegraph, dated 15th of January, 1881, to Sanderson, and this telegraphic order was for daily service on 89 miles. The jacket order of February 26, 1881, was for daily service on the whole route from January 15, 1881. If that order had been carried out, he would have received pay for daily service on the whole route instead of for daily service on the 89 miles to which he was entitled. It turned out that the order of February 26, 1881, was signed by Postmaster General Maynard. The only possible charge is that Sanderson received pay for a daily service on the whole route from January 15, 1881 to February 26, 1881, instead of 89 miles. But we find in the table of payments introduced by the government that for that quarter a deduction was made of $3,422.19, showing that the department could only have paid for the daily service on the 89 miles, and that is exactly what the daily service would come to on the balance of the route. That ends that route. We had nothing to do with it anyway. It was Sanderson, He filed his own contract. He got his own orders. He collected his own money and settled with the department. We have nothing to do with it, and we will bid it farewell. The next is number 38156. First, filing false oath, June 12, 1879. The oath was filed May 6, 1879. That is the end of that. I do not care whether it is true or false, that is, so far as this verdict is concerned. I care whether it is true or false so far as my clients are concerned, but so far as this verdict is concerned, it makes no difference. There is a fatal variance. Second, it is alleged that Brady made a fraudulent order June 12, 1879. The order of June 12, 1879, was made by French. There is another fatal variance. You have no right to take it into consideration. French is not one of the parties here. Third, sending a subcontract of Dorsey and filing it. As I told you before, you cannot by any possibility thus defraud the government, not even if you set up nights to think about it. There is no proof that the subcontract was a fraud. Let us have some sense. It is an absolute impossibility to commit this offense, and therefore we will talk no more about it. Fourth, the fraudulent order of Brady increasing the distance 4 miles. This was done on the 20th of December, 1880. That is the only real charge in this route. I turn to the record and find from the evidence, on page 943, that the distance was from 5 to 6 miles, according to the government's own proof. Beside all that, the order of which they complain is not in the record. It was never proved by the government, and never offered by the government, so far as I can find. That is the end of that route. The only charge in it is that they increased the distance 4 miles, and the evidence of the government is that it was from 5 to 6. The next is 46132. Overt acts. Filing a false oath by everybody, June 24, 1879. The evidence shows it was filed April 11, 1879. That is the end of that. No matter whether it is true or false, it is gone. Second, the fraudulent filing of a subcontract. Well, I have shown you that that cannot be fraudulent. The subcontract of Vail shows that Vail was to receive 100%. It was executed April 1, 1878, in consequence, as my friend General Henkel explained, of a conspiracy made on the 23rd of May following. The service commenced July 1, 1878. There could have been no fraud in it. It was filed, as a matter of fact, May 24, 1879, and not June 4th. Even if it had been a fraud, which is an impossibility, the description is wrong, and the variance is fatal. There is no evidence that any order was fraudulent. Every one in this case is supported by petitions, and every petition is admitted to be honest, or proved to be honest and genuine. There is no proof at all, and not the slightest attempt on the part of the government to prove that there was any fraud on this route. So much for that. Number 46247. Let us see just where we are. First, filing false and forged petitions. When? July 26, 1879. By whom? By Peck, Dorsey, and Riddell. Now, after they had solemnly written that in the indictment, and after it had been solemnly found to be fact by the grand jury, the attorneys for the government came into court and admit during the trial that all the petitions upon this route were genuine. Every one. It was admitted, I say, that every petition was genuine. Read from page 1008 of the record, and there you will find what the court said about these very petitions. Quote, "I shall take the responsibility of dispensing with the reading of petitions when there is no point made with regard to them." End quote. The petitions were so good, they were so honest, they were so genuine, they were so sensible, that the curiosity of the court was aroused to find what on earth they were being read for on the part of the prosecution. You remember it. Every one, genuine, honor, bright, from the first line to the last. In reply to the court at that time, Mr. Bliss said, quote, "There is no point made as to the increase of trips. These," meaning the petitions, "relate to the increase of trips. There is no point made there." End quote. It is thus admitted that every petition was genuine. Second, a fraudulent order increasing one trip. This order was never proved by the government. It was not even offered by the government, so that the route stands in this way. First, a charge of false petitions. Second, an admission that the petitions were all genuine. Third, a charge that a fraudulent order was made. Fourth, no proof that the order was made. That is all there is to that, and that is the end of it. Number 38134. First, sending false and fraudulent petitions and filing the same. When? July 8, 1879. On page 1031 of the record I find the following. Quote, "Mr. Bliss, the petitions under your Honor's ruling I am not going to offer." End quote. Why? Because they were all genuine. The court had mildly suggested the impropriety of the government proving its case by reading honest petitions. Consequently, when it came to this, the next route, he said, quote, "The petitions under your Honor's ruling I am not going to offer." End quote. Why? Because they are all honest, and under a charge in the indictment that they are all fraudulent, he did not see the propriety of reading them. That is what he meant. This remark was made because the government admitted these petitions to be honest. When were these petitions filed? The indictment says July 8. The evidence says May 6. So that if every petition had been a forgery, you could not take them into consideration on this route. It is charged that Miner and Company signed and placed in Brady's office a false oath on July 8th. On record, page 1032, it appears that it was filed May 8, 1879, and not as described in the indictment. The pleader has the privilege of describing it right or describing it wrong. If he describes it right, it can go in evidence. If he describes it wrong, it cannot go in evidence, and they have no right to complain if you throw out evidence that they make it impossible for you to receive. It has been charged with regard to this affidavit that Dorsey was not at that time contractor, and therefore had no right to make the affidavit. The affidavit was made April 21, 1879, and the regulation that such affidavits must be made by the contractors was made July 1, 1879. That is a sufficient answer. The next charge is a fraudulent order made by Brady, July 8. The petitions were all admitted to be genuine. There was no evidence that the order was not asked for by the petitions. There was no evidence that the order in and of itself was fraudulent, not the slightest. There is nothing like taking these things up as we go and seeing what the government has established. I know that you want to know exactly what has been done in this case, and you want to find a verdict in accordance with the evidence. Route 38140. Overt Acts. First, making, sending, and filing false petitions. When were they made and sent? The 23rd day of May, 1879. There were some petitions filed May 10, 1879, and there was a letter of the same date. They are misdescribed. They are all genuine, but they are out of the case as far as this is concerned. I will tell you after a while where they are applicable in this case. A letter of Belford of April 29, 1879, and a letter of Senator Chaffee of April 24, 1879, we have, while the indictment charges that they were all filed May 23, 1879. There is an absolute and fatal variance. All these petitions, however, are admitted to be genuine and honest. See Records, pages 1001 to 1003. The charge in the indictment is that they were forged, false, and altered. The admission in open court by the representatives of the government is that they were genuine and honest. There is the difference between an indictment and testimony. There is the difference between public rumor and fact. There is the difference between the press and the evidence. The next is that a false oath was filed by John W. Dorsey on the 23rd of May, 1879. When was that oath filed? April 30th, 1879. A fatal variance. Yet the man who wrote the indictment had the affidavit before him. Why did he not put in the true date? I will tell you after a while. Did he know it was not true when he put it in the indictment? He did, undoubtedly. Third, fraudulent order of May 23rd, reducing the time from 19 3/4 hours to 12 hours. As a matter of fact, no order was made on the 23rd of May upon this route. It is charged in the indictment that it was made on the 23rd of May. The evidence shows that it was on the 9th of May. There is a fatal variance, and that order cannot be considered by this jury as to this branch of the case. Here is an order of which they complain. They charge that it was made on the 23rd day of May, the same day the conspiracy was entered into. As a matter of fact, it was made on the 9th of May. On this description it goes out, and it goes out on a still higher principle, that an order could not have been made on the 9th of May in pursuance of a conspiracy made on the 23rd of that month. But I am speaking now simply as to the description of this offense. Fourth, a subcontract was fraudulently filed. I have shown you it is impossible to fraudulently file a contract. Utterly impossible. All the agreements imaginable between the contractor and the subcontractor cannot even tend to defraud the government of a solitary dollar. I make a bid, and the contract is awarded to me at so much. The mail has to be carried. The government pays, say, $5,000 a year. It makes no difference to the government who carries the mail under that contract, so long as it is carried. It is utterly impossible to defraud the government by contracting with A, B, C, or D. That is the end of that route. The order itself is misdescribed, and that is all there is in it. When the order is gone, everything is gone. Number 38113. Overt acts, fraudulently filing a subcontract. We do not need to talk about that any more. Second, Brady fraudulently made an order for increase of trips. The evidence is that an increase was asked for by a great many officers, a great many representatives, and by hundreds of citizens, and that the increase was insisted upon not only by the officers who were upon the ground, but by General Sherman himself. I do not know how it is with you, but with me, General Sherman's opinion would have great weight. He is a man capable of controlling hundreds of thousands of men in the field, a man with the genius, with the talent, with the courage, and with the intrepidity to win the greatest victories, and to carry on the greatest possible military operations. I would have nearly as much confidence in his opinion as I would in the guess of this prosecution. In my judgment, I would think as much of his opinion given freely as I would of the opinion of a lawyer who was paid for giving it. General Sherman has been spoken of slightingly in this case, but he will be remembered a long time after this case is forgotten, after all the engaged in it are forgotten, and even after this indictment shall have passed from the memory of man. Number 38152. Overt acts. Fraudulent orders of August 3, 1880, discontinuing the service and allowing a month's extra pay for the service discontinued. That is all. May it please your Honor, in this route the only point is, had the Postmaster General the right to discontinue the service? And if he did discontinue it, was he under any obligation to allow a month's extra pay? It is the only question. I call your Honor's attention to the case of the United States against Reside, 8 Wallace, 38. Fullenwider against the United States, 9 Court of Claims, 403, and Garfield against the United States, 3 Otto, 242. In those cases, it is decided not only that the Postmaster General has the right to allow this month's extra pay, but he must do it. That is in full settlement of all the damages that the contractor may have sustained. The court can see the very foundation of that law. For illustration, I bid upon a route of 1,000 miles. I am supposed to get ready to carry the mail. 500 miles are taken from that route. The law steps in and says that for that damage I shall have 1 month's extra pay on the portion of the route discontinued. It makes no difference whether I have made any preparation or not. The law gives me that and no more. If I should go into the Supreme Court and say that my preparations had cost me $50,000, and the month's extra pay was only $5,000, I have no redress for the other $45,000. That is all that is charged in this instance, and if the second Assistant Postmaster General, or anyone else, has done differently, he would have acted contrary to law. He is indicted for doing in this case exactly what is in accordance with the law. Let us get to the next route. That is all there is in this. Number 38015. Overt acts. Sending a false oath. When? May 21. The evidence shows that on May 14 it was sent. On May 15 it was filed. A fatal variance, no matter whether it is true or false. The oath is gone. That is the end of it. What else? They did not show that the oath was false. First, it is misdescribed in the indictment as to the date it is filed. Second, the evidence shows that it is honest and genuine, which is also fatal. That is the end of this route, as far as the indictment is concerned. Second, that Dorsey made and Rerdell filed false petitions. There is no proof that any of the petitions were false, no proof that any were forged, and no proof that John W. Dorsey or M.C. Riddell had anything to do with that route one way or the other. All the petitions on record, page 1160, are admitted to be genuine except one. One petition asking for a 10-hour schedule was attacked, and only one. But this petition was filed May 14, 1879, and that is out so far as the indictment is concerned. The Court. What is the date of the indictment? Mr. Ingersoll. The 23rd day of May. The indictment says that this was filed July 10, 1879. The evidence says May 14, 1879. A fatal variance. It is not the same one they were talking about. They did not find the petition they described. It is their misfortune. Now, here is only one petition attacked. Who attacked it? Mr. Shaw. See page 1159. They were going to show that that was a forgery, and they were going to show it by Shaw. That was the only one they attacked. What does Shaw say? Quote, I signed a petition for increase of service and expedition upon that route, but I did not read the petition. If I had, I should have discovered a 10-hour schedule. End quote. He would not have discovered it if it had not been there, would he? That shows it was there. Quote, I would not have recommended a 10-hour schedule on a 70-mile route. End quote. He was the man that was going to prove that 10 hours was not there. But it shows that he was not able to do it, because he first swore that he never read it, and second, that he would not have signed it if he had. Goodbye, Mr. Shaw. That is all there is as to that matter. The court will understand I am going now upon what is in the indictment, and not what has been thrown in from the outside. The Court. I understand that. Mr. Ingersoll. I am going according to the strict letter of this indictment. I am holding these gentlemen to the law. That is what the law is for. You cannot come into this court and throw 7 or 8 cords of paper at a man and say, "You are guilty." They have managed this case after that fashion, but I propose to bring them back to the law. Route 35051. First, signing, sending, and filing false petitions. When? August 2nd, 1879. There is no evidence of any petitions being filed on that day, none whatever. The only thing near it is a letter of Frederick Billings on record, page 1217. This letter was dated July 31st, 1879. Under the charge of signing, sending, and filing false petitions, the only evidence is that a man by the name of Billings wrote a letter, and there is not the slightest testimony to show that a solitary word in that letter was false, not one. Nothing to connect it with Mr. Billings. No evidence that he ever spoke to him on the subject. No evidence that Billings knew who was carrying the mail. No evidence that he ever knew or did a thing except to write that letter. And he was interested, I believe, in the Northern Pacific Railroad. Now, that is everything there is there. That is all there is in that case. Nobody has tried to show that the letter of Billings was not true. What else? A fraudulent order of August, 1879. Who made it? The indictment says Brady made it. The evidence says it was signed by French, and it was in accordance with Billings's letter. Is there any fraud now in that route? Let us be honest. False petitions. Not one filed. False oath? Not one attacked. Simply a letter that we did not write, and that there is no evidence that we ever asked to have written. That is the end of that, but they cannot even get the letter in, gentlemen. They did not describe it right. The next route is 40104. Overfacts. First, fraudulently filing a subcontract. That you cannot do. When did we file it? July 23rd, 1879, the indictment says. What does the evidence say? May 8th, 1879. First, we could not commit the offense. Secondly, you could not prove it under this description. Second, filing a false oath. When did we file it? July 23rd. That is what the indictment says. What does the evidence say? November 26, 1878. A fatal variance. See record, page 1305. That is the end of that. The indictment is for something. You have got to follow it, and it certainly is not as hard work to write an offense against a man as it is to prove it. If they cannot write an offense, you certainly ought not to find the man guilty. Besides all that, that oath was not even impeached. It was not ever attacked. There was not a word said upon the subject except in the indictment. It was charged to be false, and not one word of evidence was offered to this jury to show that it was false. Third, an alleged fraudulent order of increase by Brady, July 23, 1879. Brady never signed any such order. It was signed by French. That is the end of it, no matter whether it was good or bad, honest or dishonest. That is the end of it. And yet there is not a particle of evidence to show that it was dishonest. But you must hold them to their own case as they have written it, and not as they wish it was now. Fourth, a fraudulent order of April 10, 1880, allowing 1 month's extra pay on the service reduced. This order was not even proved by the government. As a matter of fact, it was not offered by the government, and if it had been offered, and if it had been proved, it would have only established the fact that Mr. Brady acted in accordance with law. End of Ingersoll's closing address to the jury in the first Star Route trial, Part 2 of 7. Read by Roger Melin. Chapter 2, Part 3 of the Works of Robert G. Ingersoll, Volume 10. Ingersoll's closing address to the jury in the first Star Route trial, Part 3 of 7. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Part 3. Now we come to some more. 44160. First, filing false petitions. When did we file them? July 16, 1880. The proof is that they were filed long before that time. The proof is that Peck, Dorsey, and Rudell had nothing to do with this route after the 1st of April, 1879, and the petition claimed to be signed by Utah people and claimed to be fraudulent in the petition marked 19Q. It was filed on the 7th day of May, 1879. That is a fatal variance. This indictment charges it was filed July 16, 1880. The petition cannot be considered. There is another petition marked 20Q, claimed to have been written by Minor, upon which the name of Hall is said to have been forged. It has no file mark whatever, and consequently cannot be the petition referred to in the indictment that was filed. That, however, has been explained by General Henkel fully. This petition was identified by McBean, and was signed by him, and he recognized the signatures of many of the citizens of Cañon City. Mr. Merrick admitted that the petition 19Q was never acted upon. As a matter of fact, orders had been made before the petition was received, which shows conclusively that they were not acted upon. The petition marked 20Q, to which Hall's name was, as is claimed, forged, was never filed, and was consequently never acted upon. This charge stands as follows: 2 petitions, one being filed May 17, 1879, a fatal variance, and the other not filed, another fatal variance. These petitions are both described as having been filed July 16, 1880. The variance is absolutely fatal, and these petitions cannot be considered. Besides, the order was made before the petition 19Q was filed. Second, the fraudulent order by Brady for increase of trips, July 16, 1880. The only objection to this route is that the expedition was made before service was put on. This was in the power of the Postmaster General. It has been done many times, and is still being done by the Post Office Department, and the fact that it was done in this case does not even tend to show that any fraud was committed or intended. That is all there is in that case. The petitions were never acted upon. One was never filed, and the other is not described, or rather is misdescribed. Route 48150. Overt acts. A fraudulent order by Brady reducing service to 3 trips a week and allowing a month's pay on service dispensed with July 26, 1880. This point, gentlemen, I have already argued. Whenever the Post Office Department dispenses with any service, it is bound to give 1 month's extra pay any time after the contract has been made and any time after the bid has been accepted. It is bound to give the month's extra pay on the service dispensed with, and this question, as you heard me say a little while ago, has been decided by the Supreme Court in Garfield's case. This route was operated by Sanderson. He was the subcontractor, and according to the subcontract filed and presented here in evidence, he received every cent of the pay. We could have had no interest in perpetrating any fraud upon that route. Why? Because another man, J. L. Sanderson, received every dollar and we not 1 cent. Another fraudulent order of increase, August 24, from Powderhorn to Barnum, 7 miles. No fraud was shown, but the order in fact was made for the benefit of Sanderson, and not for the benefit of any of the defendants in this case. In other words, it was made for the benefit of the people. It was made because they wished to reach another post office. Another charge is that the subcontract made by Sanderson was filed September 18, 1878. Recollect the charge is about filing this subcontract. The fact is, it was filed in 1878 to take effect from July 1, 1878. See Record, page 1406. On this very route, the subcontract took effect the 1st of July, 1878, with Sanderson, and from that moment until now he has received every dollar. This route, as a matter of fact, is out of the scheme. Sanderson carried the mail from the 1st of July, 1878, until the end of that contract, the last day of June, 1882. So much for that route. It is gone. Nobody can get it back, either, in this scheme. Route 40113. Overt acts. Filing of a false oath. When? June 3, 1879. When was it filed? May 7, 1879. That oath is gone. Was it false? They did not attack it. They never impeached it. Good. Second, false petitions filed. When? June 3, 1879. All the petitions were filed prior to May 10, 1879. They are gone. One was filed May 23rd, but none was filed as alleged on June 3rd. They are gone. A magnificently written instrument. A fatal variance as to every petition, and yet not a solitary petition was attacked. Every petition was genuine and honest. Third, a fraudulent order by Brady for increase and expedition. This order was asked for by the petitions. No fraud was established. See record, page 1503 on this route, also page 2159. Fourth, they also charged that Brady made a fraudulent order on the 4th of January, 1881. But the government never proved that order, never offered any order of that date. That is the end of that order. Fifth, a fraudulent order of February 11, 1881. This was not offered by the government, and no evidence was offered as to the existence of the order, neither the jacket nor the order, nor the petitions, so far as I can find. That is the end of that. Every overt act so far, except some of the orders, wrong. The overt acts charged were filing fraudulent petitions. When? May 23, 1879. These are the petitions said to have been gotten up by Wilcox. Mr. Wilcox was a government witness, and he swore that every petition was honest, that every name was genuine, and that in order to get the names he did not circulate a falsehood, he circulated only the truth. To use his own language, quote, "I did only straightforward, honest work." End quote. That is all there is on that. 44140 is the number of this route, and this evidence is on record, page 1568. And in regard to getting up these petitions, you will recollect the language used by the court. His Honor said, in effect, clearly, quote, "Every man carrying the mail has the right to take care of his business. He has the right to get up petitions. He has the right to call the attention of the people to what he supposes to be their needs in that regard. He has the right to do it. And the fact that he does it is not the slightest evidence that he has conspired with any human being." End quote. Deny me the right to attend to my own affairs? If I have taken the route from the government, and contract to carry the mail, tell me that I cannot suggest to my fellow citizens that they ought to have daily mail instead of a weekly? Tell me that I have not the right to talk it on the corners, in every post office for which I start, and that if I do, I am liable to be pursued and convicted of an infamous offense? Every man has the right to attend to his own affairs, and he has the right to get all the people he can to help him. He has no right to go around lying about it, but he has the right to call their attention to the facts the same as you would have the right to get a road by your house. Just exactly the same as you would have the right to get a schoolhouse built in your district, no matter if you were to have the contract for making a brick. You have a right to say what you please in favor of education, no matter if you are an architect and expect to be employed to build the schoolhouse, and any other doctrine is infinitely absurd. There is another charge, that a false oath was filed on the 24th of May. The affidavit was made by Mr. Peck, and I believe it has been admitted that Mr. Peck never did anything wrong. Then there is alleged to be a fraudulent order for increase, signed June 26, and they never introduced the slightest evidence tending to show that there was fraud in the order. It was made in accordance with the petitions. It was made in accordance with what we believe to be the policy of the Post Office Department. And allow me to say to your honor that I think that the general policy of the Post Office Department, as disclosed in the documents that have been presented in the reports made to Congress that have become a part of this case, I think even from that evidence I have the right to draw an inference as to what the policy of the Department was. The Court: I have no doubt in the world as to the views of the Post Office Department in regard to that subject. The Court refused to receive evidence on that subject in defense, for the simple reason that the Court was of opinion that no second Assistant Postmaster General had the authority to establish any policy for this government or for any branch of this government. The policy of the government is to be found in its laws, and the Court was unwilling to allow a second Assistant Postmaster General to set up his policy in his defense against a charge in this Court. He had no right to have a policy. Mr. Ingersoll: We never set up the policy on the second assistant. We never asked to be allowed to prove the policy of the second assistant. We never imagined it, nor dreamed of it, nor heard of it until this moment. What we wanted to show was the policy, not of the second assistant, but of the Postmaster General. But I am not speaking now upon that branch. The Court: The Postmaster General, by law, is the head of the department, of course, but several assistants were given him by law, and he had the authority to apportion out the business of the department amongst those several assistants. The particular business of the department pertaining to the increase of service and expedition of routes belonged under this apportionment to the second Assistant Postmaster General. His acts, therefore, are to be looked to. Mr. Ingersoll: I do not claim, if the Court please, that his policy had anything to do with it. I simply claim that from the orders that have been introduced, not of the second assistant, from the books that have been introduced, showing the views of the Postmaster General, not of the second assistant. I also admit that if the Postmaster General had ordered by direct order the second Assistant Postmaster General to expedite every one of these routes, even then there could have been such a thing as a conspiracy to expedite them too greatly, and to receive money from every man for whom they were expedited. I understand that. But in the absence of any proof that it is so, all I have ever insisted was that the general policy of the head of the department might be followed by any subordinate officer without laying himself open to the charge that he had been purchased. That is all. Now, gentlemen, all these things had been asked. They had been earnestly solicited by hundreds of congressmen, by senators, by judges, by governors, by cabinet officers, and by hundreds and thousands of citizens. Now let me recapitulate all the overt acts, and I have gone over them all now excepting one, and I will come to that presently. In the indictment there are 12 charges as to filing false petitions. There are 10 charges as to false oaths. There are 7 charges as to fraudulently filing subcontracts, and the evidence is that the 10 oaths are substantially true, that it is impossible to fraudulently file a subcontract, and as to the petitions, that every one is absolutely genuine and honest, with the exception of 3. They prove that the words "Schedule 13 hours" were inserted. That is, they tried to prove that by Mr. Bois, who is an expert on handwriting, as has been demonstrated to you. One with 13 hours inserted in it, and the very next paragraph in that same petition begs for faster time. I have not the slightest idea that that ever was inserted by anybody. I believe it was in there when it was signed. And why? There would have been, there could have been, there can be no earthly reason for inserting those words. You cannot imagine a reason for it. Now, that is 13 hours. Then there is another one they say had some names of persons living in Utah, and we say that that is not described properly. Not only that, but that it was never acted upon, and in my judgment, that whole thing is a mistake and not a crime, because there were plenty of petitions without that. There was no need of it. All the other petitions have either been proved or have been admitted to be absolutely genuine. Now, I have gone over every overt act except payments, and when it was said here in court, or when the objection was made to these being proved as overt acts, the court will remember that again and again and again the prosecution denied that they were offered as overt acts. The Court: I never understood them as being offered as overt acts. Mr. Ingersoll: At that time the court made just the remark that your Honor has made now. He said, quote, "But what are the payments?" End quote. Now I will take up the payments, and we will see whether there are any overt acts in the payments, gentlemen. Now let me call your attention to that magnificent rule that has been laid down by the court. When you describe an offense, you are held by the description. When it is said that I made a false claim against the government in a conspiracy case, for instance, that I conspired to defraud the government, that I presented a false claim, it may be that the laxity or lenity of pleading might go the extent of saying that the pleader need not state the amount of that false claim, but if the pleader does state the amount of that false claim, he is bound by that statement. Now that is my doctrine. The Court: What I understand in regard to the evidence of the payments is this. The charge was a conspiracy to defraud, and the averment was that the fraud had been completed, and this evidence of payments was to show that the fraud had been carried out. Mr. Ingersoll: That is all. Now let us see if this can be tortured into an overt act. I now come to the presentation of false claims charged to have been presented and collected by these defendants. It is a short business. On the route from Kearney to Kent, the charge is that Peck and Vail presented false claims on the third quarter of 1879 for $550.72. The entire pay for that quarter, 3 trips and expedition, was $795.78, and there is no charge that the increase of trips was fraudulent. Only the expedition was attacked. The 3 trips, according to the old schedule price, came to $735.81, all of which was honestly carried, honestly earned. Now, deducting from the pay $795.78, the amount of the 3 trips on the old schedule honestly performed, $735.18, if the expedition was fraudulent, we have a fraudulent claim of $60.16. And yet the government charges that we made a claim of $550.72. Not 1 cent is allowed for carrying the 2 additional trips without expedition. There is another trouble about this. It is charged that Peck and Vail presented this claim for their benefit. The record, page 386, shows that Peck did not present this claim, that it was presented by H. M. Vail, that H. M. Vail received the warrant for the full amount, that he held a subcontract at that time for every dollar. This is another fatal variance, and the evidence of Vail is that every dollar belonged to him, that not a dollar of that money was ever paid to any other one of the defendants, that he paid all the expenses, that he paid the debts, and that there never went a solitary cent to any government official. So much for that payment. The next charge is that on Route 41119, from Tokerville to Adairville, Peck presented a false claim for the third quarter of 1879 for $2,460.14. The pay for that quarter was $3,628.14 for 7 trips and expedition. The pay for the 3 trips on the old schedule was $876, a difference of $2,752.14. And yet the government charges that the false claim presented was $2,460.14. If they give the figures, they must give them correctly. If I am charged with presenting a claim against the government for $2,460 that is not substantiated by showing that I presented a claim for $2,700, if you give the figures, you must stand by the figures, and you are bound by them. You cannot charge one thing and prove something else. This is a fatal variance. In addition to this fact, we find the deductions for failures in that very quarter amounted to $540.42, and this deducted from the other amount leaves $2,211.72, so that in both cases the variance is absolutely fatal. I am showing you these things, gentlemen, so that you may see that there is in this case no evidence to fit the charges in this indictment. 44140, Eugene City to Bridge Creek. It is charged that Peck and Dorsey presented a false account for the third quarter of 1879 for $4,783.99. The pay for 3 trips with expedition was $4,689.72. The pay for 1 trip on the old schedule was $617, a difference of $4,072.22. The government says the difference was $4,783.99, an absolutely fatal variance. Now, as a matter of fact, there were deductions in that quarter of $1,932.83, and this is deducted from the entire pay, leaving only as a claim $3,768.39. And yet the government charges that we presented a false claim for $4,783.49. It will not do. It is a fatal variance. But when we take into consideration that there is no claim that the increase of trips was fraudulent, only the expedition, and that by the old schedule 1 trip came to $617, that 3 trips came to $1,851, and that added to deductions would make $3,773.83, to be deducted from $4,689.22, it would leave as a fraudulent claim, even if their claim was true, $915.39. Now, the next is 44155, the Dallas to Baker City. The false claim was $8,896 by Peck. The pay per quarter was $16,666.09. The pay for 3 trips and expedition was $7,770, a difference of $8,896.09. But there were deductions, $99.34, leaving $8,796.75. But by making this claim, the government concedes that the expedition was legal, and another trouble is that the payment on this route was made to Vail, not to Peck or Miner. It was made to Vail, who was the subcontractor for the full amount, and this is another fatal variance. Now, Route 46132, Julian to Colton. The charge is that Peck and Vail presented a fraudulent claim for the third quarter of 1879 for $1,657.71. The pay for 3 trips and expedition is $1,954.71. For 3 trips in the old schedule, it was $891, a difference of $1,063.73. A fatal variance. Besides, it was not Peck and Vail. Vail was the subcontractor at full rates on this route. He presented the claim. He received the entire pay. Another variance. Route 44160, Canyon City to Camp McDermott. The charge is that Peck and Vail presented a false account for the fourth quarter of 1879 for $11,819.66. It is charged in the indictment that this was paid in pursuance of the order set out in the indictment, and we find on page 64 that the order was dated July 16, 1880. That was the order. No such payment was made in pursuance of that order for the reason that an order was made nearly a year afterwards, and the order of July 16, 1880, as set out in the indictment, was not retrospective, a fatal mistake in their indictment. As a matter of fact, the pay for the fourth quarter of 1879 was $5,375. There were deductions to the amount of $352.72, and the balance was $5,022.28, instead of $11,819.66. And this was paid to Vail, who was a subcontractor at full rates, and the variance in the case is absurd and fatal. Route 46247, Reading to Alturas. The charge is that Peck and Dorsey filed a fraudulent account for the third quarter of 1879 for $7,485.06. This was in pursuance of the order set out in the indictment, and the only order set out in the indictment is dated February 11, 1881. This is another fatal variance. The next route is 35051, Bismarck to Miles City. The charge is that Miner and Vail presented a false account for the fourth quarter of 1879 for $14,100. The pay for the quarter for 6 trips was $17,500. For 3 trips under the old order, the pay was $8,750, leaving $8,750 at the outside sum that could have been fraudulent, and yet the government charges $14,100, an absolutely fatal variance. Besides that, there were deductions in that very quarter of $4,503. This amount deducted from $8,750 leaves $4,256.11 as the greatest amount that could by any possibility have been fraudulent. 3 routes are lumped together next in the indictment: 38134, 38135, 38140, 38134, Pueblo to Rosita. 38135 Pueblo to Greenhorn, and 38140 Trinidad to Madison. The charge here is on page 81 of the indictment that Miner presented a fraudulent account for the fourth quarter of 1879 on routes amounting to $2,776.47. The greatest possible difference that could be made on Route 38135 is $777.20. The greatest difference that could be made on Route 38134 is $1,940. The greatest difference that could be made on Route 38140 is $689.51. These three differences added together do not make what is charged in the indictment $3,776.47, but as a matter of fact, they amount to $3,396.71. This cannot be the fraudulent claim described in the indictment. But I find that on the first route there was a reduction of $12.60, on the second route of $154.38, and on the third of $38.02. And these deductions added together make $205.90, and deducted from the $3,396.71 leaves $3,190.81. And yet the government charges that the fraudulent claim was $2,776.47. It is impossible that the amount of the claim said to be fraudulent by the government can be correct. But as a matter of fact, according to the evidence, there was no fraud upon any claim in that route. The next is Route 38150, Sagosh to Lake City. The charge is that Miner presented a false account for $2,202.77, and that he did this in pursuance of the order set out in the indictment, and the only order set out is dated August 24, 1880. That is an absolutely fatal variance. As a matter of fact, Sanderson was a subcontractor on this route from July 1, 1878, at full rates, and he carried the mail from July 1, 1878. The route was expedited on his oath and for his benefit. No point was made during the trial that the oath was not true, and the pay was calculated upon Sanderson's oath, and the money paid to him. The only claim is that there was an error in the order of $4,568 per year, and it is admitted that the mistake was afterwards corrected and the money refunded. You remember it, gentlemen. Mr. Turner, in making up the account, showing how much the expedition would come to, and you understand the way in which they make up that expedition, made a mistake and added to the expedition and the then schedule the amount of the then schedule, $4,000 and odd dollars. He made the mistake, and it was honestly made. No man would dishonestly do it because it was so easy of detection, and that was his only fault, gentlemen. The only crime he ever committed in this case was to make that mistake. That mistake was afterwards discovered, and the money was paid back by Mr. Sanderson. And yet that man has been indicted, has been taken from his home charged with a crime. He has been pursued as though he were a wild beast. He made one mistake. They could not prove the slightest thing against him. There was no evidence touching him. There was only one way for them, and that was to dismiss him with an insult. You remember the case. Not one thing against that man, not one single thing. He stands as clear of any charge in this indictment as anyone upon this jury. He is an honest man. It is admitted now that there was no conspiracy on this route either. It is Sanderson's route, not ours. Not only that, but the government says that it was not one of the routes with which Vail had anything to do, or in which Vail had any possible interest. The failure here is fatal to the indictment, and I shall endeavor to show that it is fatal to the entire case. The next route is 35105, Vermilion to Sioux Falls. It is charged that Vail and Dorsey presented a false account for the third quarter of 1879 for $881.14. The pay for 6 trips and expedition was $1,085.58. The pay for 2 trips on the old schedule was $204.44, showing a balance for once, as stated in the indictment, it being the only time, of $881.14. Parties are entitled to pay for the extra trips, and the number of men and horses has nothing to do with the value of an extra trip. You understand that. If I agree to carry the mail once a week for $5,000 a quarter, and you wanted me to carry it twice a week, then I get $10,000 a quarter, no matter if I do it with the same horses and the same men. That is not the government's business. You all understand that, do you not? Every time you increase a trip, you increase the pay to the exact extent of that trip, no matter whether it takes more horses or not. If I agree to carry the mail once a month for $5,000 a year, and you want me to carry it once a week, I am entitled to $20,000, no matter if I do it with all the same men and same horses. It is nobody's business. But if the government wants the mail carried faster, then I am entitled to pay according to the men and animals required at a more rapid rate. You all understand that. But, as a matter of fact, upon this route, Vail was the subcontractor at full rates, was so recognized by the government, and received every dollar himself, and consequently, the charge that it was paid to John W. Dorsey is not true, and is a fatal variance. The government proved it was paid to Vail. Next we have 2 routes, 38145, Hoyo Caliente to Parrott City, and 38156, Silverton to Parrott City. These routes are put together in the indictment. It is charged that a false account was presented of $6,004.17, and that this was done in pursuance of an order set out in the indictment. The order set out is on page 47. It is in relation to Route 38145. The order was made not in relation to the other route. No order as to the other route was made. This was made February 26, 1881. Consequently, the claim presented for the third quarter of 1879 could not by any possibility have been in pursuance of that order. That order was made in 1881. The payment for the third quarter of 1879 could not by any possibility have been made in pursuance of that order. The evidence shows that it was paid before, and consequently there is a fatal variance. Routes 40104, Mineral Park to Pioche, and 40113, Wilcox to Clifton, 2 routes put together. The charge is a fraudulent presentation for the third quarter of 1879 of $7,064.72. The pay on the first route was $10,503.62. On the second route, $3,528. No proof has been offered that the expedition was fraudulent. Not a witness was called on Route 40113. Not a solitary petition was objected to. The truth of no oath was called in question. The honesty of no order was attacked. And how can you say that the claim was fraudulent? No order attacked, no oath questioned, no petition impeached. The only evidence upon these two routes was something read in regard to productiveness and the size of the mail, and that is all. Route 38113, Rawlins to White River. The charge is that John W. Dorsey and Riddell presented a false account for the third quarter of 1879 for $2,975. The order set out in the indictment was made March 8, 1881. Consequently, the variance is absolutely fatal, and there is no allegation in the indictment that the expedition was fraudulent. End of Ingersoll's closing address to the jury in the First Star Route trial, Part 3 of 7. Read by Roger Melin. Chapter 2, Part 4 of the Works of Robert G. Ingersoll, Volume 10. Ingersoll's closing address to the jury in the First Star Route trial, Part 4 of 7. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Part 4. Now I have gone through every route with the payments. As to the general allegation of the amount of money fraudulently claimed and received, the allegation in the indictment is that J. W. Dorsey received, by virtue of these fraudulent orders, made in pursuance of the conspiracy, brought to perfection by these overt acts, for the year ending the 30th day of June, 1880, $124,591. Good. The evidence shows that there was paid on the 7 Dorsey routes in all $62,831.46. That is fatal as to that. But we will go further. One of these routes was turned over to Vail by Dorsey, Route 35015, and the amount paid to Vail was $2,837.16, so that the amount paid on the Dorsey routes, instead of being $124,591, was in truth and in fact $58,994.30. Now the charge is that this was all received by John W. Dorsey, whereas the evidence shows that John W. Dorsey received 3 warrants, 2 for $87 each, both of which were recouped, and 1 warrant for $392, and that is every cent he ever received, according to the evidence in this case. There is what you might call a discrepancy. The indictment says he got $124,591. The evidence shows that he got $392 and not another copper. I shall insist that that is a variance. If it is not a variance, I will take my oath it is a difference. The second claim is that John R. Minor received upon the routes awarded to him and claimed to be his in the indictment, $93,067 for the fiscal year ending June 30, 1880. The evidence is that, as a matter of fact, on all these routes the money was paid to assignees and subcontractors, and that John R. Minor, as a fact, received not 1 cent from the government. The third charge is that Peck received, for the same fiscal year, $178,438. The evidence shows that he received nothing. There is another difference. Thus it will be seen that every link in the chain in this indictment is either a mistake or a falsehood. Every other one is a mistake, and then every other one is a falsehood, and this indictment was made by adding mistakes to falsehoods, and what the indictment weaves the evidence reveals. Now, why were these dates put in this indictment, gentlemen? We have now gone over every overt act charged in this indictment. The result is that not one of the charges set forth has really been sustained. Hereafter I will notice some things that have been proved outside of the indictment. Nearly every petition and letter is admitted to have been honest and genuine. Those that have been attacked were misdescribed in the indictment, and the evidence has shown that they were substantially true. There is a fatal variance between the allegation and the proof, so far as these charges in the indictment are concerned, and they are left absolutely without a prop. The dates attached to the overt acts are false. There is only one of the routes in which the petitions are properly described, and that is Route 44140, where the petitions are alleged to have been and were filed on the 23rd of May. And every one was proved to have been genuine and honest. The dates on the indictments were false. Now, why? Let me tell you, gentlemen. They had to deceive the grand jury. It would not do to tell the grand jury these men conspired on the 23rd of May, and in pursuance to that conspiracy filed some affidavits on the third day preceding. They had first to deceive the grand jury and put in false dates for the filing of petitions, for the filing of subcontracts, and for the drawing of money. What else did they want these false dates for? To deceive the circuit court, or rather the Supreme Court, to deceive His Honor, because if the date of these petitions, the date of these oaths, had been set forth in the indictment, it would have been bad. The court would have instantly said, "You cannot prove a conspiracy on the 23rd of May by showing acts in April previous." So these false dates were put in the first place, to fool the grand jury, and in the next place, to keep this court in the dark. It was necessary to have a good charge on paper, and why? Did they expect to win this case on that indictment? No. But they could keep it in court long enough to allow them to attack and malign the character of these defendants. They could keep it in court long enough to vent their venom and spleen upon good and honest men, and justify in part the commencement of this prosecution. This forenoon I tried to strip the green leaves off the tree of this indictment. Now I propose to attack the principal limbs and trunk. What is the scheme of this indictment? I insist that the law is precisely the same as to the scheme of the conspiracy in its description that it is as to the description of an overt act. Now, what is the scheme of this indictment? That is to say, the scheme of this conspiracy. We want to know what we are doing. It is the great bulwark of human liberty that the charge against a man must be in writing and must be truthfully described. First, for the defendants, with the exception of the officers Brady and Turner, to write and procure the writing of fraudulent letters, communications, and applications. Now let us be honest. Is there the slightest evidence that a fraudulent letter was ever written? Is there the slightest evidence that a fraudulent communication was ever sent to the department? Not the slightest evidence. Second, to attach to said petitions and applications forged names. Is there any evidence of that except in one case, and the evidence in that case is that the order was made before the petition was received, and that the petition was never acted upon? More than that, is there any evidence as to who forged any names to any petitions? Not the slightest. Which of these defendants are you going to find guilty upon that petition when there is not the slightest evidence as to who wrote it? What next? To have these petitions signed by fictitious names, or with the names of persons not residing upon the routes. Is there any evidence of that kind? Is there any evidence that the signatures of real persons were attached, and the real persons did not live upon the routes? I leave it to you, gentlemen. Fourth, to make and procure false oaths, declarations, and statements. Those I shall examine. Fifth, for William H. Turner falsely to endorse on the back of these jackets false brief statements of the contents of genuine petitions. You know what has become of that charge, gentlemen. This indictment against Turner has been changed into a certificate of good moral character. That is the end of the indictment, so far as he is concerned, and I am glad of it. He is a man who fought to keep the flag of my country in the air, and who lay upon the field of Gettysburg 16 days with the lead of the enemy in his body, and I am glad to have the evidence show that he was not only a patriot, but an honest man with a spotless reputation. I do not think that, in order to be a great man, you have got to be as cold as an icicle. I do not think that if you wish to be like God, if there is one, it is necessary to be heartless. That is not my judgment. When I find that a man is honest, I am glad of it. When I find that a patriot has been sustained, my heart throbs in unison with his. What is the next? That Brady, for the benefit, gain, and profit of all the defendants, and I emphasize the word all because upon that I am going to cite to the court a little law, made fraudulent orders, that is, for the benefit of Turner, Brady, and everybody else. Eighth, that he caused these fraudulent orders to be certified by the auditor of the Treasury for the Post Office Department. Ninth, that Brady refused to enter fines against these contractors when they failed to perform their service, that he fraudulently refused to impose these fines. What is the evidence? The evidence is that the whole amount of fines imposed by Brady was $126,865.80. That evidence is given in support of the charge that he refused to impose them, yet the imposition amounts to $126,000. How much of that vast sum did he relieve the contractors from upon the evidence? $23,000, leaving standing of fines that were paid $103,670.12. That evidence is offered to show that he conspired not to impose the fines. $126,000 imposed in fines, and only $23,000 remitted. Yet the charge was, and an argument has been made upon it before this jury, that the contractors agreed that he was to have 50% of all the fines he took off. Think of a man making that contract with a man having power to impose the fines. Now, all you will take off I will give you 50% of. There is an old story that a friend of a man who was bitten by a dog said to him, "If you will take some bread and sop it in the blood and give it to the dog, it will cure the bite." "Yes," he says, "but my God, suppose the other dog should hear of it." Think of putting yourself in the power of a man who has the right to fine you. And yet that is a part of the logic of this prosecution. The next charge is of fraudulently cutting off service and then fraudulently starting it and allowing a month's extra pay. That happened, I believe, in 2 cases, $30 in one case and something more in the other. The Court: $39. Mr. Ingersoll: Then the case is $9 better than I thought. 12th. By the defendants fraudulently filing subcontracts. That I have already shown is an impossible offense. All these things were done for the purpose of deceiving the Postmaster General. Now, the court has already intimated that we have no right to say that the Postmaster General would be a good witness to show whether he was deceived or not, and that it may be that his eyes were sealed so tightly that he has not got them open yet. But whether they can prove it by him or by somebody else, they have got to prove it in order to make out this case. That is the scheme of this indictment. It makes no difference whether the Postmaster General has found out that he was deceived or not. The jury have got to find it out before they find a verdict against the defendants. It is possible that the Postmaster General thinks he was not deceived, or that he was. I do not know what his opinion is, and do not care. They have got to prove it by somebody. I do not say they can prove it by him. I do not know. This is the scheme, and what I insist is that this scheme must be substantiated and must be proved precisely as it has been laid, without the variation of a hair. You must prove it as you have charged it, and you must charge it as you prove it. It is simply a double statement. I wish to submit some authorities to the court upon this question. Must the exact scheme be proved? First, I will refer the court to the 10th edition of Starkey, page 627. It is a most general rule that no allegation which is descriptive of the identity of that which is legally essential to the claim or charge can ever be rejected. As an absolute and natural identity of the claim or charge alleged with that proved consists in the agreement between them in all particulars, so their legal identity consists in their agreement in all the particulars legally essential to support the charge or claim, and the identity of those particulars depends wholly upon the proof of the allegation and circumstances by which they are ascertained, limited, and described. No matter whether the description was necessary or unnecessary. To reject any allegation descriptive of that which is essential to a charge or a claim would obviously tend to mislead the adversary. It seems indeed to be a universal rule that a plaintiff or prosecutor shall in no case be allowed to transgress those limits which in point of description, limitation, and extent he has prescribed for himself. He selects his own terms in order to express the nature and extent of his charge or claim. He cannot therefore justly complain that he is limited by them. As no allegation therefore which is descriptive of any fact or matter which is legally essential to the claim or charge can be rejected altogether, inasmuch as the variance destroys the legal identity of the claim or charge alleged with that which is proved. Upon the same principle no allegation can be proved partially in respect to the extent or magnitude, where the precise extent or magnitude is in its nature descriptive of the charge or claim. Nothing can be plainer than that. I refer also to Starkey on Evidence, 7th American edition, Volume 1, page 442. There he says, "In the next place, it is clear that no averment of any matter essential to the claim or charge can ever be rejected, and this position extends to all allegations which operate by way of description or limitation of that which is material." I also cite Russell on Crimes, 9th American edition, Volume 3, page 305, and Roscoe's Criminal Evidence, 7th edition, page 86. I now call the attention of the Court to the case of Rex v. Pullman and others, 2 Campbell, 239. I may say before reading this decision that, in my judgment, so far as the scheme of this indictment is concerned, it should end this case. This was an indictment against the defendants which charged that they unlawfully and corruptly did meet, combine, conspire, consult, consent, and agree among themselves and together, with divers other evil-disposed persons, to the jurors unknown, unlawfully and corruptly to procure, obtain, receive, have and take, namely to the use of them, the said P, F, J, K, and S, H, and of certain other persons to the jurors likewise unknown, large sums of money, namely the sum of £2,000, as a compensation and reward for an appointment to be made by the Lords Commissioners of the Treasury of our Lord the King of some person to a certain office, touching and concerning his Majesty's customs, to wit, the office of a coast waiter in the port of London, through the corrupt means and procurement of them, the said F. P., J. K., and S. H., and of certain other persons to the jurors unknown, the said office then and there being an office of public trust, touching the landing and shipping coastwise of divers goods liable to certain duties of custom. The indictment went on and stated various overt acts in furtherance of the conspiracy. There were several other counts which all laid the conspiracy in the same way. Now I come to the part of the case which, in my judgment, affects this. It appears that the defendants Pullman, Keylock, and Harvey had entered into a negotiation with one Hess to procure him the office mentioned in the indictment for the sum of £2,000, which they had agreed to share among themselves in certain stipulated proportions. But although this money was lodged at the banking house of Stanks, Snaith and Company, in which the defendant Watson was a partner, and he knew it was to be paid to Pullman and Keylock upon Hess's appointment, there was no evidence to show that he knew that Sarah Harvey was to have a part of it, or that she was at all implicated in the transaction. He was a co-conspirator, and he knew that the money was to be deposited at this place. He knew that, but he did not know that Sarah Harvey was to have a part of it. Lord Ellenborough threw out a doubt whether as to Watson the indictment was supported by the evidence. The evidence being that Watson did not know that it was to be divided in the precise way stated in the indictment. Manifestly, they need not have stated in the indictment how it was to be divided, but having stated it, the question is, are they bound by the statement? Let us see. The Attorney General contended that the words in italics coming under a videlicet might be entirely rejected. The sense would be complete without them. The indictment would then run that the defendants conspired together to obtain a large sum of money as a consideration and reward for appointment to be made by the Lords Commissioners of the Treasury. This was the corpus delicti. The use to which the money might be applied was wholly immaterial. The offense of conspiring together would be complete, however the money might be disposed of. True. There was no occasion to state this, and the averment might be treated as surplusage. Suppose the manner in which the money was to be disposed of had been unknown. Would it have been impossible to convict those engaged in the conspiracy? But without rejecting the words, the variance was immaterial. The charge in the indictment had been substantially made out as laid. Dallas and Walton, of counsel for Watson, denied that the words could be rejected, though laid under a videlicet, as they were material, and they were not repugnant to anything that went before. The application of the money might be of the very essence of the offense. Suppose it had been obtained for the use of the Lords of the Treasury, who would make the appointment. Would not this be a much greater crime than if the money had been obtained for the benefit of a public charity? I think that reasoning is bad. I think the crime is exactly the same. But if the words were rejected, then the variance was more palpable. In that case, there being no mention of any persons to whose use the money was obtained, the necessary presumption was that it was obtained to the use of the defendants themselves. That is good sense. The evidence shows, however, that Watson was to have no part of it, and that he was utterly ignorant of the manner in which it was to be distributed. Lord Ellenborough, there can be no doubt that the indictment might have been so drawn as to include Watson in the conspiracy. Even if the manner the money to be applied was unknown, this might have been stated on the face of the indictment, and then no evidence of its application would have been required. The question is whether the conspiracy as actually laid be proved by the evidence? That is the question. Have they made out a case according to the scheme of the indictment? Has the conspiracy as laid been proved by the evidence? I think that as to Watson it is not. He is charged with conspiring to procure this appointment through the medium of Mrs. Harvey, of whose existence for aught that appears he was utterly ignorant. When a conspiracy is charged, it must be charged truly. He did not know that Mrs. Harvey was to have a portion of the money, and yet she was a member of the conspiracy. The evidence showed that she was to have a portion of it, and Lord Ellenborough says that they did not prove the charge as laid, and that it cannot include Watson. Garrow submitted that it was unnecessary to prove that each of the defendants knew how the money was to be disposed of, and that it was enough to show that the destination of the money was as stated in the indictment. A fact of which all of those engaged in the conspiracy must be taken to be cognizant. Watson, by engaging with the other conspirators to gain the same end, had adopted the means by which the end was to be accomplished. That is what the attorney for the government says. Lord Ellenborough replies, "You must prove that all the defendants were cognizant of the object of the conspiracy, and the mode stated in the indictment by which it was to be carried into effect. A contrary doctrine would be extremely dangerous. The defendant Watson must be acquitted." Now let us apply that case to this. In the first place, they must not only prove this indictment according to the scheme, but they must prove that every defendant understood that scheme, knew the scheme, how it was to be accomplished, and what was done with the money. The Court. In that case Watson was acquitted. What was done with the others? Mr. Ingersoll. They, of course, were found guilty, because they were guilty, as the indictment charged. They knew the exact scheme set forth in the indictment. They were guilty exactly as the indictment said. They divided the money exactly as the indictment charged they divided the money, and they were cognizant of every fact set forth in the indictment. But Watson, although a co-conspirator, did not know what was to be done with the money, and consequently was to be discharged. Why? Because they did not prove the conspiracy as to him as charged. They need not have set forth in the indictment what was to be done with the money, but they did set it forth, and then they had to prove it. They need not have said that every man knew what was done with the money, but they did say that every man knew, and they failed to prove it, and when they failed to prove it, as to Watson, he was discharged. Now, gentlemen of the jury, what I insist upon, and what I shall ask the court to instruct you, is that the government, no matter how guilty the defendant may be, no matter if he has robbed this government of hundreds of millions, is to be tried by this indictment, is to be guilty of this charge as written in this indictment, and nowhere else. And he has got to understand it. They say he understood it, and they have got to prove that he understood it. Now, upon that same subject, they say that the money was to be divided between all these parties, between Rodell, Turner, and everybody. I think it was Mr. Bliss who said there was no evidence that Rodell ever had any of the money. Certainly they do not think that Turner obtained any of the money. Is there any evidence of it? Not the slightest. Is there evidence that there ever was any division? Any evidence that there was ever any money divided upon a solitary route mentioned in this indictment? Not one particle. If you say there is evidence, when was the division made? The Court. The question is not what was done. The question is with what view the conspiracy was entered into. Mr. Ingersoll: Certainly. The Court: The object of the conspiracy may have failed, and this money might not have been divided as they intended, but still the conspiracy would be here. Mr. Ingersoll: Good, perfectly. But if they set forth in this indictment that the money was divided, that statement is not worth a last year's dead leaf unless they prove it. That is all I insist upon. You cannot find anybody guilty of charges in an indictment unless you prove them. Unless you prove them, they amount to no more than charges written in water, than characters engraved on fog or written on clouds. You have got to prove them. Now, upon this same point, I say that if the scheme has not been established by the evidence, the case fails, no matter what the proof. The offense must not only be proved as charged, but it must be charged as proved, doubling the statement for the sake of doubling the idea of accuracy. That is in Archibald's Criminal Pleadings, American edition, page 36. The same thing is held in First Chitty's Criminal Law, 213. I also refer to the case of King against Walker, 3rd Campbell, 264. King v. Robinson, First Hope's Nisi Prius Reports, 595. I have the books here, but I will not take up the time of this court in reading them. Now, if I am right, that is the language of that indictment. The overt acts with the leaves are gone. The scheme with the branch and trunk are gone. They prove no such scheme. They prove no such division. I will now proceed to examine the alleged evidence against my clients, Stephen W. and John W. Dorsey, and I want to say right in the commencement that suspicion is not evidence. You charge that a couple of persons conspired, that they met about 9 o'clock on the shadowy side of the street. A suspicious circumstance. Why did they not get under the lamp? They were seen together once more, and the moment a man came up, they walked off. Guilty. They ran. And out of these idiotic suspicions that never would have entered the mind, except for the reason that the persons were charged, hundreds of people began to say, "There is something in it. They met 4 or 5 times. One of them wrote a letter to the other, and so help me God, it was not dated." Another suspicious circumstance. There was a heading on the paper. It was not the number of his office. So they work it up, and ignorance begins to stare, and wonders to open its mouth, and finally prejudice finds a verdict. Suspicion, gentlemen, is not evidence. You want to go at this with this idea. Whatever a man does, the presumption is it is an honest act until the contrary is shown. Those men wrote letters. They had a right to do it. They met. They had a right to meet. They entered into contracts. They had a right to do it, no matter whether they were dated or not dated. One of the greatest judges of England said if you let out of the greatest man's brains all the suspicions, all the rumors, all the mistakes, and all the nonsense, the amount of pure knowledge left would be extremely small. If you take out of this case all the suspicions, all the guesses, all the rumors, all the epithets, all the arrogant declarations, the amount of real evidence would be surprisingly small. Now I want to try this case that way. I do not want to try it by prejudice. Prejudice is born of ignorance and malice. One of the greatest men of this country said, "Prejudice is the spider of the mind. It weaves its web over every window and over every crevice where light can enter, and then disputes the existence of the light that it has excluded." That is prejudice. Prejudice will give the lie to all the other senses. It will swear the northern star out of the sky of truth. You must avoid it. It is the womb of injustice, and a man who cannot rise above prejudice is not a civilized man. He is simply a barbarian. I do not want this case tried on prejudice. Prejudice will shut its eyes against the light. I want you to try it without that. And right here, although it is a subject about which most courts are a little tender, the question arises as to the jury being judges of the law and fact. One of the attorneys for the government, Mr. Merrick, told us that at one time he insisted that the jury was the judge of the law, and made this remarkable declaration: "But even at the time I spoke the words to the jury, I did not believe them to be indicative of safe and true principles of law." Was he candid then? Is he candid now? I do not know. But his doctrine appears to be this: when I am afraid of the court, I insist on the jury judging the law. When I am afraid of the jury, I turn the law over to the court. But in this case, having confidence in both judge and jury, it is wholly immaterial to me how the question is decided. Now, if it please the court, I believe the law to be simply this: I believe the jury to be absolute judges of the facts, and yet if on the facts they find a man guilty whom the court thinks is not guilty, the court will grant a new trial. The court has the powers to set aside a verdict because the jury find contrary to the evidence. The court cannot do it, however, when the jury finds a verdict of not guilty. I do not believe that the jury have a right to disregard the law from the court, unless a juryman upon his oath can say that he believes, he knows, or is satisfied that is not the law. And he must be honest in that, and he must not be acting upon caprice. He must be absolutely honest. He must be in that condition of mind that to follow the law pointed out by the court would trample upon his conscience, and that he has not the right to do. That is all the distance I go. The history of the world will show that some of the grandest advances made in law have been made by juries who would not allow their consciences to be trampled into the earth by tyrannical judges. I am not saying that for this case. I am simply saying that as a fact. There was a time in this country when they used to try a man who helped another to gain his liberty, and there was now and then a man on the jury who had sense enough, and heart enough, and conscience enough to say, "I will die before I carry out that kind of law." They did not carry it out either, and finally the law became so contemptible, so execrable, that everybody despised it. All I ask this jury to do is just to be governed by the evidence and by the law as the court will give it to them, honestly and fairly. End of Ingersoll's closing address to the jury in the first Star Route trial, Part 4 of 7. Read by Roger Melin. Chapter 2, Part 5 of the works of Robert G. Ingersoll, Volume 10. Ingersoll's closing address to the jury in the first Star Route trial. Part 5 of 7. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roger Melin. Part 5. Now I am coming to the evidence against John W. Dorsey. I am traveling through this case now we have started it. As you have heard very little about it, gentlemen, there is nothing in the world like speaking on a fresh subject. I feel an interest in John W. Dorsey. He is my client. I believe him to be an absolutely honest man. He is willing to take the effect of all his acts. He is no sneak, no skulk. He will take it as it is. Let us see what he has done. The first witness is Mr. Boone. Mr. Boone swears that John W. Dorsey was one of the original partners. Well, that is so. It is claimed that the conspiracy was entered into before there was any bidding. Well, Boone does not uphold that view. Now, if Boone and Miner and John W. Dorsey and Peck had an arrangement with Brady whereby they were to bid and then have expedition and increase, I want to ask you, why did Boone write to all the postmasters to find out about the roads and the cost of provender, and the kind of weather they had in the winter, in order to ascertain what bid to make? If he had had an arrangement with the second assistant postmaster general to expedite the route, he would have simply made up his mind to bid lower than anybody else, and he would not have cared a cent what kind of roads they had there, or what kind of weather they had in the winter, or how much horse provender cost, and yet he sent out thousands of circulars to find out these facts. For what? To make bids. What for? According to the government, these were routes on which they had already conspired for expedition and increase without the slightest reference to the horses and men, and, of course, if that theory is true, Boone is one of the conspirators. But I will come to that hereafter. More routes, according to Boone's testimony, were awarded than they anticipated. They got, I think, 126. They had no money to stock the routes. They got more than they expected. Well, that was not a crime. Boone left in August, 1878, and Mr. Merrick takes the ground that Boone had done the work, manipulated all the machinery, and yet could not be trusted with the secret. Boone had gathered all the information, he had done the entire business, and yet the secret up to that time had been successfully kept from him. Do you believe that? Now, Vail came, and another partnership was formed, and the second partnership remained in force, I think, till the 1st of April, 1879, or the last day of March, and then the routes were divided. Now, then John W. Dorsey is charged with conspiracy as to these routes, and these routes were afterwards assigned to S. W. Dorsey to secure advances and endorsements that were made. Now, of the routes mentioned in the indictment, John W. Dorsey was interested in 7 at the time of the division. From Vermilion to Sioux Falls, from White River to Rawlins, from Garland to Parrott City, from Ouray to Los Pinos, from Silverton to Parrott City, from Mineral Park to Pioche, and from Tres Alamos to Clifton. How much money did he get on all these routes? I have already shown you. He received 2 warrants for $87, and they recouped them both. He received another warrant for $392 and succeeded in keeping it. That is all the money he got in these 7 routes. Now, the testimony of Mr. Vail shows, if it shows anything, that after April 1879 he took those routes and kept them and never paid $1 to any official in the world, and he also swears that no matter how much he got, it made no difference as to the routes that had been given to John W. Dorsey and Peck. It could not in any way affect their amount, and that no person in the world except themselves had any interest in them. Now it is charged that false affidavits were made by John W. Dorsey, and that the making of these false affidavits was the result of conspiracy. Let us see. It has been shown by the evidence, and I have already shown it, and conclusively shown it, that the affidavit was substantially correct, so far as the proportion was concerned. Now, let me explain what I mean by proportion. For instance, I am getting $5,000 a year on a route, and it takes 5 men and 10 horses. That is an aggregate of 15. Now, suppose I simply expedite it a certain number of miles an hour and say it will take 15 men and 30 horses. That makes an aggregate of 45, does it not? Then the government gives me 3 times as much for the expedited service as for the then service. Now, suppose I am getting $1,000, and it only takes 1 man and 1 horse, and I make an affidavit that it takes 100 men and 100 horses, and if it is expedited, it will take 200 men and 200 horses. How much more do I get? I get just double, and the result of the affidavit is exactly the same as though I said the 1 man and 1 horse that it then took, and it would require 2 men and 2 horses. If you keep the proportion, you cannot by any possibility commit a fraud against the government. Now, we understand that. Now let us see. When you make an affidavit, what do? When you make an affidavit of how many horses it will take, you take into consideration the length of the term, 3 or 4 years. You take into consideration the life of a horse. You take into consideration the roads and the weather. You take into consideration every risk, and find it is only a matter of judgment, only a matter of opinion, and the fact that men differ as to their judgment upon those points accounts for the fact that they make different affidavits. If everybody made the same calculation as to food, as to weather, as to roads, as to disease, everybody would make substantially the same bid. But on the same route they differ thousands of dollars a year, because they differ in judgment as to the number of horses it will require and as to the number of men. And then there is another thing. Some men will make a horse do twice as much as others. Some men are hard and fierce and merciless. Some men are like they ask you to be in this case, icicles. Some men resemble the gods so far that they will make a horse do 5 times the work they should, and other men are merciful to the dumb beast. So they differ in judgment. One man says he can go 25 miles every day, and another man says he can only go 15. One man says stations ought to be built 25 miles apart. Another says they should be built 10 miles apart. They differ, and for that reason, gentlemen, the bids differ, and for that reason the affidavits differ. I shall not speak of all these affidavits, but I shall speak of the ones that have been attacked. Mr. Merrick called Mr. Dorsey a perjurer because he made 2 affidavits on Route 38145. Now, no such charge is made in the indictment, but I will answer it. Now, then, as to the 2 indictments. The Court. 2 affidavits. Mr. Ingersoll. 2 affidavits. Well, there ought to have been 2 indictments to cover both cases. Now, this is on Route 38145, Garland to Parrott City. Now, there were 2 affidavits made on 38145, as is set forth in the evidence, but it is not in the indictment. The first affidavit was sworn to March 11, 1879, in Vermont, and filed April 16, 1879. Neither could come in under this conspiracy anyway. The second was made in Washington, April 26, 1879, and filed the same day, which is a suspicious circumstance. The letter dated April 23, 1879, according to the prosecution, purports to transmit an affidavit made on the 26th. There is no evidence that the affidavit dated the 26th was enclosed in the letter dated the 23rd. The affidavit set forth the number of men and animals required to run the route on a schedule of 50 hours, 3 trips a week. There is no evidence as to the character of the paper transmitted, if any was transmitted, nor, in fact, is there any evidence that any paper was transmitted with that letter. Now, on page 804 of the record, Mr. Bliss submitted 2 papers to Mr. McSweeney, a witness, saying, "I show you 2 papers pinned together." Who pinned them? I do not know. One dated April 26, 1879, and the other dated April 24, 1879. The paper dated April 26 is endorsed in the handwriting of William H. Turner. The endorsement on the paper dated April 24 is in the handwriting of Byron C. Coon. This fact shows that the papers were read by Mr. Bliss as one paper and marked 17E, were treated by the department as two separate papers received on separate dates, and so marked and so filed, and that they were marked at the time they were identified as numbers 17 and 18. Now, the only question is whether the last affidavit was made for the purpose of committing a fraud upon the government, and whether the change in the figures in the last affidavit were intended to or could in any way defraud the government of the United States. Now, let us see what it is. Mr. Merrick charges that the second oath was willful perjury. In order to show that this was an honest transaction and that Mr. Dorsey should be praised instead of blamed, I will call your attention now to the exact state of facts. Now, if I do not make out from this that it was a praiseworthy action instead of perjury, a good, honest action, I will abandon the case. In the first affidavit, Dorsey swore that it would require 3 men and 7 animals, as the schedule then was, and that for the proposed schedule it would take 11 men and 26 animals. Now, 3 men and 7 animals make 10, and 11 men and 26 animals make 37, so that by the first affidavit he swore that it would take 3 7/10 more animals to carry the mail on the expedited schedule than on the schedule as it then was, did he not? 3 men and 7 animals as against 11 men and 26 animals, it would take 3 7/10 more animals. Consequently, you would get for that 3 7/10 more pay. Now, let us understand that. That is an increase in the ratio of 10 to 37, and if his pay had been calculated on that first affidavit, it would have been $13,433.04. But it was not calculated on that. He made another affidavit. Now, the second affidavit said that it would take 20 men and animals instead of 10, as it then was, and for the expedition 54 men and animals. Now, the ratio between 20 and 54 was 2 7/10 instead of 3 7/10, so that under the second affidavit, which they say was willful and corrupt perjury, he would only get $8,457, and the change of that affidavit, if the amount had been calculated on the first instead of the second, would have cost him for the 3 years yet remaining of his term $14,925.60, and that change saved, exactly as if they had made the calculation on the other affidavit, about $15,000, and yet they tell me that that was willful and corrupt perjury. There has nothing been shown in the case more perfectly honorable. Nothing shown calculated to put John W. Dorsey in a fairer, in a grander light than this very affidavit that is charged to have been willful perjury. Do you see? He made the first affidavit, and in it he made a mistake against the government of $14,925, and then, like an honest man, he corrected it, and for that honest correction he is held up as a perjured scoundrel. It will not do, my friends. But, as a matter of fact, not one of these affidavits is set out in the indictment. Not one charged in the indictment. They are wandering tramps that were picked up as they went along with the case, and have no business here. In Route 38152 he made no affidavit. In Route 38113 there is no charge in the indictment that he made any affidavit. In the Route 38156 the affidavit was not false. It was charged and was not successfully impeached. In Route 40104, the affidavit was never disputed, and it was never attacked. In Route 40113, the affidavit was not attacked, not a solitary witness was examined. In Route 35105, no affidavit was made by Dorsey. In Route 38134, there are 2 more affidavits. Now, let us see. Here is some more fraud. Put it down. 38134, 2 affidavits, a great fraud. The first affidavit said 3 men and 12 animals. That made 15. That for the expedition it would take 7 men and 38 animals. That made 45. In other words, the proportion was 15 to 45, just 3 times as much. 3 times 15 makes 45. Then he made a second affidavit, filed it with a purpose to defraud the government. Let us see. In the second affidavit, he said that it took 2 men and 6 animals. That makes 8. That on the expedition it would take 6 men and 18 animals. That makes 24. The proportion was 8 to 24. 3 times 8 makes 24, and 3 times 15 make 45, so that the amount was raised exactly the same to a cent under the second affidavit that it was under the first, and consequently could not have been made for the purpose of defrauding anybody. Impossible. The proportion, of course, is the material thing in every affidavit, and it is only by that proportion that you can tell whether they are trying to defraud this government or not. Suppose that second affidavit had changed the proportion so that he was not to get just the amount of money, then you might say it was a fraud. But it did not change the proportion. On Route 38156, another affidavit is filed and not successfully impeached. I went over that. I have got through with that. That is all there is to it. That is all. That is everything. 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 There is no evidence tending to show that John W. Dorsey ever spoke to Thomas J. Brady. There is no evidence to show that he ever saw him. There is no evidence to show that he was ever seen in his company. No evidence to show that he ever saw Turner, that he ever heard of Turner, that he ever spoke to Turner, that he ever received a letter from Turner, that he ever wrote anything to him. No evidence, as a matter of fact, that he ever exchanged a word with these men. No evidence that he ever saw Harvey M. Vail, that he ever spoke to him. Certainly there is no evidence that he ever conspired with him. No evidence that he ever made an agreement with Thomas J. Brady, or with Mr. Turner, or with any officer. No agreement of any sort, kind, character, or description at any place, upon any subject, or for any purpose, not the slightest. No evidence that he conspired with anybody. No evidence that he ever received from the United States a solitary dollar, with the exception of $392. Not the slightest. There is no evidence that he ever wrote a false communication to the department. Nothing of it. There is no evidence that he ever wrote a petition. No evidence that he ever forged one. No evidence that he ever signed anybody's name to one. No evidence that he did anything of the kind, or that he ever changed one. No evidence that he ever put a man's name to it that did not live on the route. No evidence that he ever put in a fictitious name. No evidence that he helped to deceive the Postmaster General. Not the slightest. If there is, I want somebody just to put their finger upon the evidence. There is no evidence that he ever made false statements at any time. There is no evidence that he ever paid, as I say, $1 to any official, and no evidence that he ever promised to pay it. All the evidence is that he got $392. He made the affidavits in accordance with what he believed to be the truth. The evidence shows that when he made the affidavits on those routes, he had no personal interest, that he received not a dollar for making them. He made them because he supposed the contractor or subcontractor had to make them. He made them because he believed them to be true. He was guided by the little experience he had in himself, and by the statements made to him by others, and in all this evidence there is not a word, not a line, not a letter tending to show he did a dishonest act, and the jury will bear me out that in the affidavits attacked he was substantially right, while in the first instance he was too high, in others he was too low. But there is no evidence that he deliberately swore to what he believed to be untrue. The proportion sworn to by him has always been substantially correct. In other words, gentlemen, the testimony shows that John W. Dorsey is an honest man, and there is no jury, there never was, there never will be, that will find a man like that guilty upon evidence like this. It never happened. It never will happen. Now, I come to my other client, Stephen W. Dorsey, and I feel an interest in him. He is my friend. I like him. He is a good man. He has good sense. He is not simply a politician, he is a statesman, and I want you to understand that he never did an act in this case that he did not thoroughly understand, as well as any lawyer in this prosecution ever will understand, or as well as any lawyer of the defense ever will understand. He knew exactly his liabilities. He knew exactly his responsibility. He knew exactly what he did and knew he did only what was right. In the opening of this case, Mr. McSweeney made a statement. He told you the exact connection of Dorsey with this matter. He not only told you that, but he told you that Dorsey had lost money on these routes, and that he had never been repaid the money he had advanced, and in that connection he said that he had turned the routes over to James W. Bosler, and the department knew of James W. Bosler because they introduced testimony here that the warrants were paid to James W. Bosler. Mr. McSweeney stated that Bosler controlled the business, and now we are asked by the prosecution, why did you not bring James W. Bosler on the stand and show that you had lost money? I return the compliment and say to them, why did you not bring James W. Bosler on the stand and show it was not true that he had lost money, as he kept the books? I ask them that. Why did they not bring James W. Bosler? Mr. Merrick: If your Honor please, there is no evidence whatever as to whether S. W. Dorsey lost money on those routes, and the statement of counsel made in the opening, I respectfully submit, cannot be used as evidence by the counsel in the case. The Court: Of course it is impossible for me to say, after so long a time spent in receiving evidence, what evidence has been given on a disputed question. I cannot say from recollection what evidence has been given on the subject, but I understand the remarks now made are not made upon evidence in the case, but in reply to remarks made in the opening of the case. Mr. Ingersoll: Partially so. Mr. Merrick: The opening by their counsel. The Court: By their counsel. Mr. Merrick: By their counsel, Mr. McSweeney. Mr. Ingersoll: Let me just state it, and the Court will understand it perfectly. Mr. McSweeney, in his opening, said that these routes had been turned over to James W. Bosler, that he received the money and paid it out, and that S. W. Dorsey on these very routes had not made money, but lost money. Very well. But that statement was simply a statement. It was never proved afterwards. The government said to us, "Why did you not bring James W. Bosler to prove that?" The Court: Where did they say that? Mr. Ingersoll: They said it in their speeches. Mr. Merrick said it. Mr. Merrick: Not to prove as to the money. Mr. Ingersoll: Aye. Why did you not bring James W. Bosler? Mr. Merrick: Yes, but not as to proof of money, but as to other questions in reference to the distribution of routes and the loaning of money by Dorsey and by Bosler to Dorsey, and Dorsey's transfer of the routes to Bosler as security for the loan as appeared in Vail's testimony. The Court: I shall not interfere. Mr. Merrick: I shall not attempt to arrest the course of counsel unless there is ground for it, and I ask the Court that, there being no evidence of this fact, that the counsel shall not. Mr. Ingersoll, interposing: I am going to show there is some evidence. The Court: I understand it is a remark in reply to an observation of your own. Mr. Ingersoll: That is principally it. Now, they introduced the warrants that had been drawn by the contractors and subcontractors from the Post Office Department. They proved that these warrants had been paid to James W. Bosler, and that one after the other, hundreds had been assigned to James W. Bosler. Now, then, I say, they say to us, why do you not bring in James W. Bosler and prove your innocence? I say, why did you not bring in James W. Bosler and prove our guilt? We opened the door. We told you the name of the witness. We told you that he had taken the routes, that he kept the books, that he disbursed the money, and that we had lost money. Instead of robbing the government has robbed us. And they say, why did you not bring Bosler? And I say to them, why did you not bring him? They know him, and they know he is a reputable man. Now, there is another point. I ask you all to remember what was said in the opening, and I understand that a defense is bound by its opening, bound by what it says to the jury. The question is, has any fact been substantiated in this case that contradicts a statement made in the opening? The Court: The defense has no right to avail itself of. Mr. Ingersoll, interposing: Of what it says. The Court: Of what it says in its opening, unless it is followed by evidence. Mr. Ingersoll: Certainly not, but it has a right to show that no evidence has been introduced by the government that touches that opening statement. It has the right to do that, surely. Now then, Mr. Boone was the witness for the government, a smart man. He swore who were interested in the bidding. He told and he positively swore that Dorsey was not interested in these routes. He gave the names of the persons interested, and he swore positively that he was not. Dorsey, then, I say, had not the slightest interest. He loaned money, he went security, he assisted in getting sureties on bonds, and you recollect the trouble that they have made about some bonds. Has there any evidence been introduced to show that there was a bad bond? Has any evidence been introduced to show that the name of an insolvent man was put upon any bond as security? Has there been any evidence to show that any action was ever commenced on any of these bonds? Any evidence tending to show that every bond was not absolutely good? As a matter of fact, the government waived all of that. In offering the contract on Route 35015, Mr. Merrick made this remark: It is offered for the purpose of showing the contract made. The contract itself is not an overt act. That is all right. There is nothing criminal about that. Good. Nothing criminal about any contract, gentlemen. You will all admit they had to make the bids, and if they were the lowest bidders it was the duty of the government to accept the bids and afterwards to make the contracts in accordance with them. There was nothing wrong in that. That is Dorsey's first step. His first step really was an act of kindness. What was the second step? He was unable to advance any more money. Mr. Peck, Mr. Miner, Mr. Dorsey, and Mr. Boone were unable to advance the money, so Mr. Boone went out and Mr. Vail came in, and the new partnership agreed to refund this money that had been advanced. That is, the money advanced by the other parties. What one gets another to advance is really advanced by him, as long as he is liable for it. Mr. Vail, a man of large experience and means, was taken in Boone's place. Is there anything suspicious up to this time? That is the only test of this whole question. Is it natural? If it is natural, there is no chance for suspicion. After Mr. Vail came in, a written contract was made on August 16, 1878. There is no conspiracy up to that time. Not the slightest evidence of it. No arrangement with any officers up to that time. Now, under the August contract, Mr. Vail took the entire business in charge, and he ran it, as I understand, until the first day of April, 1879. No officer had any interest in it then. There was no conspiracy then. Vail received all the money and paid it out. Here we stand on the first day of April, 1879. Now, what is the history up to this time? That John W. Dorsey, Peck, Miner, and Boone were bidders, that certain routes had been awarded. They had not the money to stock the routes, and that S. W. Dorsey advanced some money and went security. That afterwards Boone went out and Vail came in, and the contract was made by virtue of which Vail became the treasurer and knew everybody, and ran the business to the first day of April, 1879. He swears positively that he made no arrangement, and that he paid no money. It is also in evidence that in December, 1878, Stephen W. Dorsey and Vail met for the first time, and met in the German-American Bank for the purpose of settling the claim upon which Dorsey was security, and replacing the notes upon which Dorsey was by notes of Vail, Miner and Company. Afterwards these notes were paid by Vail and the security of Dorsey released. Now, in April, 1879, a division is made. The contract of August, 1878, was done away with, and a division of the routes was made, 70% being taken by Vail and Miner, and 30% by John W. Dorsey and Peck. In April, 1879, the parties divided instead of coming together. They do not conspire, they separate. They do not unite, they go asunder. From that moment they agree to have nothing in common. Each man takes his own, and each man attends to his own and does not help anybody else except when they insist that a contractor or subcontractor shall make the affidavit. They made affidavits on the routes on which they were contractors. That is all there is to it up to that time. Then these routes were assigned to Dorsey for the purpose of securing him. Now, I go to the overt acts charged against Stephen W. Dorsey. Do you know I am delighted to get right to that page of my notes? I am delighted that I now have the opportunity to answer, and to answer forever all the infamous things that have been charged against this man. Here we are, before this jury, a jury of his fellow citizens, a jury that has the courage to do it right. I have finally the chance of telling here before men who know whether I am speaking the truth or not, what has been charged against Stephen W. Dorsey, and what has been proved against him. Let us examine the overt acts charged. On Route 38135, it is charged that Miner, Rudell, and S. W. Dorsey transmitted a false affidavit. The evidence is that the affidavit was made by Miner, not by Dorsey, transmitted by Miner, not by Dorsey, and that it was not transmitted as charged in the indictment, but transmitted on the 18th day of April, 1879. There is no evidence that Dorsey even heard of that affidavit, that he ever made it, that he ever transmitted it, that he ever saw it, that he never knew of its existence. That is the first charge. There is not one particle of evidence to show that he ever knew there was such a paper. Upon that written lie, upon that mistake, these infamous charges affecting the character of this man have been circulated over the United States. What is the next? That he, with others, filed false petitions. I am telling you now all the charges, every one of them. What is the evidence? Oh, it is splendid to get to the facts. The evidence is that every petition is shown to have been genuine. There is no evidence that he ever filed one or sent one or asked to have one sent on that route, and every petition is genuine and no charge made except as to one. In one they said the words "quicker time" were inserted, but the very next paragraph asked for quicker time, and nobody pretended that had been inserted. Besides that, it was charged in the indictments to have been filed on the 26th day of June. As a matter of fact, it was filed on the 8th day of May. It was never filed by Stephen W. Dorsey. It was never gotten up by Stephen W. Dorsey. There is no evidence that he ever knew of it or heard of it. Third, that he fraudulently filed a subcontract. 2 mistakes and an impossible offense. That ends that route. That is everything on earth in it. I defy any man to make anything more out of it than I have. I have told every word. The next route is number 41119. It is charged that Stephen W. Dorsey, with others, transmitted a false oath. The evidence is that the oath was made by Peck, and it was transmitted by Peck and not by Stephen W. Dorsey. What else? That it is true. There are 3 mistakes in that charge. They say Dorsey made it. Peck made it. They say Dorsey transmitted it. Peck transmitted it. They say it was false. The evidence shows it true. That is all there is to that route. It is the only charge on that route. No petitions were claimed to be false. Now we come to Route 38145. Let us see if we can do any better on that. The first charge is that Stephen W. Dorsey fraudulently filed a subcontract. The subcontract was made with Sanderson. Sanderson got his own contract filed. This charge was copied from the old indictment. It is a mistake, and that is all there is to it. These are the charges that have carried sorrow to many hearts. These are the charges that have darkened homes. These are the charges that have filled nights with grief and horror, every one of them a lie. The next route is 38156. The first charge is that he transmitted a false oath. The oath was made by John W. Dorsey and is true. The second charge is of fraudulently filing a subcontract, an impossible offense. That is everything on that route. Absolutely untrue. Now we come to the next, number 46217. The charge is filing base petitions. The evidence is that every petition was genuine, every one. Mr. Bliss said, "We make no point about increase of trips on this route." Every petition was for increase of trips. You will see that on record, page 1008. That is the only charge on that route, gentlemen. Utterly false. End of Ingersoll's closing address to the jury in the first Star Route trial, Part 5 of 7. Read by Roger Melin. Chapter 2, Part 6 of the Works of Robert G. Ingersoll, Volume 10, Ingersoll's closing address to the jury in the first Star Route trial. Part 6 of 7. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roger Melin. Part 6. Come now to Route 38140. Charge: filing false and forged petitions. Evidence: all the petitions genuine. Second charge: transmitting a false oath and making it. Evidence: oath made by John W. Dorsey, and true. That is all there is to that route. If they can make up any more, I want to see it. I have been through this record. Route 38113. Charge: fraudulently filing a subcontract. That is all. You cannot fraudulently file a subcontract. Route 40113. Charge: filing false and forged petitions. Evidence: every petition admitted by the government to be genuine. Good. Second, transmitting a false oath. Evidence: oath made by John W. Dorsey, and the government introduced no witness to show that it was false. See how these charges fall. See how they bite the ground. That is all. I have told you every one in this indictment, every one. You will hardly believe it. Now let me give you the recapitulation. S. W. Dorsey is charged on 8 routes with having transmitted 4 false oaths. The evidence is he never made one nor transmitted one, and that the 4 oaths were all true. On 5 routes he is charged with having filed false petitions. The evidence is that all the petitions were genuine. None of the petitions charged in the indictment to have been transmitted by him were transmitted by him. He is charged with filing fraudulent subcontracts, and the evidence is that the subcontracts were genuine, and besides that, as I have said a dozen times, it is utterly impossible to fraudulently file a subcontract. Not a single solitary charge in this indictment against Stephen W. Dorsey has been substantiated. Not one. He has been called a robber, he has been called a thief, but the evidence shows he is an honest man. Not one single thing alleged in that indictment has been substantiated against him, and I defy any human being to point to the evidence that does it. Now think of it. All this charge has been made against that man upon that evidence, no other evidence, not another line so far as the indictment is concerned. What is outside of the indictment? That he wrote 2 letters, taking possession of routes that had been turned over to him as security, which he had a right to do. What else? That he got up some petitions, or had them gotten up, in the state of Oregon. The man who got them up was brought here as a witness. I believe his name was Wilcox. He swore that everything he did was honest, and that every name to every petition was genuine. Now let us see. Another point has been made upon S. W. Dorsey. I want to read it to you. This is from the argument of Mr. Merrick. Quote, Peck, John W. Dorsey, and Miner, or some other one of Stephen W. Dorsey's friends. Who was making up this conspiracy? Who was gathering around him arms and hands to reach into the public's treasury for his benefit, while his own were apparently unoccupied with pelf? S. W. Dorsey. My brother and brother-in-law will go in, and Miner, or if not Miner, then one of my other friends. End quote. This is quoted. Quote, one of S. W. Dorsey's other facile friends. That was in 1877, gentlemen, the morning of this day of fraud and criminality. In that room where Boone and S. W. Dorsey sat arose the sun, and there was marked his course. There was fashioned the duration and the business of that criminal day." Now let us see what the evidence is. The object of that speech is to convince you that Dorse said to Boone, "I will either put in Miner or one of my friends." Do you know that there is not money enough in the Treasury of the United States, there is not gold and silver enough in the veins of this earth, to tempt me to misstate evidence when a man is on trial for his liberty or his life? Let us see what the evidence is. "Who else besides his brother-in-law and brother?" Answer: I could not say positively whether Mr. Miner's name was mentioned. He either mentioned his name or a friend of his from Sandusky, Ohio." Now, I submit to you, gentlemen, what does that mean? Mr. Boone, in effect, says, "He told me either it was Miner or a friend of his from Sandusky." That is, he either described Miner by his name, or he described him as a friend of his from Sandusky. Then there was objection made, and after that comes another question. Question: Was anything said of Mr. Miner's coming to Washington? Answer: I could not say whether his name was mentioned or a friend of his, a personal friend. What does that mean? Boone cannot remember whether he called him Miner or called him a friend of his from Sandusky? What else? Answer: There was to be nobody that I understood outside of the parties I spoke of. Question: You and John W. Dorsey and Peck? Answer: And Mr. Miner. Question: Or one of his friends? Answer: Or Mr. Dorsey's friend. The arrangement made was not made until they came here. It was only to prepare the necessary blanks and papers pending their coming, because the time was getting short, and it was necessary to get the information to bid upon. Nothing was said about any interest at all until after they came here, and then there was a partnership entered into." Now I ask you, gentlemen of the jury, what is the meaning of that testimony? The meaning is simply this: Boone could not remember whether he mentioned Miner's name or called him a friend of his from Sandusky, yet the object has been to make you believe that the testimony was that S. W. Dorsey said, "I will either have Miner or I will get another friend of mine." Dorsey had no interest in it, not the interest of 1 cent. Not the interest of $1, directly, indirectly, or any other way. He had no interest in having a friend of his. All that Mr. Boone said is that Mr. Dorsey either called this man Miner or described him as a friend from Sandusky, Ohio. The evidence is that Mr. Miner did come, and the evidence is that the arrangement was made. What else is there outside in this case against Stephen W. Dorsey? I ask you to put your hand upon it. I ask anybody to point it out. What other suspicious circumstance is there? I want you to understand that all the suspicious circumstances in the world are good for nothing. All the evidence on earth tending to show a thing does not show it. Anything that only tends that way never gets there, never. You cannot infer a conspiracy. Unless you have the facts proved, you cannot infer the fact and then infer the conspiracy. There has not been, I want to say it again, there has not been a solitary fraudulent act proven against Stephen W. Dorsey. They have not done it, and they cannot do it. All I ask of you, gentlemen, is to find a verdict in accordance with this testimony. May it please the court, it appears from the evidence in this case, I think the evidence of Mr. James, that Stephen W. Dorsey at one time about 16 or 17 months ago, made a statement in writing of his connection with all these routes. That statement he gave to the Attorney General and the Postmaster General. There is no evidence of what was in that statement. The only evidence is that such a statement was made, embracing his connection with these routes. The Court. You offered to prove that. Mr. Ingersoll. Oh, no. The reason it was established was I wanted to show whether that statement was made before or after Mr. Rodell made a statement. The fact simply appears that he made a statement. The Court. You offered to prove the fact. Mr. Ingersoll. I do not remember offering to prove it. I proved it. The Court. If it was not proven, Mr. Ingersoll interposing, I did prove it as a fact. The Court. That he made a statement. Mr. Ingersoll. Yes, sir. Right here it is, taking up the record. The Court. Oh, well, you cannot base any remarks upon that. Mr. Ingersoll. Let me read what the evidence says. Quote, Question. Was this statement of Rodell's made to you after you had received the statements of S.W. Dorsey as to his connection with all these entire routes, or with this entire business? The Witness. To what statements do you refer? Mr. Ingersoll. To the statement that was made in writing and given to you and the Attorney General by ex-Senator S.W. Dorsey. Answer. It must have been after that. Question. You mean Rodell's statement was after that? Answer. Yes, sir. Question. Did you ever see that statement made by Senator Dorsey? Answer. It was referred to the Attorney General. Question. Did you ever see it? Answer. Certainly. Question. Do you know where it now is? Answer. I do not. End quote. I am not going to say a word about what was in that statement, but the Court will see that that has a direct bearing upon their action with regard to Rodell's statement, whether it was made before or after, which I will endeavor to show. And the only point that I wanted to make upon that statement now was that the government has not endeavored to prove that anything in that statement was inconsistent with the evidence in this case. I am not going to say what the statement was, simply that he made a statement, and it follows as naturally as night follows morning and morning follows night that if that statement had been incorrect, it would have been brought forward. That is all. The Court. For anything the Court knows, it might have been a confession. We do not know anything about it. Mr. Ingersoll. If it had been a confession, it would have been here. That is the point I make. If there had been in that anything inconsistent with the testimony, it would have been here. The Court. Probably it would. Mr. Ingersoll. Yes, sir, that is my point. The Court. When a man is charged with crime, no man has a right to say that because he did not deny it, that is evidence of his guilt. Mr. Ingersoll. No, sir, and no man has a right to say that because he did deny it is evidence of his innocence. The Court. It is not evidence either way. Mr. Ingersoll. It is not evidence either way, and if I am charged with a crime, and I make a written statement to the government of my entire connection with that thing, and they go on and examine it for 1 year and finally finish the trial without showing that the statement was incorrect, it is a moral demonstration that my statement agreed with the testimony. The Court. On the principle, I suppose, of an account rendered and no objection made? Mr. Ingersoll. Good. That is a good idea. The Court. I do not see anything in that. Mr. Ingersoll. I see a great deal in it, and it is a question whether the jury can see anything in it. The Court. It is a question whether the Court, too— Mr. Ingersoll interposing. Very well. The Court continuing. Whether the Court is going to allow an argument to be based upon a mere vacuum, wind, nothing. Mr. Ingersoll. That would seem to be stealing the foundation of this case. Laughter and cries of silence from the bailiffs. We will consider the argument made to the Court and not to the jury. The next question, then, is, what is the corpus delicti? That is, in a case of conspiracy. I do not believe the combination to be the corpus delicti, the mere association. It may be the corpus, but it is not the delicti, and under the law there must not only be a conspiracy, as I understand it, but also an overt act done by one of the conspirators to accomplish the object of the conspiracy, so that the conspiracy with the fraudulent purpose and the overt act constitute the corpus delicti. Now I read from Best on Presumption, page 279. Quote, the corpus delicti, the body of an offense, is the fact of its actually having been committed. End quote. The dead body in a murder case is not the corpus delicti. It is the corpse and nothing more. It must be followed by evidence that murder was committed. The corpus delicti is the body, substance or foundation of the offense. It is the substantial and fundamental fact of its having been committed. 1 Haggard, 105, opinion by Lord Stowell. I now refer you to Peoples v. Powell, 63, New York, page 92. It seems that the defendants in this case were commissioners of charities of the County of Kings, and they were indicted for conspiring together to buy supplies contrary to law and without duly advertising. Their defense was that they were not aware that such a law existed, that they were ignorant of the law. The court below thought that made no difference. The court above said before they could be guilty of this crime, there must be the intention to commit the crime, and this language is used. Quote, the agreement must have been entered into with an evil purpose, as distinguished from a purpose simply to do the act prohibited in ignorance of the prohibition. This is implied in the meaning of the word conspiracy. Mere concert is not conspiracy. End quote. So, combination is not conspiracy. Partnership is not conspiracy. Neither is it the corpus delicti of conspiracy. There must be the evil intent. There must be the wicked conspiracy not only, but there must be one at least overt act done in pursuance of it before the corpus delicti can be established. Quote, the actual criminal intention belongs to the definition of the offense, and must be shown to justify a conviction for conspiracy. The offense originally consisted in a combination to convict an innocent person by perversion of the law. It has since been greatly extended, but I am of opinion that proof that the defendants agreed to do an act prohibited by statute, followed by overt acts in furtherance of the agreed purpose, did not conclusively establish that they were guilty of the crime of conspiracy. End quote. It would be hard to find a stronger case, in my judgment, than that. Although they agreed to violate a statute, they agreed to buy supplies without complying with the statute by advertising, they claimed they were in ignorance of it, and the question was whether they were guilty of conspiracy, having no intent to do an illegal act, and the Court of Appeals decided that the verdict could not stand. The Court. because the court below had instructed the jury that whether what they did was done in ignorance or with knowledge, it made no difference. Mr. Ingersoll: Certainly, it made no difference. Everybody is supposed to know the law. Now the next point is, and great weight has been put upon it, gentlemen, that concurrence of action establishes conspiracy. That if one does a part and another part, and finally the culmination comes, that is absolute evidence, or in other words, an inference. Admitting now that they were perfectly honest, if any of these parties made a bid, that bid had to be accepted by the government. They had to act together. The department and the man had to act together to have the bid accepted. The department and the man had to act together to make the contract. The department and the man had to act together to get the pay, and no matter how perfectly honest the transaction was, they had to act together from the first step to the payment of the last dollar. Now, in a business where they do have to act together, where one necessarily does one thing and the other necessarily does another, the fact that that happens does not even tend to prove that there is any fraud. Upon this concurrence of action, I refer to the case of Metcalf against O'Connor and wife, in Little's Select Cases, 497. One of the men confessed that a large party went to the house where there was a disturbance, and where they tried to take by force a boy from the custody of a man and woman. Now the fact that these men did go to the house, the fact that they were there at the time this happened, and the fact that one of the conspirators, or one of the trespassers, had confessed that he went there, and that the other went with him for that purpose, the court decides that you cannot infer the purpose of these men from the statement of the other. Neither can you infer it from the fact that they were there. You must find out for what purpose they were there by ascertaining what they did and when they were there, and that concurrence in actions shows nothing. The Court: Did you not say that the decision there was that the conspiracy might be inferred from the combination to do the act? Mr. Ingersoll: I will just read it, and then there will be no guessing about it. Quote, This is a writ of error prosecuted by the defendants to a judgment for the plaintiffs in an action of trespass for an assault and battery alleged to have been committed upon the plaintiff, Anne, the wife of the other plaintiff. We are of the opinion that the Circuit Court erred in refusing to instruct the jury, at the instance of the defendants, to find for all of them, except for the defendant Metcalf. He is the only one of the defendants proven to have touched the defendant Anne, and against the other defendants there is no evidence conducing in the slightest degree to prove them guilty of committing any assault or battery upon her, or of any intention to do so. It is true that it was proved that the other defendants confessed that they were at the house of Connor when the assault and battery charged is alleged to have been committed, and it was also proved that Metcalf confessed that he and the other defendants had gone there for the purpose of taking from Connor by force an idiot boy whom he had in his custody. But the circumstances of the other defendants being at Connor's house, there is no evidence they were there for any unlawful purpose, nor can it itself be sufficient to render them responsible for any act done by Metcalf in which they did not participate, and the confessions of Metcalf are certainly not legitimate evidence against the others to prove the unlawful purpose with which they went to Connor's, and thereby to charge them with the consequences of his act. End quote. Now, to all appearances, they went there together. To all appearances, they went there for the one purpose, and Metcalf, the man who really did the mischief, confessed that they all went there for the one purpose, but the court held that that was not sufficient. Quote, Where several agree or conspire to commit a trespass, or for any other unlawful purpose, they will, no doubt, all be liable for the act of any one of them done in execution of the unlawful purpose, and when the agreement or conspiracy is first proved by other evidence, the confession of one of them will be admissible evidence against the others. But it is well settled that the confession of one person cannot be admitted against the others to prove that they had conspired with him for an unlawful purpose." Now, the next evidence that I wish to allude to, gentlemen, is the evidence of Mr. Walsh, and I will only say a few words, because it has been examined, and it has been ground to powder. Everything in this world is true in proportion that it agrees with human experience, and you can safely say that everything is false, or the probability is that it is false, in proportion that it is not in accordance with human experience. Other things being equal, we act substantially alike. Now, when anything really happens, everything else that ever happened will fit it. You take a spar crystal. I do not care how far north you get it, and another spar crystal, no matter how far south you get it, and put them together, and they will exactly fit each other. Exactly. The slope is precisely the same, and it is so with facts. Every fact in this world will fit every other fact, just exactly. Not a hair's difference. But a lie will not fit anything but another lie made for the purpose. Never. It never did. And finally there has to come a place where this lie, or the lie made for the sake of it, has to join some truth. And there is a bad joint always. And that is the only way to examine testimony. Is it natural? Does it accord with what we know? Does it accord with our experience? Now take the testimony of Mr. Walsh, and I find some improbabilities in it. Just let me read you a few. 1. Bankers and brokers do not, as a rule, loan money without taking at least a note. That is my experience. And the poorer this broker is, the less money he has, the more security he wants. He not only wants an endorser, but he would like to have a mortgage on your life, liberty, and pursuit of happiness. That is the first improbability. 2. Bankers and brokers do not, as a rule, take notes that bear no interest, or in which the interest is not stated. People who live on interest find it always to their interest to have the interest mentioned, always. I never got a cent of a banker that I did not pay interest, and generally in advance. 3. Bankers and brokers do not, as a rule, take notes payable on demand, because such notes are not negotiable. 4. It is hardly probable that when a banker and broker holds the note of another for $12,000, the note being unpaid, he would loan $13,500 more, taking another note on demand in which the rate of interest was not stated. 5. It is still more improbable that the same banker and broker, with a note for $12,000 and one for $13,500 being unpaid, would loan $5,400 more without taking any note or asking any security. 6. When such banker and broker called upon his debtor for a settlement and exhibited the two notes, and thereupon his debtor took the two notes and put them in his pocket, it is highly improbable that the banker and broker would submit to such treatment. 7. It is improbable that such banker and broker would afterwards commence suit to recover the money, without mentioning to his attorney in fact that the notes had been taken away from him. 8. It is also improbable that the banker and broker would commence another suit for the same subject matter and still keep the fact that the notes had been taken from him by violence, a secret from his attorney. 9. If Mr. Brady took the notes by force, it is improbable that he would immediately put himself in the power of the man he had robbed by stating to him that he, Brady, was in the habit of taking bribes. 10. It is impossible that Mr. Brady could, in fact, have done this, which amounted to saying this, quote, "I have taken $25,500 from you. Of course you are my enemy. Of course you will endeavor to be revenged, and I now point out the way in which you can have your revenge. I am Second Assistant Postmaster General. I award contracts, increases, and expedition, and upon these I receive 20% as a bribe. I am a bribe taker. I am a thief. Make the most of it. I give you these tacks in order that I may put a weapon in your hands with which you can obtain your revenge." End quote. There are also other improbabilities connected with this testimony. If Mr. Brady was receiving 20% of all increases and expeditions, amounting to hundreds of thousands of dollars per annum, it is not easy to see why he would be borrowing money from Mr. Walsh. Now, if that story is true, boil it down, and it is this, because if he got this 20% from everybody he had oceans of money. Boil it all down, and it is this. A rich man borrows without necessity, and a poor banker loans without security. These twin improbabilities would breed suspicion and credulity itself. No man ever believed that story, no man ever will. There is something wrong about it somewhere, unnatural, improbable. And it is for you to say, gentlemen, whether it is true or not for me. What is the effect of that testimony? So far as my clients are concerned, it is admitted, I believe, by the prosecution, it was also stated, I believe, by His Honor from the bench, that it could not by any possibility affect any defendant except Mr. Brady, and the question now is, can it even affect him? I call the attention of the court to 40th New York, page 228. I give the page from which I read. Quote, "To make such admissions or declarations competent evidence, it must stand as a fact in the cause, admitted or proved, that the assigner or assignees were in a conspiracy to defraud the creditors. If that fact exist, then the acts and declarations of either, made in execution of the common purpose and in aid of its fulfillment, are competent against either of them. The principle of its admissibility assumes that fact." End quote. That the conspiracy has been established. Quote, "In case of conspiracy where the combination is proved, the acts and declarations of the conspirators are not received as evidence of that fact, but to show what was done, the means employed, the particular design in respect to the parties to be affected or wronged, and generally those details which, assuming the combination and the illegal purpose, unfold its extent, scope, and influence either upon the public or the individuals who suffer from the wrong, or show the execution of the illegal design. But when the issue is simply and only, was there a conspiracy to defraud, these declarations do not become evidence to establish it. So far, then, as the admission of the evidence in this case, of declarations subsequent to the assignment, is sought to be sustained as evidence of the common fraud, on the ground of conspiracy, the argument wholly fails. A conspiracy cannot be proved against three by evidence that one admitted it, nor against assignees by proof that the assigner admitted it. It is a fact that must be proved by evidence, the competency of which does not depend upon an assumption that it exists." End quote. So to the same point is the case of Cowles against Coe, 21st Connecticut 220. I will read that portion of the syllabus that conveys the idea. Quote, "To prove the alleged conspiracy between the defendant and G, the plaintiff offered the declaration of R, stating declarations made by G to R while G was engaged in purchasing goods of him on credit, and relative to G's responsibility and means of obtaining money through the defendant's aid. These declarations were objected to, not on the ground that the conspiracy had not been sufficiently proved, but because the defendant was not present when they were made. It was held that they were admissible, within the rule regarding declarations made by a conspirator in furtherance of the common object." End of Ingersoll's closing address to the jury in the first Star Route trial, Part 6 of 7. Read by Roger Melin. Chapter 2, Part 7 of the Works of Robert G. Ingersoll, Volume 10. Ingersoll's closing address to the jury in the first Star Route trial, Part 7 of 7. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roger Melin. Part 7. Now let us see what the court says about it. Quote, "The remaining question is whether the declaration of Gale to Edmund Curtis and William Ives were properly received. These declarations were not offered as in any way tending to prove the combination claimed. The motion shows that they were offered and received after the plaintiff's evidence on that subject had been introduced. Had they been admitted for that purpose, or if, under the circumstances, they could have had any influence with the jury on that point, we should feel bound to advise a new trial on this account." End quote. All that I have said in respect to Walsh applies to what is known or what is called the confession of Rerdell. It was admitted by the prosecution that not one word said by him could bind any other defendant in the case. But, gentlemen, is there enough even to bind him? Did he confess that he was guilty of the conspiracy set forth in this indictment? And I want to make one other point. In this case there must be not only a conspiracy, but an overt act, and no man can confess himself into it without confessing that he was a conspirator, and that he knew that an overt act was to be done, because it takes that conspiracy and the overt act to make the offense. What overt act did Rerdell confess that he was guilty of? What overt act charged in this indictment? 1. Filing a subcontract. And by no earthly method, by no earthly reasoning, can you come to the conclusion that that could carry it into conspiracy. He must have confessed that he was guilty according to the scheme, according to the indictment set forth, and in no other way. That indictment says that the money was to be divided, that it was for the mutual benefit of certain persons. Unless that has been substantiated, this case falls. According to the case of the King against Pommel, the scheme of the indictment must be established, otherwise the case goes. In that case they charged it was one way, and they proved it was that way. And one of the defendants did not understand it that way, and he was acquitted. Now, suppose they had not proved the scheme as they charged it. Then all would have been acquitted, and unless the jury believed beyond a reasonable doubt, from the evidence that the scheme set forth in the indictment, here was the scheme, then they must find everybody not guilty. There is no other way. What is the next argument? The next argument is extravagance. What is extravagance? If I pay more for a thing than it is worth, that is extravagance. If I buy a thing that I do not want, that is extravagance. And if I do this knowing it to be wrong, if I do this understanding that I am to have a part of the price, that is bribery, that is corruption, that is rascality. Nobody disputes that. How do you know that a thing is extravagant unless you know the price of it? For instance, an army officer is charged with extravagance in buying corn upon the plains at $5 a bushel. How do you prove it is extravagance? You must prove that he could have obtained it for less, or that there was a cheaper substitute that he should have obtained. How are you going to prove that too much was paid for carrying the mail upon these routes? Only by showing that it could have been carried for less. What witness was before this jury, fixing the price? How are we to establish the fact that it was extravagance? We must show that it could have been obtained for less money. What witness came here and swore that he would carry it for less? And would it be fair to have the entire case decided upon one route when it is in evidence that my clients had 30% of 126 routes? Would it be fair to decide the question whether they had made or lost money on one route? Your experience tells you that upon one route they might make a large sum of money, and upon several other routes lose largely. A man who has bid for 100 routes takes into view the average and says, "Upon some I shall lose and upon others I shall make." How are you to find that this was extravagance unless you know what it could have been done for? They may say that they subcontracted some of the routes for much less. Yes, but what did they do with the rest of them? I might take a contract to build a dozen houses in this city, and on the first house make $10,000 clear, and on the balance I might lose $25,000. You have a right to take these things and to average them. When a man takes a contract, he takes into consideration the chances that he must run in that new and wild country. It takes work to carry this mail. You ought to be there sometimes in the winter when the wind comes down with an unbroken sweep of 3,000 or 4,000 miles, and then tell me what you think it is worth to carry the mail. All these things must be taken into consideration. Another thing. You must remember that every one of these routes was established by Congress. Congress first said, quote, "Here shall be a route. Here the mail shall be carried." End quote. It was the business then, I believe, of the first Assistant Postmaster General to name the offices, and the second assistant to put on the service. Take that into consideration. Every one of these routes was established by Congress. Take another thing into consideration, that the increase of service and expedition was asked for, petitioned for, begged for, and urged by the members of both houses of Congress, and according to that book which I believe is in evidence, a majority of both houses of Congress asked, recommended, and urged increase of service and expedition upon some of the 19 routes in this indictment. The Court: What evidence do you refer to? Mr. Ingersoll: I refer to the Star Route investigation in Congress. The Court: That record is not in evidence. Mr. Ingersoll: I thought that was in evidence. The Court: No, sir. Mr. Ingersoll: It was used as if it was in evidence. I saw people reading from it and supposed it was in evidence. The Court: It is not in evidence. Mr. Ingersoll: Well, we will leave that out. Now, upon these 19 routes, this is in evidence, increase and expedition of service were recommended by such senators as Booth, Farley, Slater, Grover, Chaffee, Chilcott, Saunders, and by the present Secretary of the Interior, Henry M. Teller, and by such members of Congress as Whitaker, Page, Luttrell, Pacheco, Berry, Belford, Bingham, Chairman of the Post Office Committee, by Stevens of Arizona, a delegate, and by McGinnis of Montana, and Kidder of Dakota, by Generals Sherman, Terry, Miles, Hatch, and Wilcox. In addition to these, recommendations were made and read by judges of courts, by district attorneys, by governors of territories, by governors of states, and by members of state legislatures, by colonels, by majors, by captains, and by hundreds and hundreds of good, reputable, honest citizens. They were the ones to decide as a matter of fact whether this increase was or was not necessary. I believe in carrying the mails. I believe in the diffusion of intelligence. I believe the men in Colorado or Wyoming or any other territory that are engaged in digging gold or silver from the earth or any other pursuits have just as much right, in the language of Henry M. Teller, to their mail as any gentleman has to his in the city of New York. We are a nation that believes in intelligence. We believe in daily mail. That is about the only blessing we get from the general government, excepting the privilege of paying taxes. Free mail, substantially free, is a blessing. Now there is another argument which has been used: productiveness. But that has been so perfectly answered that I allude to it only for one purpose. How would the attorneys for the government in this case like to have their fees settled upon that basis? Productiveness. Is it possible that this government cannot afford to carry the mail? Is it possible that the pioneer can get beyond the government? Is it possible that we are not willing to carry letters and papers to the men that make new territories and new states and put new stars upon our flag? I have heard all I wish on the subject of productiveness. Now, gentlemen, that is all the evidence there is in this case that I have heard. What kind of evidence must we have in a conspiracy case? You have been told during this trial that it is very hard to get evidence in a conspiracy case, and therefore you must be economical enough to put up with a little. They tell you that this is a very peculiar offense, and people are very secret about it. Well, they are secret about most offenses. Very few people steal in public. Very few commit offenses who expect to be discovered. I know of no difference between this offense and any other. You have got to prove it. No matter how hard it is to prove, you must prove it. It is harder to convict a man without testimony, or should be, than to produce testimony to prove it if he is guilty. All these crimes, of course, are committed in secret. That is always the way. But you must prove them. There is no pretense here that there is any direct evidence, any evidence of a meeting, any evidence of agreement, any evidence of an understanding. It is all circumstantial. I lay down these two propositions. Quote, "The hypothesis of guilt must flow naturally from the facts proved, and be consistent, not with some of the facts, not with a majority of the facts, but with every fact." End quote. Let me read that again. Quote, "The hypothesis of guilt must flow naturally from the facts proved, and must be consistent with them, not some of them, not the majority of them, but all of them." End quote. The second proposition is, quote, "The evidence must be such as to exclude every single reasonable hypothesis except that of the guilt of the defendant. In other words, all the facts proved must be consistent with and point to the guilt of the defendants not only, but every fact must be inconsistent with their innocence." End quote. That is the law, and has been since man spoke Anglo-Saxon. Let me read you the last proposition again. I like to read it. Quote, "The evidence must be such as to exclude every reasonable hypothesis except that of the guilt of the defendants. In other words, all the facts proved must be consistent with and point to the guilt of the defendants not only, but they must be inconsistent, and every fact must be inconsistent with their innocence." End quote. Now, just apply that law to the case of John W. Dorsey. Apply that law to the case of Stephen W. Dorsey. Let me read further I read now from 1 Bishop's Criminal Procedure, paragraph 1077. Quote, "It matters not how clearly the circumstances point to guilt, still if they are reasonably explainable on a theory which excludes guilt, they cannot satisfy the jury beyond reasonable doubt that the defendants are guilty, and hence they will be insufficient." End quote. Just apply that to the case of Stephen W. Dorsey and John W. Dorsey. I would be willing that this jury should render a verdict with that changed. Change it. You are to find guilty if you have the slightest doubt of innocence. Even under that rule you could not find a verdict of guilty against John W. or Stephen W. Dorsey. If the rule were that you are to find guilty if you have a doubt as to innocence, you could not do it. How much less when the rule is that you must have no doubt as to their guilt? The proposition is preposterous, and I will not insult your intelligence by arguing it any further. Now then, there is another thing I want to keep before you. When a man has a little suspicion in his mind, he tortures everything. He tortures the most innocent actions into the evidence of crime. Suspicion is a kind of intellectual dye that colors every thought that comes in contact with it. I remember I once had a conversation with Surgeon General Hammond in which he went on to state that he thought many people were confined in asylums, charged with insanity, who were perfectly sane. I asked him how he accounted for it. Said he, quote, "Physicians are sent for to examine the man, and they are told before they get to him that he is crazy. Therefore, the moment they look upon him, they are hunting for insane acts, and not sane acts. They are looking not to see how naturally he acts, but how unnaturally he acts." End quote. They are poisoned with the suspicion that he is insane, and if he coughs twice, or if he gets up and walks about uneasily, his mind is a little unsettled. Something wrong. If he suddenly gets angry, sure thing. When a man believes himself to be, or knows himself to be sane, and is charged with insanity, the very warmth, the very heat of his denial will convince thousands of people that he is insane. He suddenly finds himself insecure, and the very insecurity that he feels makes him act strangely. He finds in a moment that explanation only complicates. He finds that his denial is worthless, that his friends are suspicious, and that under pretense of his own good he is to be seized and incarcerated. Many a man as sane as you or I has under such circumstances gone to madness. It is a hard thing to explain. The more you talk about it, the more outsiders having a suspicion are convinced that you are insane. It is much the same way when a man is charged with crime. It is heralded through all the papers, quote, "This man is a robber and a thief." End quote. Why do they put it in the papers? Put anything good in a paper about Mr. Smith, and Mr. Smith is the only man who will buy it. Put in something bad about Mr. Smith, and they will have to run the press nights to supply his neighbors with copies. The bad sells. The good does not. Then you must remember another thing, that these papers are large, some of them several hundred columns, for all I know, 60 or 100. Just imagine the pains it would take and the money it would cost to get the facts enough to fill a paper like that. Economy will not permit of it. They publish what they imagine they can sell. As a rule, people would rather hear something bad than something good. It is a splendid certificate to our race that rascality is still considered news. If they only put in honest actions as news, it would be a certificate that honesty was rare. But as long as they publish the bad as news, it is a certificate that the majority of mankind is still good. Now, to be charged with a crime, and to be suddenly deserted by your friends, and to know that you are absolutely innocent, is almost enough to drive the sane man mad. I want you to think what these defendants have suffered in these long months. If the men who started this prosecution, if the men who originally poisoned the press of the country, feel that they have been rewarded simply because innocent men have suffered agony, let them so feel. I do not envy them their feelings. There is another thing, gentlemen. The prosecution have endeavored to terrorize this jury. The effort has been deliberately made to terrorize you, and every one of you. It was plainly intimated by Mr. Kerr that this jury had been touched, and that if you failed to convict, you would be suspected of having been bribed. That was an effort to terrorize you, and the foundation of that argument was a belief in your moral cowardice. No man would have made it to you unless he believed at heart you were cowards. What does that argument mean? I cannot say whether you will be suspected or not, but in my opinion, a juror in the discharge of his duty has no right to think of any consequence personal to himself. That is the beauty of doing right. You need not think of anything else. The future will take care of itself. I do not agree with the suggestion that it is better that you should be applauded for a crime than blamed for a virtue. Suppose you should gain the applause of the whole United States by giving a false verdict. How would the echo of that applause strike your heart? I do not believe that it is wiser to preserve the appearance of being honest than to be honest with the appearance against you. I would rather be absolutely honest, and have everybody in the world think I was dishonest, than to be dishonest, and have the whole world believe in my honesty. You see, you have got to stay with yourself all the time. You have to be your own company, and to be compelled to know that your company is dishonest, that your company is infamous, is not pleasant. I would rather know I was honest and have the whole world put upon the forehead of my reputation the brand of rascality. You were also told that the people generally have anticipated your verdict. That is simply an effort to terrorize you, so that you will say, quote, "If the people think that way, of course we must think that way. No matter about the evidence, no matter if we have sworn to do justice, we will all try and be popular." End quote. You were told, in effect, that the people were expecting a conviction, and the only inference is that you ought not to disappoint the public, and that it is your duty to piece and patch the testimony and violate your oath rather than to disappoint the general expectation. Mr. Merrick told you you were trying these defendants, but that the people of the whole country were trying you. What was the object of that statement? Simply to terrorize this jury. What was the basis of that statement? Why, that not one of you has got the pluck to do right. It was not a compliment, gentlemen. It was intended for one, no doubt, but when you see where it was born, it becomes an insult. I do not believe you are going to care what the people say, or whether the people expect a verdict of guilty or not. You have been told that they do. I might with equal propriety tell you that they do not. I might with equal propriety say there is not a man in this courthouse who expects a verdict of guilty. With equal propriety I might say, and will say, that there is not a man on this jury who expects there will be a verdict of guilty. But what has that to do with us? Try this case according to the evidence, and if you know that every man, woman, and child in the United States want an acquittal, and you are satisfied of the guilt of the defendants, it is your duty to find them guilty. If I were on the jury, I would, in the language of the greatest man that ever trod this earth, strip myself to death as to a bed that longing have been sick for, before I would give a false verdict. Again, Mr. Merrick said, after having stated in effect that a majority of the people were convinced of the guilt of the defendants, that the majority of the men of the United States do not often think wrong. What was the object? To terrorize you. That is all. This verdict is to be carried by universal suffrage. You are to let the men who are not on oath decide for the men who are. To let the men who have not heard the testimony give the verdict of the men who have heard the testimony. What else? Again, the same gentleman said, quote, "There is to be a verdict of the people for or against us." End quote. What is the object? To frighten you. Let the people have their verdict. You must have yours. If your verdict is founded on the evidence, it will be upheld by every honest man in the world who knows the evidence. You need certainly to place very little value upon the opinion of those who do not know the evidence. Mr. Merrick also suggested, I will hardly put it that way, he was brave enough to hope that you have not been bribed. Brave enough to hope that. All this, gentlemen, is done simply for the purpose of terrorizing you. I tell you to find a verdict according to the evidence, no matter whom it hits, no matter whom it destroys, no matter whom it kills. Save your own consciences alive. Your verdict must rest on the evidence that has been introduced, and all else must be thrown aside, disregarded, like forgotten dreams. All that you have read, all the press has printed, must find no lodgment in your brains. You must regard them no more than you would the noises of animals made in sleep. You must stand by the testimony. You must stand by the laws that the court gives you. That is all we ask. These articles in the newspapers were not printed in the hope that justice might be done. They were printed in the hope that you may be influenced to disregard the evidence, in the hope that finally slander might be justified by your verdict. Gentlemen, you ought to remember that in this case you are absolutely supreme. You have nothing to do with the supposed desires of any men, or the supposed desires of any department, or the supposed desires of any government, or the supposed desires of any president, or the supposed desires of the public. You have nothing to do with those things. You have to do only with the evidence. Here all power is powerless except your own. Position is not. If the defendants are guilty, and the evidence convinces you that they are, your verdict must be in accordance with the evidence. You have no right to take into consideration the consequences. When you are asked to find a verdict contrary to the evidence, when you are asked to piece out the testimony with your suspicions, then you are bound to take into consideration all the consequences. When appeals are made to your prejudice and to your fears, then the consequences should rise like mountains before you. Then you should think of the lives you were asked to wreck, of the homes your verdict would darken, of the hearts it would desolate, of the cheeks it would wet with tears, and of the reputations it would blast and blacken, of the wives it would worse than widow, and of the children it would more than orphan. When you are asked to find a false verdict, think of these consequences. When you are asked to please the public, think of these consequences. When you are asked to please the press, think of these consequences. When you are asked to act from fear, hatred, prejudice, malice, or cowardice, think of these consequences. But whenever you do right, consequences are nothing to you, because you are not responsible for them. Whoever does right clothes himself in a suit of armor that the arrows of consequences can never penetrate. When you do wrong, you are responsible for all the consequences, to the last sigh and the last tear. If you do right, nature is responsible. If you do wrong, you are responsible. You were told, too, by Mr. Merrick that you should have no sympathy, that you should be like icicles, that you should be godlike. A cool conception of deity. In that connection, this heartless language, as it appears to me, was used. Quote, "Man, when he undertakes to judge his brother man, undertakes to perform the highest duty given to humanity." End quote. Good. He should perform that duty without fear, without prejudice, without hatred, and without malice. He should perform that duty honestly, grandly, nobly. I read on. Quote, "Enclosed within the jury box or on the bench, he is separated from the great mass of mankind." End quote. Then you should not pay any attention to the opinion of the public. If you are separated, you should not be dominated by the press. If you are separated, you should not be disturbed by the desires of anybody. But he continues, quote, "and sentiments of brotherhood die away." End quote. About that time you would be nice men, quote, "standing above humanity and nearest God, he looks down upon his fellow and judges them without any reference to the sorrow his judgment may bring." End quote. This is not my doctrine. The higher you get in the scale of being, the grander, the nobler, and the tenderer you will become. Kindness is always an evidence of greatness. Malice is the property of small souls. Whoever allows the feeling of brotherhood to die in his heart becomes a wild beast. You know it, and so do I. Quote, "Not the king's crown nor the deputed sword, the marshal's truncheon nor the judge's robe, become them with one half so good a grace as mercy does." End quote. And yet the only mercy we ask in this case, gentlemen, is the mercy of an honest verdict. That is all. I appeal to you for my clients because the evidence shows that they are honest men. I appeal to you for my client, Stephen W. Dorsey, because the evidence shows that he is a man with an intellectual horizon and a mental sky, a man of genius, generous and honest. And yet this prosecution, this government, these attorneys representing the majesty of the Republic, representing the only real republic that ever existed, have asked you, gentlemen of the jury, not only to violate the law of the land, they have asked you to violate the law of nature. They have maligned mercy. They have laughed at mercy. They have trampled upon the holiest human ties, and they have even made light of the fact that a wife in this trial has sat by her husband's side. Think of it. There is a painting in the Louvre, a painting of desolation, of despair, and love. It represents the night of the crucifixion. The world is represented in shadow. The stars are dead, and yet in the darkness is seen a kneeling form. It is Mary Magdalene with loving lips and hands pressed against the bleeding feet of Christ. The skies were never dark enough nor starless enough. The storm was never fierce enough nor wild enough. The quick bolts of heaven were never lurid enough, and arrows of slander never flew thick enough to drive a noble woman from her husband's side. And so it is in all of human speech. The holiest word is wife. And now, gentlemen, I have examined this testimony. I have examined every charge in the indictment against my clients, not only, but every charge made outside of the indictment. I have shown you that the indictment is one thing and the evidence another. I have shown you that not one single charge has been substantiated against John W. Dorsey. I have demonstrated to you that not one solitary charge has been established against Stephen W. Dorsey. Not one. I believe that I have shown to you that there is no foundation for a verdict of guilty against any defendant in this case. I have spoken now, gentlemen, the last words that will be spoken in public for my clients, the last words that will be spoken in public for any of these defendants, the last words that will be heard in their favor until I hear from the lips of this foreman 2 eloquent words, "Not guilty." And now, thanking the court for many acts of personal kindness, and you, gentlemen of the jury, for your almost infinite patience, I leave my clients with all they have, and with all they love, and with all who love them, in your hands. End of Ingersoll's closing address to the jury in the first Star Route trial, Part 7 of 7. Read by Roger Melin.
Chapter 3, Part 1 of the Works of Robert G. Ingersoll, Volume 10. Ingersoll's opening address to the jury in the second Star Route trial, Part 1 of 5. This is the LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Washington, D.C., December 21st, 1882. May it please the court and gentlemen of the jury, we consider that the right to be tried by jury is the right preservative of all other rights. The right to be tried by our peers, by men taken from the body of the county, by men whose minds have not been saturated with prejudice, by men who have no hatred, no malice to gratify, no revenge to wreak, no debts to pay. We consider an inestimable right, regarding the jury as the bulwark of civil liberty. Take that right from the defendants in any case, and they are left at the mercy of power, at the mercy of prejudice. The experience of thousands of years, the experience of the English-speaking people, of the Anglo-Saxon people, the only people now upon the globe with a genius for law, is that the jury is a breastwork behind which an honest man is safe from the attack of an entire nation. We esteem it, I say, a privilege, a great and invaluable right, that we have you 12 men to stand between us and the prejudice of the hour. We believe that you will hear this case without passion, without hatred, and that you will decide it absolutely in accordance with the law and with the evidence. This is the tribunal absolutely supreme. In a case of this character, gentlemen, you are the judges of what is the law. You are the judges of what are the facts. You are the absolute judges of the worth of testimony. And you have not only the right, but it is your duty to utterly disregard the testimony of any man that you do not believe to be true. You, I say, are the exclusive judges, and for that reason we ask, we beg you to hear all this testimony, to pay heed to every word, and then decide, not as somebody else desires, but as your judgment dictates, and as your conscience demands. Hear before this jury all letters of attorneys general, all desires of presidents, all popular clamour, all prejudice, no matter from what source, is turned simply to dust and ashes, and you are to regard them all simply as though they never had been. There is one other thing. Some people are naturally suspicious. It is an infinitely mean trait in human nature. Suspicion is only another form of cowardice. The man who suspects constantly suspects because he is afraid. Whenever you find a man with a free, frank, generous, brave nature, you will find that man without suspicion. Suspicion is the soil in which prejudice grows, and prejudice is the upas tree in whose shade reason fails and justice dies. And allow me to say that no amount of suspicion amounts to evidence. No case is to be tried upon suspicion. No case is to be tried upon suspicious facts. No case is to be tried on scraps and patches and shreds and ravellings. There must be evidence. There must be absolute, solid testimony. A case is tried according to the rocks of fact, and not according to the clouds and fogs of suspicion. No juror has a right to make a decision until he feels his feet firmly fixed upon the bedrock of truth. So I say, gentlemen, that we are glad of the opportunity to make a statement of this case to you, and to tell you exactly the manner in which my clients became interested in what is known as the Star Route service. You have to be guided in this case by the indictment. That is the star and compass of this trial. You cannot go outside of it. The evidence must be confined to the charges contained in that instrument. If you find us guilty of a conspiracy, it must be such a conspiracy as is set forth in that indictment. That indictment is the charter of your authority, and you have no right to find us guilty of anything in the world except that which is therein charged. Now, let me give you an exceedingly brief statement of what we are here for. It is charged in that indictment that all these defendants, including one who has been discharged by a jury, who has been found not guilty, Mr. Turner, including another who is dead, Mr. Peck, conspired together for the purpose of defrauding the United States, and we are met at the threshold with the statement that conspiracy is very hard to prove. It is like any other offence, gentlemen. They say conspirators generally meet in secret. My reply to that is that people generally steal in secret, and the fact that they stole in secret was never deemed an excuse for not proving the offence before they were found guilty. You can see that this is precisely like any other offence in the world. Men, when they commit crimes, endeavour to get away from the public eye. They are in love with darkness. They do not carry torches in front of them, and it is so in every crime. But whether conspiracy is difficult to prove or not, it must be established before you can find the defendants guilty. That is a difficulty that the government must overcome by testimony. The jury must not endeavour to overcome it by a verdict. And I say here today that the same rule of evidence applies to this case as to any other, and you must be satisfied by the testimony the government will offer that these men conspired together, that they entered into an arrangement wherein the part of each was marked out, and that that arrangement was contrary to law, and that the object of that arrangement was to defraud the government of the United States. This indictment is kind enough to tell us the means that were employed to carry out that conspiracy. How did they find these means, gentlemen? They must have had some evidence on which they relied. If they had evidence enough to convince them, they must introduce that evidence here. And if that evidence establishes beyond a reasonable doubt that these men conspired, then you will find them guilty. Otherwise, not. The difficulty of establishing it is something with which you have nothing to do. How did they conspire? What were the means they had agreed to use? Let us see. Thomas J. Brady was the second Assistant Postmaster General. The Postmaster General was not included in the scheme. Consequently, they must deceive him. The sixth auditor was not included in this conspiracy, and as by virtue of his office it was his duty to go over all of these accounts and pass upon the legality of each item, it was necessary to deceive him. According to the indictment, Mr. Turner was a clerk in the department, and his part of the rascality was, on the jackets enclosing petitions, to make false statements in regard to the contents of the petitions enclosed. The object of that being that when the second Assistant Postmaster General, Mr. Brady, exhibited these jackets to the Postmaster General, it being considered that he would not have time to read the petition, he would be misled by the false statements on the cover touching the contents. The next step was for the contractors to get up false petitions. That is, petitions to be signed by persons who did not live along the route upon which the mail was to be carried. These petitions also to be forged, that is to say, the names of persons put there by another, or the names of fictitious persons written when in fact no such persons existed. The next thing to do was to write false and fraudulent letters, to induce others to write such letters. The next thing to make false affidavits, and the next thing to make false orders, those to be made by Mr. Brady, and these false orders were to have, as a false foundation, false petitions, false letters, false communications, false affidavits, and fraudulently written representations. That is the indictment. That is the scheme said to have been entered into by my clients with all of these defendants, and the object being to defraud the government of the United States. Now, in order to establish that scheme, it would be necessary for the government to prove it, not to assert it, neither have you the right to infer it. No man can be inferred out of his liberty. No man can be inferred into the penitentiary. That is not the way to deprive a man of his reputation and of liberty, by inference. They must prove it. They must prove that the petitions were false. They must prove that the letters were fraudulent. They must prove that the orders rested upon those false and fraudulent petitions, letters, and affidavits, and they must prove that Mr. Brady knew them to be false. It is also stated in this indictment that service was to be paid for when it was not performed. That service was discontinued and a month's extra pay allowed. That fines were imposed and afterwards set aside because the contractors agreed to pay 50% of such fines to General Brady. I will speak of them when I come to them. Now, there is a clear statement. What part, then, did my clients play in this scheme? I will tell you. It is charged in the indictment that John M. Peck was in this scheme, and although he is dead, whatever he did, I imagine, can be established by the government. A man can be found guilty I understand of having entered into a conspiracy with another, although the other be dead, and the living man can be convicted. Now, it is stated in the outset that my clients never had been engaged in carrying the mail, and that is regarded as an exceedingly suspicious circumstance. A man has got to commence some time, if he ever goes into the business, and if this doctrine be true, the first bid that a man ever makes is evidence that he has entered into a conspiracy. Suppose, on the other hand, my clients have long been engaged in this business. What would the government counsel then have said? They would have said, gentlemen, that they had been engaged for years in the business. They knew all the tricks that were played, and consequently they were the very persons to form a conspiracy. And that is the wonderful thing about suspicion. It changes every fact. It colours every word it reads and every paper at which it looks. And no matter what are the facts, the moment they are regarded with a suspicious mind, they prove what the man suspects. So then, the first charge is that we had never been in the business, and consequently our going into the business must have been the result of a conspiracy. Gentlemen, if the doctrine be laid down that it is dangerous for a man to make a bid, the result of that doctrine will be to double the expenses of the government in carrying the mails. All that will be necessary then is for the old bidders to combine. They will know that there is no danger of any new men interfering with them, because the new men will be immediately indicted for conspiracy, and the old men will have the field to themselves. You can see that this is infinitely absurd. There is only one step beyond such absurdity, and that is annihilation. No man can possess his faculties and get beyond that absurdity, if it is evidence of conspiracy, because it is the first thing. As a matter of fact, however, John M. Peck had been engaged in the mail business. He was engaged in the business before 1874. He had been interested with others before that time. He was interested in several important routes from 1874 to 1878. It was in the fall of 1877 that he made arrangements to bid at the next letting. He was a businessman. He was not an adventurer. He was secretary at that time of the Arkansas Central Railroad. He had been, I believe, for 2 sessions a member of the Arkansas legislature. He was in good standing, solvent, and regarded as an honest man. In 1874 he was interested in the bids, and, as I said, was engaged in carrying the mails at the time these contracts were entered into. He became acquainted with John W. Dorsey, I believe in 1874, when he made up his mind to put in more bids for the letting of 1878. He went after John W. Dorsey, and they met together in the city of New York, I believe in the month of September, and agreed that they would put in some bids for the letting of 1878. Peck was acquainted with John R. Minor, and had been acquainted with him for a considerable time. Mr. Minor wanted to go into some other business than that in which he was then engaged, and those 3 men made up their minds to bid. Was there anything criminal in that? Nothing. Any man anywhere have the right to combine, the right to form a partnership, the right to come together for the purpose of making proposals for carrying the United States mails. Of course you will all admit that. Now that is what they did. There was nothing criminal, Nothing secret, nothing underhanded. Everything was above board, open, and in the daylight. There is no conspiracy yet, and we will show that. John M. Peck had been troubled with a lung disease. He had gotten much better in September, and thought that he was almost well. Later in the fall he took a severe cold and got much worse, and from that difficulty, I believe, he never wholly recovered. He went, however, to Colorado and New Mexico and finally died. Now, let us see about John W. Dorsey. I believe that great pains have been taken to say that he was a tinsmith, which is a suspicious circumstance. Why? Is there any law against a tinsmith bidding to carry the mails? Is there any such provision in the statute? And yet that has been lugged forward as one of the evidences of a conspiracy in this case, and it has been lugged forward in a way to cast some disgrace upon this man, simply because he was a tinsmith. Well, do you know, I have as much respect for a good tinsmith as for a good anything. What is the difference? Sometimes I have thought I had more respect for a good tinsmith than a poor professional man. Sometimes. In this country, of all others, labor is held to be absolutely honorable, and I think 1,000 times more of a man who works in the street and takes care of his wife and children than I do of somebody else who dresses well and lives on the labor of others, and then is impudent enough to endeavor to disgrace the source of his own bread. I think the man who eats the bread of idleness is under a certain obligation to speak well of labor. And yet we have the spectacle in this very court of the Attorney General of the United States endeavoring to cast a little stain upon this man. As a matter of fact, and I am almost sorry to say it, John W. Dorsey is not a tinsmith. I am almost sorry to make the admission. He happened to be a merchant, which is no more honorable but somewhat easier. He dealt in stoves and tinware. That, gentlemen, is his crime, and upon that rests the terrible suspicion that he is a conspirator. And I want to say more, that his reputation for honesty, his reputation for fair dealing is as good as that of any other man in the state in which he resides. He made up his mind to cast his fortunes with John M. Peck and with John R. Minor, and make some bids for carrying the mails of the United States. That is all there is about it. There is, however, another suspicious circumstance, and that is that John W. Dorsey was the brother of Stephen W. Dorsey, and Stephen W. Dorsey at that time was a senator of the United States. That is another suspicious circumstance. Whenever you find a man with a senator for a brother, put him down as a conspirator. Another suspicious circumstance, John M. Peck was the brother-in-law of S. W. Dorsey, absolutely married a sister of Mrs. Dorsey, and that was the beginning of this hellish conspiracy. It was suspicious. He intended to rob the government when he was courting that girl. Now we come to another man, Mr. John R. Minor, and the suspicious thing about Minor is that he lives in Sandusky. But that of itself would be nothing. Dorsey lived there once too. Now do you not see how they moved to that town with the diabolical purpose of swindling this great government? Minor was not in very good health. Do you not see, pretended to be sick so that he could leave Sandusky, and in some way Minor and Dorsey were excellent friends. Another suspicious circumstance. And for several years, whenever John R. Minor visited Washington, he laid the foundations of this conspiracy by always stopping at the house of Senator Dorsey. Another suspicious thing. And do you not recollect the delight, the abandon with which Mr. Bliss emphasized the word house, when he said that they met at Dorsey's house? I had a great notion to get up and plead guilty on that emphasis. Minor came here. He and Peck were acquainted, and wherever you find four men acquainted, gentlemen, look out, there is trouble. When Minor came here, he went directly to the house of Senator Dorsey. I admit it, with all the damning consequences that flow from that admission. He did not even go to a hotel. He went directly to Dorsey's house. I want that in all your minds, because the prosecution regards that as one of the foundation facts in this conspiracy. And while admitting it, do you not see how much I save them in the way of evidence? And there is another damning fact connected with this case. Dorsey, in the top of his house, had set apart one room for an office. It was up 2 or 3 pair of stairs. I think he established his office there to shield himself a little from the people who usually call on a senator in the city of Washington. But he found he put himself to more trouble than he did them. So he moved his office to the lower part of the building. And when John Minor got to that house, he occupied a room next to that office upstairs, and sometimes he went in there and wrote. Now, you see, gentlemen, how that conspiracy was planted, how the branches sprang out of the windows of that room and covered all the territory of the United States. I might as well admit that frightful fact. I do not know that they know that, but I might as well admit it, because we want the worst to come first. Before Minor came here, he wrote a letter. There is another place to put a pin of suspicion. He wrote a letter to S.W. Dorsey. That is, it was Minor or Peck. I have forgotten which, and maybe that very forgetfulness of mine is another evidence of conspiracy. A letter was written either by Minor or Peck to Stephen W. Dorsey, saying that they were going to bid, that Peck was not well enough to be here at that particular time, and would he be kind enough to hand that letter to some man in whom he had confidence, and let that man get such information as he could with regard to the routes upon which they expected to bid. All these Western Star routes. Now, what did S.W. Dorsey do? There was a man in town by the name of Boone. He sent for Mr. Boone, and I believe that Mr. Boone went to Mr. Dorsey's house, and that Dorsey handed him that letter in his house. And what was the object of the letter? For Boone to get information regarding these routes. Well now, what did Boone do? Boone made up a circular which he sent to all the postmasters, or most of them, through Oregon, Washington Territory, Colorado, New Mexico, Nevada, California, Kansas, Nebraska. That is to say, the western states and territories. In this circular, a certain number of questions were propounded to each postmaster. First, the distance from that post office to the next, and from the next to the next, and so through the route. Second, the condition of the roads, whether hilly or level. Third, about the snows in winter and the floods in spring. Fourth, the cost of hay and corn and oats. Fifth, the wages that would have to be paid to the man or men. And it may be some other questions in addition. Now, these circulars were sent by Boone to all the postmasters in consequence of a letter that he received in Dorsey's house. What for? so that by the time that Miner and Peck and John W. Dorsey came, they could sit down and bid intelligently upon these routes, so that they would have some information that would guide them. In other words, that they would not be compelled to bid at random. Now we will show, gentlemen, that that was done, and if at that time there had been a conspiracy, certainly such information was of no particular value. Now, that is what Mr. Boone did, and I believe that is about all he did at that time. There is no conspiracy yet, no fraud yet. It is utterly impossible to defraud the government by getting information from postmasters as to the condition of the roads and as to the distance from one post office to another. There is no fraud yet, no conspiracy up to this point. In a little while Mr. Miner and Mr. John W. Dorsey appeared. But they say Stephen W. Dorsey was at that time a senator of the United States. Yes, he was, and I believe he remained senator until the 4th of March, 1879. When his brother came, we will show to you that Stephen W. Dorsey said to his brother, "I would rather you would not bid. I would much rather that you would keep out of this business, because I am a senator and somebody may find fault. Somebody may suspect, and consequently I would much rather you would get out of the business." John W. Dorsey did not agree with him. He said he did not see how that could interfere with him, and that he believed he could do well in that business. And the consequence was he went on. There is nothing suspicious, so far as I can see, in that. That is what we will show. This man, being a member of the United States Senate, did what he did out of pure friendship, did what he did for his brother, what he did for Mr. Peck, and what he did for Mr. Miner from pure friendship. I know it is very difficult for some people to imagine that any man does anything for friendship. They put behind every decent action the crawling snake of a mean and selfish motive. My opinion of human nature is somewhat different. I have known thousands and thousands of men capable of disinterested actions, thousands of men that would help a brother-in-law, or a friend, and help them to the extent of their fortune. I have known such men, and I never supposed such acts could be tortured into evidence of meanness. The first charge against Stephen W. Dorsey is that he sent some bonds and proposals for bids to a postmaster by name of Clendenning in the state of Arkansas. The trouble with these bonds, as I understand it, was that the amount of the bid was not put in the blank in the printed proposal. It is claimed by the prosecution that according to the law, the postmaster has no right to certify the solvency of the security until that blank is filled. I want to explain this so that you will understand it. I think I have one of the bonds and proposals here. I would like to have the court see exactly the scope of it. The proposal is that the undersigned, whose post office address is, and of the county of, and the state of, proposes to carry the mails of the United States from July 1st, such a date, to June 30th of such a date, being 4 years, between such and such a place, under the advertisement of the Postmaster General, for the sum of $, per annum. Now, if I understand the matter of the Clendenning bonds, they were filled up with the exception of the blank in which the amount of the bid was to be written. That is the charge as I understand it. Whenever a man makes a proposal to carry the mail for 4 years on a certain route, that proposal must be accompanied with a bond in a certain amount, and certain men must sign that bond as sureties. And then a certain postmaster must certify to the solvency of the sureties having made oath as to the value of their property. Now, Understand that perfectly. It is not the bond that a man gives after his bid has been accepted. It is a bond that he gives to show that his bid is in good faith. That bond is conditioned that if the contract is awarded to him, he will give another and sufficient bond not only, but I believe it is also conditioned that he will carry the mail. The charge is, and let us get at it just exactly, that some bonds were sent to a man by the name of Clendenning, who was a postmaster, and this blank was not filled. Let me tell you why. It was the custom, and I want your honour to understand that perfectly, because so much was made of it before in talk, to leave that blank unfilled. It is the blank for the amount of the bid. In the advertisement of the government, the penalty of the bond is stated, so that the amount of the bid has nothing to do with the penalty in the bond. Understand me now. If the bond was for $10,000, it was because that amount had been put in the advertisement by the government. It did not depend upon the amount of the bid. It had nothing to do with it. The amount of the bid threw no light upon the amount of the bond. The penalty of the bond was fixed by the government before the bid was made and inserted in the advertisement published by the government. Why then did they not wish to fill up this blank? This blank, gentlemen, told the amount of the bid. Where there are many bidders and an important route, if you let the postmaster who has to certify to the sureties know the amount of the bid he might sell you, he could go and tell somebody else. I have certified to all the sureties on this route, and the lowest bid up to this time is $15,000. And the person whom he told might go and bid $14,999 and take the route. But they say the postmaster is not allowed to tell the amount of the bid. No. What was the penalty if he did? He would lose his office. Now, here is a postmaster holding an office worth perhaps $100 a century, or perhaps $50 a year, and by selling information as to one bid, he might make $10,000. I do not know what he could have made. Certainly the bidders did not feel like trusting the secret of their bids to the postmaster who certified the sureties. As a consequence, the bond was filled up with the penalty according to the advertisement, but the blank in which the amount of the bid was to be written was not filled, because they wanted the postmaster's mind left a blank upon that subject. In other words, that the blank was left unfilled, not to defraud the government, but to prevent other people from defrauding the bidder. That is all there is about it. That is everything about the Clendenning bonds. But it may be well enough to state, gentlemen, that those Clendenning bonds were never used on a solitary route in this indictment, and I believe never anywhere, that no contract was ever awarded upon any of those proposals. The only rascality in the transaction, gentlemen, was the failure to fill a blank, and the reason they failed to fill that blank was because they did not want the postmaster to know the amount of the bid. Let us come right down to practical matters and things. For instance, suppose one of this jury is in the stone-cutting business, and the government should issue an advertisement calling for proposals to furnish dressed granite, and specify that every man who bid must file a bond in a penalty of $5,000 to carry out his contract, and that the bond must be approved by the postmaster here. Suppose it was a contract of great proportions. Would the man who bid be willing that the amount of the bid should be inserted in the blank to be passed upon by the postmaster? No. Why? He would not want the postmaster to know it. Who else would he not want to know it? He would not want his sureties to know it. A man might be standing by while the bond was being approved and read the amount of the bid. The bidder would be afraid somebody would get at those figures and go and underbid him. Every man of common, ordinary sense knows that. If you made a bid, you would not let your sureties know the amount, and you would not give the amount to the keeping of a postmaster, neither would you leave it to chance or accident. You would say, I will leave the amount a blank. I will keep it in my mind, and when the paper comes into my hands for the last time, I will write it in there and fold it and seal it and give it to the government. That is what every sensible and prudent man would do, and what has been done for years. And yet that act is brought forward as something to stain the reputation of an honest man, something to strike down as with a sword the character of an ex-senator. They even say he wrote upon paper that had the mark of the United States Senate chamber upon it. That is only another evidence that there was nothing wrong in it. It was stated, too, in the opening of this case, that an affidavit was made upon paper that bore the mark of the National Hotel of this city. Think of such a damning circumstance as that. Well, gentlemen, so much for the Clendenning bonds. We will prove that the blank was left unfilled on purpose, not to defraud the government, but to prevent other people from defrauding us. Let me say in that connection that there was an investigation in 1878 upon this very question. The Clendenning bonds were brought up. Testimony was heard, and we will be able to show you the facts that I have stated. Then, if I am right, gentlemen, there is nothing in it. And when the opening statement was made, the government knew just as well as I know that there was nothing in it. At least they ought to have known it. Probably it is not proper for me to say they knew it, because men get so prejudiced, so warped, so twisted, that it is hard to tell what they know or what they do not know. But that has nothing to do with this case, and in my judgment will never be admitted by the court. If it is admitted by the court, we will establish exactly what I have told you. So much of the Clendenning bonds. Do not forget that the penalty of the bond was put in by the government. Do not forget that the amount of the bid was left blank simply to protect ourselves. Do not forget another thing, that leaving that blank unfilled could not by any possible peradventure injure the government. The bond was just as good with that proposal unfilled at the time the sureties signed it, as though it had been filled. It had to be filled before it was finally given to the government, or else there would be no bid. If there was no bid, then no obligation rested upon the sureties. Certainly they could not be harmed, and if there was no bid, certainly the government could not be harmed, unless the bid should have happened to be lower than any received. And yet, out of that nothing, out of that one bramble, a forest of rascality has been manufactured. Gentlemen, that is the result of suspicion when it is hoed by malice and watered by hatred.
This ends Chapter 3, Part 1 of 5. Read by Edward Kirkby, Warwick, England. Chapter 3, Part 2 of the works of Robert G. Ingersoll, Volume 10. Ingersoll's opening address to the jury in the Second Star Route trial. Part 2 of 5. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. The next suspicious circumstance, gentlemen, is that we bid. That is a suspicious circumstance. Minor bid, Peck bid, and John W. Dorsey bid. And the suspicious circumstance is that they did not bid against each other. Why should they? I was at an auction the other day and unconsciously bid against myself.
But I did not think it any evidence of rascality on my part. I thought it tended to show that I was not attending strictly to business. And yet it is brought forward as a suspicious circumstance that these gentlemen did not bid against themselves. Another suspicious circumstance is that they bid in their individual names. That is the way all the bidding is done, I believe. I believe every bond has to be signed by the individuals and not by any partnership. That I believe to be one of the regulations of the department. Well, there is no rascality yet, as far as I can see. Now, when the contract is accepted, I will come to the bidding question again. The contractor has to give a bond. One of those bonds will be put in evidence in this case. You will see what the contractor is bound to do. Then it can be subcontracted. You will find that the contract given by the subcontractor to the department is not 1/100th part as severe as the bond the contractor gives to the government. In the contract that we give to the government, certain things are provided. You will find that a copy of it will be introduced. The contractor is left to the mercy of discretion. I believe that is the word of the Postmaster General. You will find that if he fails to carry the mail one trip, no matter by what he may be prevented, by flood or storm or fire, he is not to be paid for it. Although he is there ready with his men and horses, if he is prevented by the elements, he has no pay. If the Postmaster General thinks he ought to have carried it when he did not, he can take from his pay 3 times the value of the trip. He can take from him 1/4's pay. He reserves in his own breast the power to declare the contract null and void, because in his judgment the contractor has not done his duty. Everything is left to him. The man who signs that contract gives a mortgage on his life, liberty, and pursuit of happiness. He has no redress. I simply call your attention to this to show you the obligation that a contractor takes upon himself. We will show you that he is under obligation to discharge any carrier that the government does not like. That he has no right to carry any package or any letter that can go by mail. That he is to forfeit a trip when it is not run, or not to exceed 3 times the pay of a trip. That he is to forfeit 1/4 of a trip if the running time is so far behind that he fails to make connection with the next mail. That if he violates any of these provisions, he forfeits a penalty equal to 1/4's pay. Or if he violates any other provision touching the carriage of the mail and the time and manner thereof, without a satisfactory explanation in due time to the Postmaster General, he can visit a penalty in his discretion, and the forfeitures may be increased in the penalty to a higher amount, in the discretion of the Postmaster General, according to the nature or frequency of the failure and the importance of the mail, provided that, except as specified and except as provided by law, no penalty shall exceed 3 times the pay of a trip in each case. It is also agreed by the said contractor and his sureties that the Postmaster General may annul the contract for repeated failures, for violating the postal laws, for disobeying the instructions of the Post Office Department, for refusing to discharge a carrier when required by the department, for transmitting commercial intelligence or matter which should go by mail, for transporting persons so engaged as aforesaid, whenever the contractor shall become a postmaster, etc. It is further stipulated and agreed that such annulment shall not impair the right to claim damages from said contractor and his sureties under this contract. But such damages may, for the purpose of set-off or counter-claim in the settlement of any claim of said contractor or his sureties against the United States, whether arising under this contract or otherwise, be assessed and liquidated by the Auditor of the Treasury for the Post Office Department. And it is further stipulated and agreed by the said contractor and his sureties that the contract may, in the discretion of the Postmaster General, be continued in force beyond its express terms for a period not exceeding 6 months. You will see, gentlemen, how perfectly, how absolutely the contractor is in the power of the department. The government enforces its contracts. No matter how many years may elapse, they are still after the sureties and are still after the principal. Nothing relieves a man but death. Only a little while ago a case was decided in the Supreme Court of which I will speak to you. An importer of sugar gave the importer's bond to pay the duty upon that sugar. By the custom of trade, sugar is sold in bond. The importer sold to a third person, and the third person went to get the sugar. By law, he could only take it after paying the tax, and yet one of the officers of the government, contrary to law, allowed him to take the sugar without paying the tax. The Supreme Court has just held that the original importer and his sureties are liable to pay that tax. The man who took the sugar out, having become bankrupt, although the sugar was given to the second party simply by a violation of law, and that law was violated by one of the officers of the custom house without the knowledge or consent of the original importer. I tell you, gentlemen, whenever a man gives a bond to this government, the government stays with him. The government does not die. The government does not get tired. The government does not get weary. The government can afford to wait, and the poor man with the bond hanging over him cannot go into business, cannot get credit, but just lingers out a life of expectation, of hope, and of disappointment. I trust none of you will ever sign a bond to the government. There is another thing, gentlemen. If you bid on 100 routes and they are given to you, and you put the service on 99 of the routes and carry it in accordance with the contract, and yet fail on the 100th route, the Postmaster General has a right to declare you a failing contractor. A failing contractor on the 100th route? Yes. On any more? Yes. On every one. And whoever is declared a failing contractor on one route is, by virtue of that declaration, a failing contractor on all. They are all taken from him. So that when a man bids for more than one route, for instance 100 or 1,000, and gets them and carries them all absolutely according to his contract but one, he can be declared a failing contractor on all. What does that mean? It means not simply ruin to him, but ruin to every one of his sureties, unless they are in a condition to go on and carry the mail. I want you to understand something of the obligation of a contractor with the government of the United States. Now, I come to the bidding. These bids were made with a full understanding of the obligation of a bidder. Messrs. Minor, Peck, and John W. Dorsey bid, I believe, on about 1,200 routes. You see, you are in great luck in bidding if you get one route in 50 that you bid upon. In the first place, there are about 10,000 star routes. I do not know that it is too much to say that the number of bids runs up into the hundreds of thousands, somewhere in that neighborhood. Hundreds of men often bid on one route.
Consequently, nobody who bids expects to get more than a few of the routes for which they bid. Now, is there the slightest evidence in the statement of the government as to the frauds in this bidding? Let me tell you how some frauds have been committed. Suppose, for instance, this was a fraudulent business, and Miner, Peck, and Dorsey were bidding. Let me explain it to you. I want you to know it all. All there is in this case is simply to have you understand it. That is all there is. And if you do not agree with me when we get through the case, I shall simply think that you have not comprehended it. Say that 4 men bid on the same route. One man $4,000, another man $3,000, another man $2,000, and another man $1,000. Now, the man who bids $1,000 is of no account, has not a dollar in the world, and so when the bid is given to him, he does not want it. He is what they call a straw man. The law provides then that the next man may have it. The law does not provide that he must take it. He may have it if he wants to, but you cannot force him to take it because he is not the lowest bidder. He is the $2,000 man. He is another straw gentleman. He does not want it. Then the government offers it to the next man at $3,000. He is another chap made of hay. He says he doesn't want it. Understand, the government cannot force these straw and hay men to take it. Then they go to the 4th fellow, who bid $4,000. It is a good thing at $4,000, and he says, yes, I will take it. That is what they call fraudulent bidding. If you had found Dorsey and Miner and Peck bidding on the same route, and one of them failing and another one taking it, you would not only have suspected fraud, but you would have known it. Now, if it is a badge of fraud for them to bid upon the same route and apparently against each other, I will ask you if it is not a badge of fair dealing that they were not found bidding against each other. They bid on about 1,200 routes, and much to their astonishment, they got 134 contracts. You have heard here a great deal of talk about the number of men and horses. We will show you all about it. Men differ upon this subject. If men did not differ upon it at all, these bids would be alike. Instead of being a dozen bids, all different, and differing sometimes as much as $10, $20, $30, $40, or $100 or more, they would bid the same. If they are all agreed on the number of horses and men it would take, and about what it would cost, they would bid about alike, wouldn't they? But when they are bidding, they honestly differ. One man says it would take 20 horses, and another says, no, it will take 40. Do you not know that the number of horses depends a great deal upon the kind of man who makes the estimate? Here is a man who is hard and brutal, and he says a horse can do so much work. He says it is cheaper to buy him and wear him out than it is to feed him decently. You have known men who were perfectly willing to make fortunes out of a horse's agony and out of animal pain. There are hundreds of them in the world. Now, take it on horse railroads and with freighters and teamsters. Whenever you find a mean, infamous man, if he cannot whip his wife, he will take his spite out on his horse. If a man is a good, broad, generous, free fellow, he will say, I don't want to work that horse to death. I think it will take 4 horses. I'm going to keep my horses fat, and I'm going to treat them as a gentleman should. Another man, a wretch, will come up and swear it would not take more than 15 horses.
When his horses are through the service, you will simply see a pile of bones wrapped in a lamentable hide. You understand that? Well, these men made 1,200 bids and got 134 contracts. Ah, but they say, here is another badge of fraud. Another badge. Ah, they bid on small routes, on cheap routes, on routes where the mail was carried infrequently, and on slow time. If it is a badge of fraud to bid on such routes, the government can never let out any more. Most of these routes were cheap routes. Now, I owe it to you to give you the reason for this. We will prove in the first place that these men were not rich men. If they had been very rich, they probably would not have gone into the business at all. They would have gone into that perfectly respectable business of buying government bonds. They would have bought government bonds and made other fellows pay the interest, and twice a year they would have formed a partnership with a pair of shears, and thus in the sweat of their faces they would clip their coupons. They bid on poor routes. Why? They were poor, comparatively speaking. They had not the money to stock the expensive routes where 4-horse coaches were run. They preferred to take the cheaper lines. Why? Because they could stock them. They would have been able to have stocked the routes if they had only obtained the number they expected. But as I told you, they got many more routes than they expected. Was that for the benefit of the government? How did these men come to bid so cheaply on some of these routes? I will tell you. Because they had the information, because they had received the facts from all the postmasters on the routes, and consequently they made a good, close calculation, and the result was that their bids were below others, and the fact that their bids were accepted saved the government hundreds of thousands of dollars. When they found themselves with all these contracts, the first hard work they did was to give away all they could. That was the first hard work. They had contracts not for sale, but just to give, and they succeeded in giving away several of them. I believe they sold 2 of these children of conspiracy for the enormous sum of $100 each. That was the highest sale they made at that time. Afterwards, another route was sold, which I will explain when I come to it. Now, there is no rascality yet, no fraud yet, no conspiracy yet. Well, they then went to work to get their bonds. But first, let me say that there was another reason for bidding on cheap routes. Whenever the bid is above $5,000, then the man who bids must, at the time he bids, put up a check for 5% of the amount. A check certified by a national bank. For instance, if it all comes to $100,000, he has got to put in a certified check for $5,000. Even in the little bids we made, we had to deposit with the government some $26,000 or $28,000, and I do not know but more in cash, or what is the same as cash, for the bank certifies that the money is there. That is another reason they bid on smaller routes. What is next? The government asks such frightful bonds, such terrible amounts, that a man must be almost a millionaire, or else there must be a confidence in him that is universal, before he can give these bonds. There was one route at this very bidding where they had to give bonds for $640,000. And the sureties upon these bonds under oath had to testify that they had real estate to the value of $640,000, exclusive of all debts, dues, and demands. So there was another reason for bidding upon small routes. Where the amount was under $5,000, no certified check had to be deposited.
And the smaller the route, of course, the smaller the bond. Now, I have endeavored to show you the reasons that we bid upon these routes instead of upon the larger ones. The reasons, as stated by the government, are that we took these routes where the service was once a week, so that we could have the service increased. That we took these routes where the time was long, so that we could have it shortened. That is to say, expedited. But I tell you that when a perfectly good reason lies at the very threshold of the question, you have no right to go further. The reasons I have given to you, it seems to me, are perfect, and you need no more. Now then, we got, I say, about 134 routes. Of these, 115 are without complaint. There is not a word about the other 115. Recollect it. We got 134 routes. In this indictment are 19. 115 appear to be perfectly satisfactory to this great government. There is not a word as to those routes, not one word. I say as to 115 routes, and they want you to believe that these defendants deliberately selected 19 routes out of 134 about which to make a conspiracy, and that they left 115 to go honestly along, but picked out 19 for the purpose of defrauding the government. Now then, when these gentlemen found themselves with these routes, the next thing was to put the stock and the carriers upon them. As I told you, a good many more had been awarded to them than they anticipated. They had not the money. So, in putting the stock upon several of the routes, they found it necessary to borrow some money. And here comes another suspicious circumstance. Mr. Miner borrowed some money off Stephen W. Dorsey, and everybody is astonished that any man would be mean enough to loan money to another, that any man could so far forget the dignity of the office that he held as to help a friend. Their idea of a senator is of such a lofty and dignified character that he ceases to take interest in anything except national affairs, that after he has been sworn in he forgets all the relationships and friendships of the world, and the idea of asking him to loan money seems to the prosecution to be the height of unconstitutionality. But as a matter of fact, he did loan some money, and we will show you how that loan was treated, showing you that at that time he had not the slightest interest in it. He loaned some money and kept loaning money until, I believe, he had given them about $16,000 to get these routes on. Then he, being on his way to New Mexico, met in the city of St. Louis John R. Miner, who at that time was coming back, I think from Montana or Dakota, where he had been putting stock on a route. Miner saw Dorsey in St. Louis and said to him, "We have got to have a little more money, and I want you to endorse my note or to loan me your note, and I can get it discounted in the German-American Bank in Washington." Finally, Dorsey said to him, "You have already obtained from me about $16,000. I will give you the note you ask, or endorse your note upon one condition, and that is that you shall give me orders, what are called post office drafts, not only for the amount of this note, but for the amount of the $16,000. We shall insist, gentlemen, that evidence shows exactly our position, and that you are entitled not only to draw from it, but that you must draw from it the inference, the fact that we had no interest in those routes. Finally, that was agreed to. Now understand it, at that time a contractor with the government who had agreed to carry the mail for a certain time could give what are called post office drafts or orders. You know, orders on his quarterly pay.
and they would be taken to the proper officer in the post office department, and they would be accepted, not for the full amount, understand, but for any amount that might be due that contractor. For instance, he might fail to carry the mail. He might be fined, and consequently the amount of that draft might not be there. So that the only thing the post office department agreed to do was to pay upon that order or draft anything that was due to the contractor. That was done at the time. And why? Because there was no other way than that to secure these advances. So he gave these drafts. He came to Washington. The orders on the post office department were filed with it, and the money advanced by the bank and charged to Stephen W. Dorsey. That made then, at that time, about $25,000 that Dorsey had advanced. That being done, he went on about his business. Now I will show you what happened after that. I think the note in the German-American bank was $9,000 or $10,000. I have forgotten which. Dorsey then went on to New Mexico from St. Louis and remained there, I believe, until December 1878. Now I want you to understand this, because here turns a very important question and a very important point. Now, you recollect the information about these bids was collected in the autumn and winter of 1877. The last bid was to be put in, I think, February 28, 1878. Now, this was in the August of that year, 1878. Still being pressed for money, Miner, Peck, and J.W. Dorsey were in danger of being declared failing contractors. Now recollect it. We will show that at that time Brady, who according to the government was a co-conspirator, threatened to declare Dorsey, Peck, and Miner failing contractors. And if he had declared them failing contractors even on one route, that was the end of all. At that time, Miner and John W. Dorsey sought out Mr. Harvey M. Vail, and let me say that is the first appearance of Mr. Vail in these contracts. He knew nothing about the bidding, was not in Dorsey's house, knew nothing about the letting. That is the first appearance in these contracts, August 1878. Now, let us see what he did. He was a man of means. He had some money, had been, I believe, for a long time engaged in carrying the mails, understood the business. They will tell you that is a suspicious circumstance as to him, and that the fact that that was John Dorsey's first experience is a suspicious circumstance as to him. Really, to avoid suspicion, you would have to have a man that had been in it a long time but never had anything to do with it. They got him and offered what? To give him a third interest in this entire business. I think that was it. They were to give him a third interest in this entire business, a business that had been born of conspiracy, a business that had as a silent partner the man who fixed the amount of money to be paid. Think of that. According to the statement of the government, there was a conspiracy fully fledged, perfect in its every part, flanked by the second assistant postmaster general, buttressed by all the clerks they desired, and yet that conspiracy got so hard up that in August 1878, 9 or 10 months after its creation, it was willing to give a third to anybody who would advance a little money to carry the thing on. So Mr. Vail came in. Now then, they had to secure Vail against any loss, and it seems that on July 1st, I believe of that year, the law allowed the subcontract to be filed. It was a little while before that a law had been passed for the protection of subcontractors. That was all explained to you yesterday. You know it is something like a mechanic's lien. that if the subcontractor would only file his subcontract in the post office department and let that department know the terms of it, they would not pay the original contractor until this subcontractor was paid. Now, that law had gone into effect a little while before August 1878, and the effect of that law, if anybody filed a subcontract on these routes, was to cut out all those post office orders that Miner had given to secure Dorsey. You understand me now, do you not? It was when he met him in St. Louis that it was agreed that these post office orders were to be given and filed with the German American Bank in this city. Now then, the law passed for the protection of subcontractors and subsequently for filing of subcontractors on these very routes would render these post office orders absolutely worthless. Very well. When they made the contract with Mr. Vail, they agreed to file the subcontracts with the department to protect Vail, and that rendered S.W. Dorsey's security absolutely nothing. That cut out all other claims, drafts, and everything else, and at that time Mr. Miner was fully authorized by power of attorney from J.W. Dorsey and from John M. Peck, who was at that time in New Mexico, to make this transfer to Vail. Now, see where we are on August 16th, 1878. On Dorsey's return in December 1878, he had not been here from that time. And do you not see he had nothing to do with it? He found that these subcontracts had been filed. He found that the note in the German American Bank had been protested, and he found that his collateral security was not worth $1, that it was all gone. Thereupon he demanded a settlement. The matter drifted along for a little while, and a settlement was made with the bank, and Mr. Vail, holding the subcontract, undertook to pay that Dorsey note, and he did pay it. He took it up and gave, I believe, his own instead, and that was finally paid. But the money due Dorsey, the $16,000 that at that time amounted to something more by virtue of interest, was not provided for. The money that had been expended by John W. Dorsey was not provided for. The money expended by Peck was not provided for. Now, I want you to see exactly how that matter stood at that time. We have got it up to that time, and here it stands, and the chief conspirator out $16,000 and without any interest in one of the routes. There is where he was at that time, and that is what we will show. The brother of the chief conspirator, $10,000 out, and not the interest on 1 cent in any route. The brother-in-law of the conspirator, about $10,000 out, and not a cent in. That was the condition of this conspiracy at this time. And when Vail took these routes, Brady telegraphed him and asked him, "What routes of Miner, Dorsey, and Peck are you going to put the stock on? This thing can be continued no longer. The stock must go on." We will show it. Now, having got to that point, we will take another step. There is nothing like understanding things as we go along. Now, from the time Mr. Vail took the route to the settlement in 1879, to which I will call your attention in a little while, Mr. Vail had the absolute control. Neither Peck nor S.W. Dorsey had the slightest thing to do with one of those routes until the final settlement. And I say to these gentlemen of the prosecution now that in that time they can find no line, no word from Stephen W. Dorsey upon the subject. They cannot find that he wrote a word to any official, that he sent a petition to anybody, that he wrote a letter to any human being upon the subject, or that he took any more interest in it than in the ashes of Sodom and Gomorrah. It went right along. Now then, up to this time, Stephen W. Dorsey had made nothing. He was only out about $16,000 or $18,000. John W. Dorsey was in the same healthy financial condition. John M. Peck had reaped the same rich harvest of $10,000 lost, and all the things had been turned over to Mr. Vail. John W. Dorsey left out with nothing to show. That is the first chapter in this conspiracy. This ends Chapter 3, Part 2 of 5, read by Edward Kirkby, Warwick, England.